kodi. But if I find there is no urgency in the matter, I will adjourn it by 8 weeks and not list till 8 weeks is over. No problem. But you give the memo. 2:30 ku memo kodi. But that will be adjourned by 8 weeks if there is no urgency.
My lord will remember
ಹಳೆ old order ಇವಾಗ ಚಾಲೆಂಜ್ ಮಾಡೋದು 2:30 ಗೆ. I don't know. Kodi. Kodangire kodi. If I find it not urgent, 8 weeks.
fresh matter for my lord will appreciate Saturday.
Give everything.
Saturday. Fresh matter.
Otherwise, all fresh matters you give.
Saturday.
Lord, sir.
Kodi ಎಲ್ಲ.
The old.
The bank account has been freezed.
No problem. ಯಾವಾಗ ಆಗಿದೆ ಸರ್?
It's about June or something.
No problem. Give it.
My lord will remember last Thursday I had appeared on VC from the Netherlands. And my lord had requested.
It's not listed today?
It's not listed. In fact, this is a recurring problem. There are 3 times on which we said, please list it, and the registry does not.
You're from the Netherlands?
Indeed, I've
yes.
all the way.
All right. We'll take it at 2:30. Give it.
If we can please list it for this afternoon.
It will be. Give it. Yes.
I'm obliged, my lord.
Serial number 111. This is that matter pertaining to
We'll take it 111. 111 correct ಆಗಿ ನೆನಪು ಮಾಡಿ. Serial number 111.
Petition number.
Even today is Thursday, sir. Next week ಬರುತ್ತೆ ಕೊಡಿ. Tax matters ಎಲ್ಲ tax days will come.
Millards, ಅದು Thursday instructions ಇದೆ post ಆಗ್ತಿಲ್ಲ ಸ್ವಾಮಿ. Date ಬರ್ತ್ ಕಳಿಸ್ಬಿಟ್ರೆ list
I can't take beyond the limit, sir. Whatever is possible, I'll take. Give it.
Couple of times we are moving.
2014-15 ಇಂದ ಇರೋ ಮ್ಯಾಟರ್ ಗಳನ್ನ ತಗೊಂತಾ ಇದೀನಿ ಈಗ, ಅದು ಬೇಡವಾ? ಎಲ್ಲ
ಅಲ್ಲ ಬಿ ಗ್ರೂಪ್ ಅಲ್ಲಿ ಬಂದ್ರೆ ಸಾಕು ಸ್ವಾಮಿ. Next
ಅಲ್ಲೇ
Thursday.
ಬರೋದು.
Next Thursday. Next Thursday. Date ಬರುತ್ತೆ.
Tax ಎಲ್ಲ will come only on seniority. Give it. Yes. We'll see, sir. Give it. No end of why? Pending matter. ಏನ್ end of the list ಯಾಕೆ? No, 2:30 ಗೆಲ್ಲ ಆಗಲ್ಲ. You serve on them. Tomorrow will take. No problem. Tomorrow will take it. Give it. Aden, you are a complainant.
I am the resident of the same society.
I will see. Yes. Give it. Yes. Give the memo. But if I find there is no urgency, it will be adjourned by 8 weeks. I am forewarning all of you. Yes. Gottilla. Anything you give, 2:30 I'll take it. But if there is no urgency, 8 weeks or got barbarad wapas. No problem, sir. Give it, sir. Please give it. Please give it. It will come tomorrow. Yes. Please give. Ilva urgency agadre angar kodi. Yes. Kodi alla. All you 2:30 beka, you give it. Please give. No, tomorrow. Other memos on the designated days. If you want at 2:30, please give it.
Not a posted, but not reached.
No problem. Give it, sir. No worries. 2:30 ge kodi tondre. Tomorrow gilla. No tomorrow. Pending matter on the designated days. Yes. Give it, madam. Please give. Please give. No date. Give it. Give it. No date. Even 100th memo, no date, madam. Give it. Yes. It will be only on seniority. Please give it. ಆ ತರ ಇದ್ರೆ IA for disposal, memo for disposal ಹಾಕಿ ಬರುತ್ತೆ. Yes.
My lord, sir, this matter, the pro rata charges matter, it is by special order before your lordship. That matter had been listed yesterday, but it did not reach, my lord, sir.
Dispose ಆಗಿ ಎಲ್ಲ ಅಲೋ ಆಗಿ ಎಲ್ಲ ಆಯ್ತಲ್ಲ. Same order what you passed in your case, that is passed.
Yesterday.
Division bench matter ಸೇರಿ.
ಅಲ್ಲ, division bench matter to ಇದರಲ್ಲಿ ಬರೋದಿಲ್ಲ. This is just advanced pro rata.
No problem then. Disposed. You are not even there. It is disposed.
My lord.
ಏನ್ ಕೊಡಿ ಸರ್, ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಕೊಡಿ. ಸ್ಯಾಟರ್ಡೇ ತಗೊಳಲ್ಲ, 2:30 ನಾಳೆಗೂ ತಗೊಳಲ್ಲ. 2:30 ಬೇಕಾದ್ರೆ ಕೊಡಿ, ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ 8 ವಾರ ಕೊಡಿ. ಕೊಡಲ್ಲ, ಸ್ಯಾಟರ್ಡೇ ಇಲ್ಲ, ನಾಳೆಗೂ ಕೊಡಲ್ಲ. ನಾಳೆ 200 ಮ್ಯಾಟರ್ಸ್ ಆದ್ರೆ ಐ ವಿಲ್ ನಾಟ್. 2:30 I'll take it if you want. Give it. Give it, sir. ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ 8 ವಾರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಆಗುತ್ತೆ.
Your lordship, my execution is pending from 22 and it has been stayed because of an order of.
We'll see. Give it, madam. Yes.
Please, your lordship.
Give them. Pending matter ಅದು. Fresh matter ಇದ್ರೆ ಬರುತ್ತೆ. 2:30 pending matter move ಮಾಡಲೇಬೇಡಿ, ಬರೋದೇ ಇಲ್ಲ. Yes. No problem. We'll see.
One matter, madam, for the respondent, I have no objection for allowing of the repetition for impediment not in the trial court. Could be disposed of matter.
Disposed of matter.
No, it can be disposed of.
Can be disposed ಕೊಡಿ.
I have no objection.
ಎಲ್ಲೇ ಬಿಡಿ, ಎಲ್ಲೇನಾ?
Allowing the repetition.
Land acquisition.
GMCPC.
GMCPC ಕೊಡಿ. Next week ಬರುತ್ತೆ.
My lord, pending.
Next week ಇರೋದೇ 3 ದಿನ sir, again, that's all, just give it.
Fresh matter, my lord.
Give it sir.
Tomorrow, my lord.
No
Attachment-
tomorrow, sir.
Attachment.
No tomorrow, attachment is 2:30, ಹಳೆ ಆರ್ಡರ್ ಆದ್ರೆ 8 weeks adjournment, yes.
Tomorrow,
With,
my lord.
no tomorrow, sir. Give it.
Attachment, sir.
If you want it, give it at 2:30. ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಇದ್ರೆ ಅದು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಅಂದ್ರೆ 8 ವಾರ ಅಡ್ಜರ್ನ್ ಮಾಡ್ತೀವಿ. ನಾಳೆಗಿಲ್ಲ ಸರ್, ನಾಳೆಗಾಗಲ್ಲ, ಇಲ್ಲಾಂದ್ರೆ 1st September, ವಾಟ್ ಎವರ್ ಯು ವಾಂಟ್. 1st September ಎಲ್ಲ ಬರುತ್ತೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಇಫ್ ಯು ವಾಂಟ್ ಇಟ್ ಟುಮಾರೋ, ದಟ್ ಈಸ್ ದಿ ಕಂಡೀಷನ್. ಎಸ್, ನಾಟ್ ಟುಮಾರೋ, ಟುಡೇ.
Moving a fresh matter for 2:30 listing.
Why?
Ex parte ad interim order granted in complete violation.
Give it.
Provided
Yes.
to 39.
No problem. Yes. When was it granted?
But it was granted, I think. I don't know.
Not very old.
No.
Fine.
Fresh
Yes.
matter.
All right. ಅಲ್ಲ, ಮ್ಯಾಟರ್ ಮೇ ಬಿ ಫ್ರೆಶ್. ಗ್ರಾಂಟೆಡ್ 6 ತಿಂಗಳಾಗಿದ್ದು ಮೂವ್ ಮಾಡ್ತಾರೆ ಫ್ರೆಶ್ ಅಂತ ಅದಕ್ಕೆ.
Hearing on IA for vacating the interim.
Give it, madam.
My lord,
No tomorrow. Don't fix the date. Give it. Yes.
This is IA for parole in Dharwad.
Parole.
Yes.
ಧಾರವಾಡ ಮ್ಯಾಟರ್ ಅಲ್ಲೇ ಮೂವ್ ಮಾಡಿ.
my lord, see.
No, ಅಲ್ಲೇ ಮೂವ್ ಮಾಡಿ. ಧಾರವಾಡ ಮ್ಯಾಟರ್, I am not going to grant extension of parole here. Move, file a fresh petition.
My lord, CRP.
You are back to the goal.
Yes.
Then file a fresh
Father
petition.
is seriously ill.
No, sir. File a fresh petition.
My lord, tax matter, my lord.
Huh?
There is urgency.
File a petition there, sir. Urgency ಇದ್ರೇನಂತೆ. File a fresh petition there.
My lord, CRP, my lord, tomorrow. My lord, assessment already has been
Give it,
stayed
sir.
by this honorable court. My lord, the dispute resolution panel is going further.
Fresh
with
up pending. At
pending matter.
2:30 ga.
Interim order has already been passed. by
What
this
is the
honorable
problem
court.
then?
My lord, the dispute resolution panel is proceeding further with the matter, even though they are parties before this honorable court.
It's all right. Give it. Yes.
The matter is listed on.
May I request for,
29, my lord.
Saturday, my lord,
No Saturday.
Thursday, my lord.
No,
My lord,
Thursday. Yes.
The matter is listed on 29/7.
Where?
2 weeks last.
ಏನಾಗಿದೆ? ಇರ್ಲಿಲ್ವಾ ನೀವು?
Reach ಆಗಿದೆ.
ರೀಚ್ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ, ಇರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ.
Because with 2 weeks, after 2 weeks ಅಂತ ಹೇಳಿ.
After 2 weeks ಅದು ಇಲ್ಲದೆ ಇರೋದಕ್ಕೆ ಆಗಿರೋದು ಬಿಡಿ. ಕೊಡಿ ಅದು. Give it, sir.
Lord, CRP fresh.
2:30 why? ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಡಿ. ಆರ್ಡರ್ ಏನಾದ್ರು 1 ತಿಂಗಳು ಹಳೇದಾದ್ರೆ I will adjourn it by 8 weeks. Give it, sir. Give it.
My lord, it's a fresh matter. My lord,
Give it.
Summary proceedings, my lord, my leave to defend has been rejected.
No problem. Give it.
Without hearing, my
No
lord.
issue.
Trial court matter is on first.
No problem.
My request for 28th or 29th. my lord.
It will come, sir. Give it. 28th it will come.
28th.
ಯಾಕೆ? ಆಯ್ತು, ನಾಳೆ ಹಾಕಿ being spoken. 2:30 ಗೆ ಹಾಕಿ. ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೋದಾ? 28th or 20 ನಾಳೆ ಬೇಡ, 28th or 29th ಕೊಡಿ. Give it, sir. Give it. It will come. Yes.
Petitioner's bank or the bank account.
No problem. Give it, sir.
My lord,
No
it is-
tomorrow, day after tomorrow, next Thursday. 29th. Why? In threat of arrest? ಕೊಡಿ. All right. Tomorrow.
My lord,
Give it. Infractures ಯಾವ ತಗೊಳ್ಳಿ ಮೇಡಮ್?
it is a matter, my lords, where the KDB
Fresh
has.
pending?
Pending, my lords, is a matter where the KDB has forced the signature, my lord. My lord has
problem.
asked
Give
me
it,
to post the matter on after 2 weeks.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಹಾಕಿ ನೋಡಿ.
My lord had ordered to be posted after 2 weeks, my lord. I
No,
thought
it will
date
come.
is fixed, but
No,
on going through the order,
No,
this thing,
sir.
daily orders, the date is not.
ಡೇಟ್
fixed, my
ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಲ್ಲಿ ಹೋಗಿ. ನೋ.
lord. I may seek for next.
No, sir.
Next Tuesday,
It
my
will
lord.
come. Give it.
26. I've already
According
given
to
them.
seniority, it will come. That's all.
Seniority ಮೇಲೆ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. It's
ಏನ್
a very
ಮಾಡಕ್ಕಾಗಲ್ಲ
short
ಸರ್, ನೀವು
matter.
ಸ್ವಲ್ಪ ಕೆಳಗಡೆ ಇದ್ದೀರಾ seniority, ಅದಕ್ಕೆ ಬಂದಿಲ್ಲ ಅಷ್ಟೇ.
ಅಲ್ಲ,
My lord,
ಕಳ್ಸ-
CRP fresh
plus-
matter, my lord, it's
plus
tomorrow.
Pending ಅಲ್ಲಿ.
Not tomorrow. Give it. CRP fresh matter will come on 28th. Yes.
My lord, fresh GMC PC
Give
for
it.
tomorrow, my lord.
Tomorrow ಇಲ್ಲ.
My lord, the urgency is, my lord, delivery of possession, they may take.
2:30.
Lords, this is a tax fresh matter, my lords. In this matter,
Next Thursday. Give it.
bank account.
Next Thursday.
My lord, seal number 57, we request for 2 weeks' time, my lords have informed.
Wait, I'll call for adjournments.
My lords, pending matter, our matter ಇದೆ, covered ಇದೆ, ಬಂದ dispose ಆಗಿದೆ.
ಯಾವ್ದದು?
Muda matters.
ಎಲ್ಲಿ? give it. Next 28th ಹಾಕಿ ಮೇಡಮ್. ಫ್ರೆಶ್ ಎಲ್ಲ? ಪೆಂಡಿಂಗ್ ಎಲ್ಲ?
Pending is.
ಹಾಗಾದ್ರೆ
Notice
2nd September ಗೆ ಹಾಕಿ ಎಲ್ಲ ಮೇಡಮ್.
Achu.
With your lordship,
Yes, sir.
one matter, this arising under this land acquisition matters. CS site grant ಆಗಿದೆ.
ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್?
ಮುಡಾ ಸೈಡ್
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರ್ ಫ್ರೆಶ್
ಪೆಂಡಿಂಗ್ ಇದೆ.
2nd ಸೆಪ್ಟೆಂಬರ್ ಕೊಡಿ.
ಅಲ್ಲ ಅದು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಸ್ವಲ್ಪ.
2nd ಸೆಪ್ಟೆಂಬರ್. ಎಸ್ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕರೆದ್ಬಿಡಿ ಮೇಡಮ್. ಫ್ರಮ್ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್.
Seal number 57, request for 2 weeks time, my lords.
You for the petitioner,
Yes, my lords.
as an interim order?
Not required. Interim order is already granted in the required
No,
section.
not now. Is it subsisting?
Yes.
Yes. The request of the council appearing for the petitioner list the matter after 2 weeks. Interim order, if any subsisting, would continue to the next date of hearing.
The
Next.
date may be given, my lords.
No. Yes, date is today. Yes.
Obliged, my lords.
Page 1378 to 85. Page 1486 to 93. Page 15 94 to 98. Page 16 99 to 103. Page 17 104 to 109. My lord, 106, my lord. I
Ah.
pay for 2 weeks time. File statement.
106. At the request of the learned HCGP list the matter after 2 weeks. Interim order, idea, madam?
Illa.
Yes. Next. Call the case.
List 2.
List 1.
List 1 being spoken to seal number 1.
ಅದೇನೋ ಬೇರೆ ರಾಂಗ್ ಆರ್ಡರ್ ಏನೋ ಆಗಿದೆ.
My
Which is the one that is covered?
There's no cover.
ಹೌದಾ?
This
Then
is
why
separate- this is a separate
why
one.
did
I think my
it,
lord
we'll
was
restore it
ordered
then.
for
Yes. This petition was disposed.
This is a
Disposed, interim order.
Fresh matter,
Fresh
my lords,
matter,
had come up last Thursday.
Ah,
We had paid 10% pre-deposit in this matter, challenges to an order in appeal.
correct.
Tribunal, therefore, we had come before my lords.
All
We had
right.
indicated to my lord that 10% pre-deposit has been paid.
Huh.
There is no similar matter on this point.
No, there are many similar matters where 10% deposit I have directed.
On the merits, my lord, there is no similar.
No, on the merits, forget it. If an interim order tribunal is not functioning, 10% is what I have passed.
10% pre-deposit has been paid.
That's a different thing. Now, if you want to stay of that order on the ground, the tribunal is not functioning, 10% is what I have directed in all the cases. I have done here also.
Only problem, my lords, is in para 2 at the bottom.
Huh.
There are 2 orders. There is one original authority order, there is a rectification order.
All right.
Mistake, my lords, I think the rectification order and the form along with the rectification order has been stayed.
No, what is that you wanted stay of?
The original order. which
Date.
It's, my lords, at
25.
25/4/2025.
And not the two that are mentioned here?
No, my lords, the first order is correct. 28/7/2025, that order is correct.
Then
There
next,
is an order before that which is 25/4/2025.
25/4/2025. And the other one, 31/7?
That is only a form, my lord.
Not necessary.
Not
Yes.
necessary. In para 3, my lords, 10% has been paid. We had
That's all right. Even then, 10% is always imposed. Yes. The petition is moved. This court on 14/8/2025 had granted an interim order. The counsel for the petitioner moved the memo on the score of certain inadvertent typographical errors being crept into the order. The learned counsel submits that the orders that had to be stayed were 25 or orders dated 25/4/25 and 28/7/25 and not 31/7/25. In that light, the unnumbered second paragraph would read as follows. A change mabudi. ಇಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ. Yes.
Order seal number 2.
Lords, I appear for the petitioner. I
Non-compliance.
paid the court fees, my lords, and the other office objection is that with respect to annexure B, D, and P. My lords, there is no original order because that's a computer generated copy, uploaded copy.
Office objections overruled.
Interim order may be extended.
Idea interim order.
Interim order,
List the matter in B group ಹಾಕೋಣ.
please.
List the matter in, post the matter in B group. Objections ಹಾಕಿದ್ದೀರಾ ಅದಲ್ಲಿ?
This case is, my lords, it's pending before the apex court.
ಏನಿದೆ? What's this?
My lords, the jurisdictional nursing officer or faceless
Faceless. Apex court ಹೋಗಿದೆ faceless ಈಗ.
Please, my lords. My lords, what had happened recently, there's one order.
A faceless ಕೊಡಿ. Now you tell me one thing. Now under 148, when a notice is issued, after the return of income is filed by the SSC, then it goes into faceless.
Please, my lords.
The notice issuing officer under 148 has to physically issue it. It is not by a faceless mode, is that correct?
Please, my lords. That is, my lords.
It is only then,
Please, my
when the proceedings begin, after return of income is filed, it gets into faceless
Please.
mode. That's the circular as I could gather.
That is, my lords.
Then what is interpreted by the courts?
We say, my lords, it's concurrent jurisdiction, faceless, and the jurisdiction nothing of.
Concurrent can't be there because of your circular.
My lords, the
Because of your order, what notification.
my lords, that
There can't be concurrent. What can be perhaps is beginning of the jurisdiction under 148 will be by a notice issued by the competent officer.
Please.
Once he files his return of income after, in return to the notice, then it gets into a faceless
there is
mode.
one more submission. My lords, the section 151A says, my lords, assessment, reassessment. My lords, the assessment proceedings are conducted by the faceless, my lords. This is pre-assessment, my lords.
It's pre-assessment, that is what I'm saying. Assessment is by faceless. Pre-assessment is by the jurisdictional officer. Is that so? I don't know.
My lords, what the assessee's content is, my lords, the 148 notice is also issued by the jurisdictional.
That is what stay is granted in all the cases. Is that the way to look at it, is what I'm asking.
My lords, we are led by, my lords, AST, my lords. Today he has some difficulty, my lords.
No, we'll grant you time. I'm only
They might take up this issue, my
only
lords, the
wanting to
assessees.
know, that's all.
My lords, recently
Because
there was.
what I read the notification and the pleadings, this is what prima facie I could gather. The assessment is faceless.
Please, please, my lords.
The initiation is by the authority.
Please, my lords.
Let me see, whatever.
My lords, this is the order. Recently, one SLP was dismissed, my lords. We
Against,
filed
against what interpretation?
my lords, against Bombay High Court, my lords. They said it cannot be done. That
What cannot be done?
faceless jurisdictional nursing officer cannot issue the 148 notice. It has
So
to-
148 notice itself begins with a faceless.
Please. My lords, that we filed a miscellaneous petition, my lords, for recalling that order, my lords, because this has wide ramification, my lords.
I know it does. That is why I'm asking.
And there is one more division bench order, my lords. I'll just place this order, my lords, before your
Kodi.
lordship. Lords, this is not under writ, under 260A, my lords. The similar identical ground was taken up before the tribunal. Tribunal, my lords, held it in our favor. Assessee came before, my lords, by way of 260A, regular appeal. My lords, this honorable court, my lords, has deferred, my lords, referring to there are contradictory decisions by various high courts. So they have deferred the matter, my lords, telling that, my lords, Apex Court is hearing the matter.
Apex Court has already dismissed one.
My lords, we filed recall. My lords, that by
Bombay High Court's judgment is affirmed. Let me see. Is faceless yesterday ella kodi?
Please,
What are the petitions pending?
lords, there are about more than 100, 150.
That is
my lords,
what. Give me the list.
Please, my lords.
Sushal.
We are, my lords, in fact.
In any of the
today-
matters, Shankar sir is there?
Lords, today many matters are listed, my lords.
ಇವತ್ತೇ ಇದೆಯಾ?
ಇವತ್ತು ಇದೆ, ma'am.
ತುಂಬಾ ಇದೆಯಾ?
ಇವತ್ತಿದೆ, ma'am.
The list, I think about 20 of them must be JAO, FAO.
So today some of them are listed?
Yes, yes, my lords.
Then
please.
we'll handle it. Yes, not a problem.
My lords, I request your lordship to kindly defer it, my
No,
lords.
no. I want to know it. Yes,
My lords,
we'll see.
next, my lords,
I will not pass any order. Let me hear the counsel.
please.
Yes. You are faceless, ಅದು whether your submission is baseless ಅಂತ ನೋಡ್ಬೇಕು. Yes. That is why.
Please.
Yes. Bharat, ನಿಮ್ದೇನು? Interim order. Yes. Interim order subsisting would continue till the next date of hearing. Post the matter in B group on 18th September.
Number 3.
Furnishing of PF 2 weeks time is granted to do the needful. Let's post the matter in preliminary hearing B group on 18th. Yes, next.
This may be taken out. Post
18th is 3 weeks only, 18 September. Yes.
Serial number 4, I require a week's time, my lord, to verify and apply with the office of.
ಇದೇನು?
They've not given the copy, they've not served the copy.
ನೋಟಿಸ್ ಆಗಿದೆಯಾ? ನೋಟಿಸ್ ಆಗಿದೆ, ಸ್ಟೇನು ಆಗಿದೆ, ಕಾಪಿ ಕೊಟ್ಟಲ್ಲಿ ವೆಕೆಟ್ ದ ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
No, my lord.
Then
I'll verify, I'll give it today itself.
the petitioner shall serve set of papers upon the counsel M. Dilip, if not already served, as on date. Subject to the said condition, interim order would stand. The coordinate bench of this court on 9/4/2025 had passed the following order. The learned counsel for the respondent submits copy is not served, and the office objections, copy is not served. The office objections that were directed to be complied within 2 weeks is also not complied. Lest the matter on 11th September, in the event the office objections would not be complied by then, the interim order subsisting would get automatically vacated. So, stay tagobekar sari irute, office objections comply ಮಾಡಬಾರದಾ? What will verify? Yes, your impression sometimes may be wrong. That's why you should verify.
Lord, in this matter, I apply for respondent. Lord, in this matter, I'm seeking a short accommodation. I have sought instructions from the assessing officer. This is pertaining to the section 6(2)(b) matter, my lord. Whether already a show cause notice was issued for the same period. I'll just factually verify, my lord. 11th, lordship may have it.
Learned counsel Arvind Chavan seeks 2 weeks' time to seek instructions and make his submissions. 11th September in preliminary hearing.
Lordship, interim order is there.
Interim order subsisting would continue to the next date of hearing.
Okay.
Yes, next.
Number 6.
For the petitioners, my lord, pertains to 107th of clause.
Rectification of office objections, what is that?
My lord, it's IA which has been.
Amendment. What amendment?
My lord sir kept it for passing orders because.
What amendment I'm asking, tell me.
My lord, this is pertaining to section 107th of clause 6, which has to be read down. I've sought for an amendment to add those paragraphs to read down section 107th of clause 6, my lord, because.
First, initially you have sought a mandamus to consider.
Consider, yes, my lord. And now, my lord, what had happened.
Now appeal is dismissed on the ground of delay.
Yes, my lord. It is not dismissed on the ground of delay. I am unable to file the appeal.
Why you pre-deposit madilva?
Because the bank account is
this
frozen.
matter. Yes.
This is a matter which my lord heard
my lord
last
had
week.
already kept it pending.
This, I kept it for passing orders, right?
Yes.
Then we'll reserve it and pass. Heard reserved. By 28th we'll pronounce.
They have given up those prayers with regard to constitutional validity.
All right. No. The system should be streamlined. Bank account freeze ಮಾಡಿ ಮತ್ತೆ pre-deposit ಹೆಂಗಾಗುತ್ತೆ?
Bank account ನಾವು recovery ಮಾಡ್ಲಿಕ್ಕೆ ಮಾಡ್ಲೇಬೇಕಾಗುತ್ತೆ.
ಮತ್ತೆ ಇದರಲ್ಲಿ you should permit defreezing only for the purpose of
They
this.
have given them 3 months time, my lords, for filing an appeal as provided under 7. They don't file
Freezing happens at the end.
after 3 months.
We'll see.
In this
In
case,
the
my lord,
extended
account is
period of
frozen
limitation of
almost 1 year ago. And one of the bank account, they removed the freezing only a few days ago after the appeal period gets over.
No, you should enable to the assessee to file an appeal by defreezing one particular account is linked to the GST. That account only you have frozen now.
That is the only account.
That's the only account that is frozen. Other account in the you can't make the pre-deposit at all. How does the appellant file an appeal? Tell me?
They lose it all. They lose on that because they don't file it.
And now you have rejected on the ground. Appeal cannot be filed, or you will reject the appeal that is beyond limit.
That is because they don't file it within the period of limitation prescribed under 107.
Let's see.
There is an extended period of limitation of 1 month, during which they want to file an appeal, during which we have frozen the account.
But statute permits them to 120 days.
3 months.
90 days.
90 days.
90
Then
plus
there is
30.
30 months, but however, we can initiate recovery as per 78.
Correct.
After 3 months.
After 3 months. Now, your initiation of recovery results in freezing of the account.
Yes, ma'am.
All right. Now, if he wants to file an appeal, he can't file at all. 3 months al madilla anta ನೀವು ಹೇಳ್ತೀರ.
In this case, the facts are a little bit peculiar, my lord. It was already frozen. It is one of the account is they have defrosed one of the account after the appeal period gets over. And the other account is already attached.
Let me see what can be done. Yes. Reserved.
7.
I appear for the respond number 36, my lord. I may be
Number?
permitted to file 36, my lord, R36. Because
Learned
I
counsel
just
to
received
submit
yesterday.
undertakes to enter appearance for respond number 36, registry to print the name of so and so as appearing for respond number 36.
I have to file a wakalat, my lord.
KRDBL, what is the matter? Housing board.
My lords, we have served the copies to all the respondents.
Hmm.
My lords, it's a matter regarding the reimbursement of the differential GST from VAT to GST period. And it's covered by Chandrasekhara's order, followed by
Page.
MG Arun Kumar's order.
Page.
Page 121. That is, page 121 is the Chandrasekhara's order.
One moment. Oh, this matter.
Yes, my lords.
Refund of GST.
Yes, my lords.
Yes, we'll close it.
My lord, according to, just
Copy is not served.
My lords,
Copy is not served.
My lords, we have served all the copies. For respondent number 6 and 7 on the previous date, my lords, you had.
Respondent number 2, my lord.
Respondent number 2 was served way before.
Copies been served last evening, my lords, in fact.
Is it not covered?
according to us, it is not covered, my
Fairly
lord.
covered, my lords. It's
Huh?
fairly covered.
According to me, it is not covered, my lord, because there is a subsequent contract.
According, who are you, sir?
I am for managing director, Davangere Smart City, my lord.
Oh, sorry.
Six, my lord.
But it is each independent bodies which have to come and answer before the court, my lords, whether it is slum clearance board, Tumkur Smart City, they have to come before the court and answer, my lords.
Individually?
Oh, because
Oh.
there are,
So the individually they have a right to contend that this judgment does not cover them?
my lords, though, my lords, there is already a judgment. That judgment is now pending in the
Yes.
writ appeal, my lords.
Ah, ready writ appeal hakli.
And in one of the judgments, my lords, matter has been carried to the Supreme Court in the case of Hubli Dharwad Smart City mass constructions.
It's all right. Anywhere you have the stay of the order passed by these two coordinate benches?
No.
Take this also. Yes. This is what respondents ಯಾರಿದ್ರಲ್ಲಿ? Justice Krishna Kumar's order. Hubli Dharwad Smart City. In that you have taken it to the apex court?
But I don't appear, one of the matters, my lords.
That's all right. The petitioner is before this court.
My lord, the question was whether the contract tenders called subsequent to the GST, whether that judgment is applicable or not is to be decided, my lord. Now, pre-existing and post-existing, that I have to look into the contract, my lord, so that I can make a submission. Because if the contract,
for the last 2 years, what were you doing?
my lord, yesterday the copy was served, my lord.
Yesterday?
Yes, my lord, the copy was collected
Wait,
yesterday. Yesterday, my lord.
Yes, the petitioner, the petitioner submits that the issue in the list stands answered by the judgments, two of the judgments rendered by the coordinate benches. The learned counsel appearing for the 36th respondent submits the copy of the petition is served only yesterday, date
20th.
on 20th. Yesterday is 20th. 20th. Yesterday I put date 20th, and would want to verify whether the contracts were entered into before the GST regime or the post GST regime, as the to submit whether judgments are covered or not. While the submission is unacceptable, but to give an opportunity to the petitioner, to the respondent number 36 to make his submissions, list the matter on 4th September. It is made clear no further adjournment would be granted in the matter.
My lords, one submission. No, my lords. One submission, my lords, with regard to the pre and post GST, it is very well covered under the 9721 ambit. For the
Let him say, copy, you have given the copy yesterday. You should have given it last week.
Apologies.
It's a prayer of the petitioners, my lords. The first prayer is to for a mandamus for the respondents to consider their representations and pass suitable
My
orders.
question is, if the issue is already answered, where is the question of over and over arguing before different benches? No.
In fact, my lords, in Chandrasekhara's case, there are directions for us, for them to file a revised return to enter into a
Whatever is
supplementary.
there, that we will pass. If the facts are similar, then I will not permit fragmented arguments in every other
That's none
court.
of the
That is
contracts are
not correct.
produced. We have to verify the contracts. When none of the
That
contracts
is why
are
I've given
produced.
time, sir. That is why I've given time.
One contract to produce Mandela. There are 25 respondents of PWD department.
Yes.
My lords,
And we
the
don't know which work
contracts-
they have done.
My
Why
lords,
have you not produced the contracts?
my lords,
ಯಾವ
all,
ಕೆಲಸ ಮಾಡಿದ್ದಾರೆ ಎಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ.
My
ಸುಮ್ನೆ
lords.
PWD ಹಾಸನ್, PWD ಧಾರವಾಡ, PWD ಇವರು ಅಂತ ಹಾಕೊಂಡು ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಹಾಕ್ಬಿಟ್ಟು
Where are
we have
where
to
are
go
the
in search of
documents?
them.
my lords, all the contracts are on the basis of old schedule of rates. That's the-
Where are the contracts?
My lords, we have produced before the court, like whichever, like a part of it. My lord, there's, it would just
Not
take the
like a
petition
part of.
bulky,
If you
my
want
lords.
to claim the benefit, if there is objection, you have to produce the contracts
Kindly, my lords, we'll do
Produce
the
the
needful,
contracts.
we'll do the needful.
and serve a copy in advance.
Kindly, my lords, we'll do them.
Otherwise, you will get these hyper-technical submissions. Yes.
ಇಲ್ಲ one PWD division
ಅಲ್ಲಿ
ಆದ್ರೆ I
ಬೇರೆ
can
ಕೋರ್ಟ್ ಅಲ್ಲಿ
verify.
ಆಗಿದೆ, ಕೋರ್ಟ್ ಚೇಂಜ್ ಆದ ತಕ್ಷಣ ಆರ್ಗ್ಯುಮೆಂಟ್ ಚೇಂಜ್ ಆಗುತ್ತೆ.
ಇಲ್ಲ change
ಮತ್ತೆ-
ನಾನು change ಮಾಡ್ತಾ ಇಲ್ಲ.
Yes.
We are not changing.
Grateful, my lords.
Eight, my lords, is a matter for refund. Assessment orders were passed for 3 assessment years, my lords, 6, 7, 7, 8, and 8, 9.
Yes, Raviraj. Dilip or Raviraj?
Raviraj.
Yes.
Three
Notice
assess-
ಆಗಿಲ್ವಾ?
I'm sorry, my lords. The prayer is for refund for
Ah.
3 assessment years. Assessment orders were passed for 3 assessment years, raising a demand. Matter travelled up to the tribunal. Tribunal held in my favor or remanded certain issues. Pursuant to that, they should have passed an order giving effect, which they have not passed till date. And the tribunal's order was in 2015. Time limits have expired in 2017. Looked at it from whichever way. So, my lords, it reverts to the return position, and there's also a decision of the coordinate bench.
Yes, sir. ಯಾವಾಗ?
My lordship may kindly say, my lord, nothing has been produced by the.
ಮತ್ತೆ
revenue
nothing
to
has been
say-
produced.
ಇಲ್ಲ, ಆಗಿಲ್ಲ.
ಯಾವುದಕ್ಕೆ?
Order giving effect to, my lord, has to be passed within the stipulated time.
Where is the order of the tribunal, madam?
Yes, my lords. Page 100, my lords.
Ah.
Three issues in all, my lords. 100 is where it starts for 3 assessment years common order. My lords may return to para 14. Page 113, my lords. This is on the first issue of transcribing adjustment. At the bottom of that page, my lords will see accordingly in the facts and circumstances. We are of the view that the comparability of the company selected by the TPO requires a proper examination and reconsideration date of the judgment of the Honorable Delhi High Court in the case of Ramp Green. Hence, the issue of comparability of the company selected by the TPO and objected to by the SSE is set aside to the record of the AO TPO for re-adjudication. This is one of the issues, my lords. Then para 15, my lords will see, accordingly, we direct AO TPO to include the gains or loss on account of foreign exchange fluctuation in respect of sale proceeds in the margin of the company of the SSE as well as comparables to maintain parity. So this was held in my favor. This is on the transpricing adjustment. Then my lords will see para 19. That was on lease rentals, whether I was entitled to a deduction. There
Yes.
again, it was remanded. My lords will see bottom of page 116. Accordingly, by considering all the terms, my lords has that?
Yes.
Considering all the terms and conditions of the lease agreement, this issue is required to be reconsidered and re-adjudicated. Hence, we set aside this issue to the record of the AO to adjudicate it afresh.
Terms of the conditions of lease agreement.
Then,
All
my
right.
lords will see next ground is software expenses disallowance, para 20. That also, my lords will see para 26. It was sent back.
So what happened after sending it back?
So after this, the officer is supposed to pass an order giving effect
All right.
within the timeline specified under 153 of the Act.
What is the timeline?
I've prepared a small chart, my lord. The timeline expires in 2017, March. My lords will see this.
ಕೊಡಿ.
So I've just prepared a small chart, my lords. 25/5/16 was the date of the tribunal's order. Then, my lords, the time limit under 153(5) of the Act begins from the end of the financial year in which the order is received. Therefore, end of the financial year is 31/3/2017. Then the limitation to pass an order under 153(5) is 9 months from the end of the financial year. Therefore, that expires on 31/12/2070. Then, my lords, because there was a substitution in the provision in 153, I've also assumed a position where if the substituted provisions don't apply, what is the timeline, that we don't really have to get into. My lords. Then 2018 onwards, I've been writing letters to the officer to give effect to the order. As of date, I have not received an order giving effect. And therefore, my lords, the Supreme Court in Shelley Products has held that where issues have been sent back to the assessing officer and order giving effect is not passed within the timelines prescribed, then it reverts to the returned position. And therefore, whatever taxes I have paid pursuant to the first assessment order will have to be refunded to me.
Ashena? Correct, nothing has, avurdalvalla, nimdu. Yes. The petitioner is before this court seeking the following prayer, page 17. Heard your Tanmay Raj. Heard the learned counsel Srimati Tanmay Rajkumar appearing for the petitioner, the YB Raviraj representing the respondent. The petitioner, what is your company?
I'm a manufacturing company.
The petitioner,
I'm sorry, back office operations.
Back office,
Page 8 of the
back office company, the name and style of SciCom Contract Service Private Limited, is before the court on the question of the respondent SSE, respondent revenue, not taking steps pursuant to the order of the tribunal. A little history is for the assessment years 2006, 7, 7, 8 and 7, 9, 8, 9, returns of income were filed by the petitioner. Returns of income filed by the petitioner comes to be picked up for scrutiny assessment. Upon the assessment proceedings culminating into a final assessment order by the assessing officer, the petitioner files appeals before the Income Tax Appellate Tribunal. The tribunal, by a common order, disposed the appeals on each of the grounds urged in the appeal for each of the assessment years, by remitting the matter back to the hands of the assessing officer for a fresh decision on all the grounds. In terms of section 153(5), read with 153(3) and 4 of the Act, a fresh assessment ought to have been carried out pursuant to the order of the tribunal before the end of the financial year. Up to 2018, there was no communication to the assessee of the compliance with the order of the tribunal by initiating proceedings afresh. In those circumstances, the assessee communicates plethora of letters. The assessee communicates several letters to the respondent revenue to comply with the order of the tribunal. The 7 years have passed by. The revenue has not acted upon the order of the tribunal, which permitted proceedings to initiate afresh in accordance with law. The learned accordance with law. Initiation of the proceedings afresh as was directed by the tribunal would result in, what did you say that word?
It reverts to the returned position.
They would revert to the returned position, and therefore the petitioner is before the court seeking the aforesaid prayer. The learned counsel appearing for the petitioner taking this court through the order of the tribunal, which decided on every ground in favor of the assessee, but remitted the matter back to the assessing officer to initiate proceedings afresh and take it to its logical conclusion. Nothing worth the name of initiating proceedings afresh has taken place till date, despite passage of close to 8 years of passing of the order of the tribunal. Therefore, the learned counsel would submit proceedings now to be taken is barred by law in terms of the aforesaid orders. The learned counsel appearing for the respondent revenue has not produced any order or any communication even to the petitioner to demonstrate that the order of the tribunal was even, liberty under the order of tribunal was even taken forward by the revenue, as the order permitted initiation of proceedings afresh, which has not taken place even till date. Therefore, the issue, the learned counsel for the petitioner would now join issue in contending that in identical circumstances, the coordinate bench of this court in the case of so-and-so writ petition 1622223 of 2023 disposed the petition on February the 5th, 2024 by directing the refund agbaka, directing refund of the amount, refund of the tax that was paid. The learned counsel for the petitioner, learned counsel for the respondent is not in a position to dispute the position of law as is laid down by the coordinate bench in identical circumstances. I have given my anxious concerns to so-and-so. The above narrated facts, link in the chain of events and the dates are all a matter of record. The assessment of the petitioner, the assessment of the petitioner for the years 2006, 7, 7, 8.
May I intervene, my lord? I'm sorry. My lord, page number 142, and draft assessment order is passed, but however, my lord, it has not, final assessment order is not passed.
Oh, let me see.
Transfer
Not a
pricing.
draft assessment order.
Sorry, transfer pricing under 92 CA.
92 CA ಶುರು ಮಾಡಿದ್ರೆ ಆಮೇಲೆ ಮುಂದೆ ಹೋಗ್ಬೇಕಲ್ಲ.
ಮುಂದೆ ಹೋಗಿಲ್ಲ. Just.
All right, yes. That's TPO order. Yes. The assessment is 2006-77-889. The said assessment of the petition was taken up for scrutiny by initiating proceedings under 92 CA. This was called in question before the tribunal by the petitioner. The tribunal, answering every ground that is urged in the disposes the appeal, reserving liberty to the revenue to initiate proceedings afresh, bearing in mind the observations made in the course of the order of the tribunal. Therefore, it becomes necessary to notice the order of the tribunal, 113 to 123. The tribunal reserved liberty to the revenue to initiate proceedings afresh as observed herein above. The order of the tribunal is dated 25/5/2016. In terms of section 153, the limitation for initiating proceedings afresh as directed by the tribunal would end at the end of the financial year of the beginning of the order of the tribunal, which would be on or before 31/3/2017.
Just to change minutes. The limitation starts at the end of the financial year, ends 9 months therefrom.
9 months therefrom, is it? The limitation would commence from 31/3 hingagutte.
End of the financial year in which I've received the order.
Correct, that is 2016, that is 31, right. 31/3/2017 and would end within 9 months from the said date,
which is 31/12/2017.
which would be 31/12/2017. This is the purport of the statute. The proceedings were not started afresh. The petitioner then addresses a communication to the respondent, assessing officer, requesting a draft assessment order to be passed in terms of the order passed by the tribunal for the aforesaid years. 7 years have passed by. No order is passed except an order on the file of the transfer pricing officer under 92 CA of the Act. That would not serve the rigor of the statute under 153(3), 4, 4, 5, and 7 of the Act. In the light of no order, no communication sent to the respondent, to the assessee of any draft assessment order beginning the proceedings in terms of the order passed by the tribunal, within the limitation, i.e. 31/12/2017, any further action now sought to be permitted would be on the face of it without jurisdiction. In that light, petition deserves to succeed with the prayers to be answered in favor of the petitioner. Therefore, the petition stands allowed. The what is that you have sought? The respondent revenue shall refund the amounts as sought for in the prayer within an outer limit of 12 weeks.
3 months.
12 weeks, adene. Outer limit of
Applicable interest.
12 weeks with applicable interest. Yes.
Lord, may I make one submission, my lord? Instead of saying, my lord, all these 8 years, my lordship may replace it with within the time prescribed under 153.
All right, no problem. Yes. ಎಲ್ಲ ಒಂದೇ. Within the time
ಎಂದು
prescribed.
ಈಗ ಮಾಡಕ್ಕಾಗಲ್ಲ ಈಗ ಅದಕ್ಕೆ.
ಅಲ್ಲ ಮಾಡಕ್ ಆಗೋದೇ ಇಲ್ಲ, correct.
One indulgence.
Yes, madam.
Serial number 38 also is a connected matter.
ಇದಕ್ಕೆ
Same
order.
assessee, previous assessment year.
ಅಸೆಸ್ಮೆಂಟ್ ಇಯರ್ಸ್ ಏನೇನು ಅದರಲ್ಲಿ?
5-6.
So
Tribunal's order is dated.
Same.
Tribunal's order is dated 16/9/2016. Same time limit.
changes ಅಷ್ಟೇ. 2005-6.
Yes, ma'am.
5-6, 6-7,
ಇಲ್ಲ, 5-6
5-6
ಮಾತ್ರ.
ಮಾತ್ರನಾ? 2005-6 ಅದೊಂದು ಸೇಮ್ ರೀಸನಿಂಗ್ ಸೇಮ್. Yes. Yes, next.
9.
9 is same as item number 2, my lords. The faceless assessment, my lords.
Faceless. I will pass it over.
Yes, ma'am.
We'll take.
10.
Lord, I appear for the petitioners. Lord, this petition challenges the order of first appellate authority for want of tribunal being constituted.
Tribunal not at constant.
10%.
Not yet. Lord,
Yes.
kindly see page 53. I have already deposited 10%. at the
No,
time of the
even
first
then, if there is, should be stay, 10% I'm directing to be deposited.
Very well,
Yes,
very well.
10% order. Heard, so, senior counsel? What's the council's name?
Prakash Shah.
So and so. Same order, 10%.
Take notice. Take notice. Maybe.
Adella, all that will be there. Yes.
Deeply
Next.
obliged. Grateful.
Eleven.
It's the same issue, Manoj. Can you pass?
Faceless.
Please.
Faceless will start. Yes.
12.
My lords, I seek a passover for this.
Why?
My lords, I'm a proxy counsel. I
What's
seek a
the
pass-
matter?
This is also tribunal not.
10%.
Yes, ma'am.
Yes, same order. Yes.
Grateful, my lords.
13.
Team password. Password. Faceless. Password.
Password.
14. My lord,
I'll take it immediately after preliminary hearing, Dilip. After 33, I'll take faceless. Yes. Nimdala, ಹೇಳಿ.
Please, my lord. My lords,
14.
14, my lords.
14.
Lords would recall, my lord, this is
My lord,
without
they
issuing me, my lords, a notice where my lords are sending my own gold to my own cousin, my lords, in Mumbai.
ಅದೇ ಇದು.
Without,
Yes, ma'am.
no, my lord, that judgment, my lords, rendered by this honorable court would say, my lords, writ petition is not maintainable if there is, my lords, an order that is passed. And my lords, appeal provisions under the GST Act have got to be resorted to. My case before your lordships is, my lords, that notice is not given to me. My lords, on the last occasion, my lord, assisted your lordships that my logistic person, my lords, who is carrying my
ಅದೇ
item,
ಗೊತ್ತಾಯ್ತು, ಡ್ರೈವರ್ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಟಿಸ್.
driver ಕೊಟ್ಟಿದ್ದಾರೆ. And the entire,
ಅದು ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಲ್ಯಾಂಗ್ವೇಜ್ ಲಾಜಿಸ್ಟಿಕ್ಸ್ ಪರ್ಸನ್.
Logistic also have been served notice.
then the gold, ಏನು?
No, why? That is also service of notice.
No, my lords, under the act, my lords, the logistic person is only, my lords, obligated to carry a sale invoice and an e-way bill. In the instant case, my lords, there is no element
Then
of sale
gold
at all.
bar, what is that?
Gold bar. And that too, my lords, only about 60 grams, which was being sent to my own.
Which is that provision?
My lords, the provision, under the act.
Where you can serve on the logistics person also. Or you can't serve on the logistics person.
Actually, address ನಮಗೆ ಸಿಗೋದಿಲ್ಲ. Only logistic will available. We have to serve him only. Throw him. He is well aware, my lord. He just doesn't want to appear.
ಈಗ ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
I shall appear before your lords.
When?
Any date, that's my lords.
Yes, madam.
Yes, ma'am.
When will we direct him to appear? Or you keep this pending or close this?
Tomorrow, no, it
But
has to be
tomorrow-
closed. Opportunity may be provided.
Will be given,
We'll pass a
yes.
fresh order.
The petitioner.
10 days time, my lords, I am.
Petitioner is before this court seeking the following prayer, heard so and so. The petitioner, the goods of the petitioner, fine gold bars, being ferried in vehicle bearing so and so number is there, was intercepted by the GST authorities. The GST authorities on such interception, finding the gold bars in the possession of the logistics person, issued a notice to the driver / the logistic person who was in charge of the said conveyance. The contention is that no notice was served upon the petitioner, therefore he could not appear before the concerned authority, who has now drawn proceedings against the petitioner. The learned counsel appearing for the petitioner submits that if an opportunity is granted, he would now appear before the which respondent? Appear before the second respondent and participate in the proceedings. In the learned counsel for the respondent also, learned HCGP for the first respondent, for the respondents, submit that the petitioner may be directed to appear on a particular date and the proceedings would be drawn after affording all opportunity to the petitioner and appropriate orders would be passed. In the light of the said submission, I deem it appropriate to obliterate the order that is passed against the petitioner and direct the petitioner to appear before the second respondent on when, madam?
1st of September.
On September the 1st, 2025 at 2:30. 2:30 now? At 2:30 p.m. and participate in the proceedings. It is open to the second respondent to regulate its procedure and take the proceedings to its logical conclusion, affording opportunity to the petitioner. In the light of the aforesaid circumstance, as a matter of form, the orders so and so stand obliterated.
I'm so very good.
Yes.
15.
May I request to pass over, my lords?
15. Why?
Chavan is in other court, my lords. There's some matters before court all one today, my lord.
All right, that's all right. What's the matter?
Well, its appeal has been rejected on saying that the hard copy of the appeal was not filed within time.
That is also covered.
Coordinate bench
I have
decision is
myself followed a judgment of Gujarat High Court, I guess. What is that?
Even this coordinate bench, there is a case.
Yes. That also should be accepted.
Page 12 and 13.
ಅದು ಜೀವನ ನೇರಳಿಗೆ ಕ್ಯಾಶ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು. Yes. Which is the one, sir?
Sir, my lord, last one, my lord, Hitachi Energy, 12 and 13, page 12.
Indian Potash, Hitachi.
Hitachi.
ಇಲ್ಲೇ ಇದ್ರಲ್ಲ ಎಲ್ಲಿ ಮತ್ತೆ I have passed, no, that's what some Gujarat High Court follow, the apex court, that's what, same. Sushal.
I was just seeking for pass over, my lords. That's all.
I'd let him come. Let Arvind Chavan come. Osho Industries, yes.
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 16.
Right. Learned Counsel Jeevan Neralgi seeks 2 weeks' time to file statement of objections. Interim order, yeah? List the matter on 18th September. Objections, if any, by the respondent revenue by then. Interim order subsisting would continue till the next date of hearing. Yes.
17.
Hello, I am a cab service. I also hire drivers with their cabs to undertake services for my customers. Well, in the previous assessment year, the central GST assesses me to certain taxes. I undertake to pay and I pay vide DRC 03 as voluntary payment. Subsequent year, the state opens proceedings against me saying, on the basis of that DRC 03 payment, I have claimed input tax credit, which is incorrect. RCM alli kattadu nanage input tax ag baralla anta our stand. The reason that they have said, my lords, is at page 36.
Yes.
May I read, my lords? Below the table.
Yes.
On verification of the reply filed by the taxpayer, it is found that
Yes.
on comparison of the ITC available in GSTR 2A with that of the GSTR 3B, it is found that there is an excess ITC claim. Taxpayer submission with respect to RCM is not acceptable for the reason that DRC 03 payment is voluntary payment under 73(5). and cannot be claimed as ITC. Further, no computation of liability, details of order against which it has been paid, no mention of RCM liability in the reason specified in DRC 03 does not substantiate taxpayer submission. Their only objection seems to be, my lords, that in the DRC 03 payment, I have not indicated why I have made this payment. Adana, I have produced the DRC 03s for under which I have made these payments. My lords may kindly look at page 63 onwards. Ali, I have produced all the 4 DRC 03 challan copies where I have made payment. Ali ಕೆಳಗಡೆ last line ಅಲ್ಲಿ
Payment against investigation initiated by so and so.
Please.
That's the one?
That is the one. Under all 4 of them, I have indicated the reason. Ondral kayal bardidini, remaining is all printed. It's the same explanation.
Yes, sir.
I'll accept notice. Appealable orders, Malaj. Appealable orders.
Malaj, I have also made 10% payment because they threatened to.
Tribunal ilvala ಈಗ.
Tribunal ಅಲ್ಲ.
Oh, ಇದು regular appeal.
107 has.
107 appeal, yes.
10% ಕಟ್ಟಿದ್ರೆ
ಕಟ್ಟಿದ್ದಾರೆ. The petitioner heard the learned counsel Lakshmi Menon appearing for the petitioner. The learned AGA is directed to accept notice for the respondents. ಎಲ್ಲರಿಗೂ ಹೇಮಕುಮಾರ್
1 to 3 Malaj.
1 to 3 4
GST intelligence.
ಇವರ ಜೀವನ್ ನೇರಳಿಗೆ
ಜೀವನ್ ಇಲ್ಲ ಅದಕ್ಕೆ.
GST intelligence ಮಧು GST intelligence learned counsel Madhu N. Rao accepts notice for the 4th respondent. The counsel for the petitioner, apart from taking the courts or the documents appended to the petition to buttress the claim for an interim prayer, also files a memo indicating that 10% payment has already been made as is determined by the respondents. In that light, owing to the fact that the matter would require consideration, there shall be an interim order of stay as prayed for till the next date of hearing. List the matter on 18th September. Objections, if any, by the respondents by then. Next.
18.
Madhu, ನೀವು ಯಾರ್ಯಾರಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ? All GST or only GST intelligence?
No, I can appear, but then substantial matters I'm handling for DGJ and DRI and.
ಅದು ಮಾತ್ರ.
ಇಲ್ಲ, CBIC ಗೂ ಇದೆ, but.
All right. ಗೊತ್ತಾದ್ರೆ ಹೇಳಕ್ಕೆ.
I can.
Yes.
My lord, in this case, there are 2 separate orders passed by respondent 2 and respondent 3 on the same subject matter and the same tax period. Then I went before respondent 3, Deputy Commissioner, seeking rectification of the same. Rectification order was passed by Deputy Commissioner, that is at annexure M 101, page number 101. Then after this rectification was done by respondent 3, I went before respondent 2 because same subject matter. Then asked him for rectification. He rejected my application saying that his order is prior to the order passed by Deputy Commissioner. I cannot, because my case is prior to that, I cannot rectify.
Against that order, they filed an appeal.
He affirms the assistant
He
commissioner.
says, Malaj, the first appellate authority says, limitation will be calculated from the date of order in original. My lords must set aside the endorsement and remind the matter to the first appellate authority.
Okay, that's
Yes.
okay. That is my prayer.
All right, that will do. The petition is allowed in part. The order so and so stands obliterated. The matter is remitted back to
Respondent 3, my.
third
Sorry.
respondent. Yaru?
Not respondent 1.
Respondent 1.
Back to the first respondent, Joint Commission of Commercial Taxes Appeals, to consider the issue afresh and pass necessary orders in accordance with law.
With the time limit.
On merits.
Otherwise,
Accordance with law,
merits
on
only.
on the merit of the matter within an outer limit of
3 months.
12 weeks from the date of receipt of the copy of the order. Yes.
Pleasure.
19.
This is a goods transport
For a
agency.
week time, my lords, I have to seek some instructions, my lords.
It's a covered issue, my lord, before this, by this court.
Covered issue?
Lord, the petitioner is running a goods transport agency, my lord.
Covered by what, sir?
Lord, covered by, my lord, where the income tax, the service tax was initiated on the income tax returns. And, my lord, it is covered by the notification by the very
Judgment
notification.
kodi, sir.
Please, my lord, I would like to pop out.
lords. Arvind Chavan sir is appealing.
Granted, wait. Chinmaya,
Please.
Chinmayana idu? Alla.
And this is one more judgment, my lord. I
One
would
minute,
like to
one
pass out. There is-
Chinmaya Seva Trust covered.
In the very same notification, my lord, even for the legal services, my lord, they have been exempted. I am also exempted, my lord, if your lordship
Chavan sir
peruse
is
page
appealing. He said
74.
he left seek some instruction.
No, let him, will
Please,
state.
please,
yes.
please, please.
The petitioner, interim order ಕೇಳಿದಿರಾ ಇಲ್ವಾ?
ಹೇಳಿದ್ವಿ.
The petitioner in support of the prayer, in support of the prayer and the interim prayer seeks to place reliance upon the judgments rendered by the coordinate benches, 2 in number, of the coordinate bench 2 in number, which according to the learned counsel of the petitioner covers the issue on all its force, FOURS. The learned counsel, Akash, is it?
No, my lords, Arvind Chavan.
Learned counsel Arvind Chavan seeks 2 weeks' time to secure instructions and make his submissions. List the matter on 11th September. Avat kodalla. Close it.
Great.
There shall be an interim order as prayed for till the next date.
Great.
Yes, next.
Lords, this is with respect to GST, my lords, wherein I'm an assessee dealing in works contract. Ex parte orders have been passed. Seeking a remand, various grounds raised is with respect to.
No notice?
No notice. First time.
Allah. Before you say violation of natural justice, why?
Why it's all under view additional tab. I was not physically served a notice, and my lords, further, the orders is in barred by limitation with respect to notification 9 and 56, which extended
We'll
as
see.
pending before.
Learned AGA
Annexure B, page 28 for mine. Notices have been served. They have not appeared.
appeared.
ವಾಪಸ್ ಕಳಿಸ್ಬೋದು.
Other ಕಳಿಸ್ಬೇಕು. Petition, ಕಳಿಸ್ಬೇಡಣ?
Upon instructions, sir.
The 12 weeks. Directing him to appear on a particular
On the
date.
let them appear on a
Particular date.
The petition is allowed in part. The order so and so stands quashed. The matter is remitted back to the hands of the second respondent. Second or first? Assistant Commissioner? Or the Commissioner?
Assistant Commissioner.
Assistant Commissioner.
Back to the Assistant Commissioner, the first respondent, to continue to for proceedings afresh on hearing the petitioner. The petitioner shall appear before the first respondent.
Second respondent. I'm sorry.
Second,
ma'am. Second respondent.
second respondent shall appear before the second respondent on the 2nd of September at 2:30 PM. No separate notice need be issued to the petitioner to appear before the second respondent. Second respondent is at liberty to.
Can be in the 9th.
9th.
To be appeared before.
All right, 9th, yes. Order doesn't come by then, order will come tomorrow. No, order may not, because certificate, it may take 29th, because I'm only doing the operative portion, yes. Madam? Second respondent is liable to initiate, to regulate the proceedings on such remand, on hearing the petitioner. Yes, next.
Obliged.
Ordered accord. Within concluding proceedings and medal. 9 months. Yes.
ಯಾಕಂದ್ರೆ ನಮ್ಗೆ limitations ಬೇರೆ
Yes.
ಬೇರೆ assessment period.
My lords, this matter, the connected matter was listed yesterday at serial number 9. It is adjourned to 18/9. We have a stay. It can be connected.
Tag this petition, number code.
0988.
Tag this petition. Already I passed an order.
My lord, we have stay.
No, I passed an order of tagging. This court on 4/8/2025 had passed the following order. The learned counsel submits the said matter is listed on 18/9.
Please.
List the matter along with the said petition on 18/9.
Please.
Yes.
22. Lord, this is a petition where there is an ex parte order. I was a partnership firm, and in the year 20 we closed down business. We admittedly have to pay tax. Now what the assessing office is, the partnership is no longer in force. Demand has been raised on total turnover. My only prayer is let it go back to 148 AB. We will file returns and pay taxes.
ಇದೆಲ್ಲ ಹಿಂಗ್ ಹೇಳ್ಬಿಟ್ರೆ ಅವ್ರು ಬರೀ.
My tax liability is 20 lakhs. They have raised 9 crore demand. Well,
Had they responded, my lords, that we will not be here, my lords.
No problem. Proceedings back to
148 AB stage.
Faceless Center assessment.
My lord, they still have one more year to reopen, so I'd rather go back and pay.
The petition is allowed in part, the order so and so stands quashed. The matter is remitted back to the hands of the first respondent, huh?
Annexure A, yes, my lords.
First respondent
My lords, annexure
To-
A1 to A5 may be quashed.
to the stage of filing of the return, is it?
No, my lords, furnishing reply under 148 AB.
To stage of furnishing the reply under section 148A3 of the
AB.
Act.
AB.
AB,
Now, oh, please, now it will be 2, I think.
148 of the Act, whatever, yes, so and so.
My lords, annexure A1 to A5 may be.
A1 to A5, yeah, allowed in part, A1 to A5 quashed, ಆಮೇಲೆ ಬರೀರಿ, yes.
23.
I appear for the petitions, lordships. Well, this is a petition with respect to the GST law. The demand has been raised only on the ground that the credits distributed by the IIT registrations in Mumbai and Delhi of the petitioner company, which credits are distributed to the Karnataka recipient unit, are not reflected in the GSTR 2A of the Karnataka recipient unit, my lords. Now, pursuant to the issuance of the impugned order, these credits have now started to reflect in the GSTR 2A of the Karnataka recipient unit, my lords. Therefore, the only technical defect which were raised in the impugned order in appeal, my lords, stands resolved. May I therefore request the impugned order in appeal to be quashed and set aside, my lords, because the only technical defect has been
Interim
resolved.
order in their favor.
ಇದೆಯಾ ಇಲ್ಲಿ?
ಇದೆ, interim order ಇದೆ. I'll have to complete the pleading.
Place the matter on 18th at the request of the learned AGA. Interim order subsisting is my order. Subsisting will continue to the next date of hearing. Yes, next.
I'm grateful.
24.
Pleadings to be completed with.
That's what I have said. Yes. Post the matter in B group. Next.
The counsel is Mr. Nagari, she's in Kotal 1. He's praying only for a remand similar to.
Similar to?
22.
But this was
148 AB.
This was an ex parte assessment, my lords.
Yes,
What has
my
happened
Then
is
it has to go back. Yes.
they had a death in their family, my lords. That's the reason they could not come.
All right, same.
As in serial number 21, 22.
22.
Please.
Because
Name may
there-
reflect, my lord,
my lords,
Nagarish.
There, my lords, 148 AB, my lord. This is not a case of 148 AB, my lords.
Ah,
143
the assessment itself, 143 stage.
143 2.
143.
25.
ಅಲ್ಲೊಂದ್ ಕಡೆ ಬರ್ಕೊಂಡು 143 ಅಂತ ಹಾಕಿರಿ.
R3 notice ಆಗ್ಬೇಕು ಸ್ವಾಮಿ.
I appear for the respondents, my lord. We have served the notice, my lord, through portal, through email and through RPD also.
Even then not appeared?
He has not appeared and RPD has returned, address is not found in the said address. It's a written is there, my lords. And he
Yes.
has to approach before the first appellate instead of they approach this honorable court.
R3 notice ಆಗ್ಬೇಕು ಸ್ವಾಮಿ. ಅದನ್ನ
ಯಾರಿಗ್ ನೋಟಿಸ್ ಆಗ್ಬೇಕು?
R3
R3 ಯಾರು?
ನಾನು ಯಾರ ಹತ್ರ ಪ್ರಾಡಕ್ಟ್ ತಗೊಂಡಿದ್ದೆ ಅವರು.
All right, yes. Learned HCGP for 1 and 2, 3 emergent notice returnable by 18th September. Next.
26.
Senior son, BC.
Appearing for the petitioner in this matter, my lord, this is an ex parte order. On account of my Gmail account storage getting full, I could not receive the notices. All that we
Yes.
seek is another opportunity, my lords.
Ex parte order.
Please, my lords.
Will same. Back to what?
Back to the filing of reply to the show cause notice.
Reply to the show cause notice.
Reply, the 148.
ಇಲ್ಲ,
No, no, it's a
143.
GST matter. GST matter,
GST.
74-1. 74-1.
Reply to the show cause notice, yes.
Lordship, may I also, one more prayer, my lords. Bank account is
Yes.
attached. Direction may be issued to the respondent number 3 to permit
Yes,
the
yes.
corporate bank account.
Next.
Obliged minutes.
On disbursement.
27.
This, your lordship, we are challenging two ex parte, proceedings, your lordship, mainly on the ground of limitation, your lordship, because in this case, your lordship, the period of dispute is 2021, your lordship, whereas the show cause notice was
Limitation
issued-
is?
Please, your lordship, 3 year, 2 year, 9 months.
Notice issued when?
Notice was issued on 6th November 2024 and 23rd November 2024.
After what period?
for 2020 and 21.
ಎಷ್ಟು ವರ್ಷ ಆದ್ಮೇಲೆ?
Yes, your lordship. Your lordship, for 2020, 21, your lordship, annual returns has to be filed on or before 31st December 2021, your lordship.
All right.
And the notice should have been issued on or before 2 year 9 months. That will be on 2023 September.
It is issued when?
6th November 2023 and 23rd November 2024. Sorry, 6th November 2024.
Kumar.
I'll accept notice.
And in the connected matters, your lordship, this honorable.
The
court has-
tag this petition, first barcode. Learned counsel, heard the learned counsel Raghavendra Hanjar appearing for the petitioner. The learned AGA accepts notice for respondent 1 and 2. Union of India?
Not
Union-
of India,
Union
it is
Bank of
Union
India.
Union
your
Bank
lordship.
of India.
Bank account has been.
Emergent notice to the third respondent.
Your lordship, in the connected matter,
Kodi.
this honorable court has already granted a stay and the
Learned
matter is
counsel-
seized up before the apex court, your lordship.
Learned
considering-
counsel for the petitioner submits that in identical cases, the coordinate benches have granted interim orders of stay, which reads interim orders of stay, and the matter is now seized before the apex court. In the light of the coordinate bench granting an interim order of stay, there shall be an interim order of stay in the case at hand as well, as is obtaining in the orders of the coordinate bench.
Much obliged.
Next. No date.
petitioner
Petitioner.
house ಸ್ವಲ್ಪ ರೋಲ್ ಚೇಂಜ್ ಆಗಿದೆ.
ಅದೇ ಯಾಕೆ?
My lord, ex parte assessment order for assessment year 1920.
Who Sushal?
Sushal.
Sushal Tiwari accepts notice for the respondent. Copy ಕೊಟ್ಟಿದ್ದೀರಾ?
First time, my lords.
Huh?
First time.
First time. We'll take it next week, 28th.
My lord, the entire retirement proceeds of this ex-serviceman have been added as an, my lord, unexplained money. The retirement benefits ಎಲ್ಲ tax ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, unexplained money ಅಂತ. And bank account is seized.
Next week we'll close it.
Please.
Interim order ಬೇಕಾ?
ಇಲ್ಲ interim order ಅಂತಂದ್ರೆ bank account close
ಅದಾಗಲ್ಲ.
ಆಗುತ್ತೆ, seize ಆಗುತ್ತೆ. ಅದಕ್ಕೆ
we'll take it on
can be
28th.
remanded back to the, my lord.
28, we'll take it on 28th. Let him copy ಕೊಡಿ ಒಂದು.
Please.
Learned counsel Sushal Tiwari accepts notice for the respondent petitioner to serve set of papers upon the aforesaid counsel list on 28th. Yes, next.
29. Raj, I'm appearing for the petitioner in this matter. Subsequent to filing of this writ petition, my lord, the department has dropped the proceedings.
Day before yesterday, some matters
Yes.
were there.
Same, similar connected.
Infractions ಆಗಿದೆ ಅಂತ.
Yes, my lord.
Yes, that's what. ಒಂದು 4 ಮ್ಯಾಟರ್ ಒಟ್ಟಿಗೆ ಮಾಡಿದೆ ಯಾರು?
After filing the writ petition here, my lords, they have filed an application for rectification before the.
It is rectified.
respondent. We have rectified.
Yes. The learned counsel for the petitioner submits that after filing of the subject petition, the rectification has come about, rectification is accepted, therefore the grievance of the petitioner has been redressed. In that light submits that the petition is rendered infructuous, therefore the petition is disposed as having become infructuous. Next.
Lordship may say, my lord, may I make a request, my lord? Lordship may
Yes.
say, leaving the question of law open, my lord, because this rectification was initiated by the department itself.
The,
Tomorrow-
all the contentions shall remain open. Yes.
Obliged, obliged.
30.
You are there? Yes, Lakshmi madam.
My lord, this is a matter where I have supplied to an SEZ. They are asking me to pay tax on it. I am saying this is an exempted supply, zero rated, sorry. And my lords,
Exempted supply through
zero
circular.
rated supply as per section 16 of the IGST Act. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಐ ಹ್ಯಾವ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಎನಿ ASMT 10 DRC 01A ಶೋ ಕಾಸ್ ನೋಟಿಸ್ ಆರ್ಡರ್ ಯಾವುದು ಬಂದಿಲ್ಲ. What I understand is when I received the DRC 013 attaching my bank account, that is when I realized that there are proceedings going on against me. I go to the portal, my lords, I've produced screenshots
That
of my
will issue
portal.
notice. The learned AGA is directed to accept notice.
Can
for
be
the-
sent back.
Huh?
ವಾಪಸ್ ಕಳಿಸ್ಬೋದು.
ಯಾವ್ದು ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀರಾ? Sweet home. What is this?
ಅಲ್ಲ ಅದು ಬೇರೆ ಮ್ಯಾಟರ್.
ಇದಲ್ವಾ?
ಇದರಲ್ಲಿ ಐ ಹ್ಯಾವ್ ಆಲ್ರೆಡಿ ಪ್ರೊಡ್ಯೂಸ್ ಜಜ್ಮೆಂಟ್ಸ್ ಅಲಾಂಗ್ ವಿತ್ ದ ರಿಟ್ ಪಿಟಿಷನ್.
Yes.
Prayer C of the petition, my lords. They want the matter to be restored to the stage of reply to the show cause notice.
Annex to the stage of show cause notice again.
Page 16.
Page?
Page 16 ಅಲ್ಲಿ ಇದೆ prayer.
Prayer C.
Order is at annexure page 33.
Yes.
My lords, may kindly fix a date we will appear in front of.
Yeah, 9th September at 2:30 PM.
Before the authority, my lords.
Before this, not here.
Great.
For the authority. ಅದೊಂದು ಬರ್ಕೊಂಡ್ರಿ ಜೀವ. ಜೀವ. ಆಯ್ತು. ನಾಳೆ ತಗೊಳ್ಳೋಣ. Yes.
31.
That's for the petitioner, my lords. This is a case where bunching of notice, show cause notice, consolidated show cause notice.
What is identical orders?
It's stayed, my lords.
It's stayed, I know, which is that.
We have stayed. I have.
Kodi,
I'll pass.
Both 31, 32 same.
No, my lords.
31
31 is only show cause notice. 32 is with respect to.
Jeevan Neralgi, who?
Chavan.
Central tax yar.
Arvind
Chavan. Counsel Arvind Chavan accepts notice for the respondents. A petitioner to serve set of papers upon the aforesaid counsel if not already served. In the light of the interim order subsisting in all companion petitions, there shall be an interim order in the case at hand as well. Yes.
Date may be fixed. It can be sent back.
And then 18th, list on 18th September.
Grateful, my lords.
Next.
My lords, seal number 32 is with respect to Chinmay. It has to be.
In my trust.
Chinmay trust.
Pasora.
Next.
28th. 28th will close. Yes. 28th. Arvind Chavan, same. Arvind Chavan accepts notice for the respondent, list on 28th. Yes, Mahesh.
That's in this matter.
Jeevan.
Jeevan sir told he's not appearing for the registrar of ITET. So we tried.
No, I'm not in the income tax. So Tiwari or Dilip will take.
This is day before yesterday's matter.
Day before yesterday.
That's had given it today.
ಏನಾಯ್ತು ಅಲ್ಲಿ?
Azim, that's
AI generated.
yes. The matter before the president, he said he'll take up the application. That's after we showed this order. That's that matter is likely to be listed on 29th because what happens.
We'll post this on 28th. ಅಲ್ಲ ಇದು ಯಾರು appear ಆಗ್ತಾರೆ ಇವ್ರಿಗೆ?
ಅದಕ್ಕೆ so that's may take it by hand to the registrar of the ITET.
Registrar of the ITET.
Yes.
The registrar, the ITET be served. The petitioner shall serve the first respondent by way of hand summons. 2 and 3 are?
2 and 3 I'll take.
Dilip.
2 and nominal clock, if you let him up.
Dilip. 2 and 3. Registry to delete the name of Jeevan Neralgi appearing for 1 to 3 and print the name of M. Dilip. Copy koti. Copy koti. Sounds. We'll take it on 28th or later?
Let's may have it first week or second week of September.
11th.
Great.
List on 11th, interim order subsisting would continue to the next date.
Great.
Password. Faceless.
Pastor matters.
Shankar sir, faceless ಯಾವ್ದು ನಿಮ್ದು?
My lord, there are other 13 matters on the list, my lords, after this.
Which is yours, sir? Question of law ಒಂದೇ ಅಲ್ವಾ? This I will not pass any order, but I want to know. Yes.
47.
47. File ಕೊಡಿ madam.
Well done.
Yes, sir.
Yes, my lord.
I am holding serial number 47.
Anyway, I'm going to just file a one paper because it's not required to see this at all, my lord.
Which one?
The petition is not required. I'm just giving you a lordship a compilation.
Ashte, that's all.
That will help you for everything.
Yes, yes. ಅದು ಗೊತ್ತಾದ್ರೆ we will face less problems.
Point is very simple, my lord. Just to give your lordship a brief. After the insertion of section 151A, the contention of the revenue, the contention of the assessees are that all notices that require to be originated for the purpose of assessment, reassessment under 147, in view of the specific notification on 29th March 2022, has to be issued by Faceless and not by the judicial. AAO has no authority. Now, this matter contained a lot of debates over various courts in the country.
Yes.
One of the most, there is one, the section 151A has to be seen, which I'll point out to your lordship, and the notification dated 29th March 2022. These are the two important things. There are so many other notifications which may not be relevant. All the notifications have been actually, my lord,
Good day. Order. High school.
even that Delhi also I put last time. No, my friend wanted to know that I put the Delhi High Court, which is against us. That also I told him I have already placed it in the compilation. Ultimately, at the end of the day, it's a question of law.
That's all.
No point in keeping something and making them
yes.
give it. One compilation which will be useful. Only two more decisions after I prepared the compilations are not there, which will give loose copies to your lordship. I won't take all those decisions. The background is, my lord, there's no quarrel on 151A that Faceless has to activate. Now the quarrel comes around the circular dated 29th March 22, which your lordship will get it at page number 212, my lord.
Yes.
Lordship get to page number 212. The actual thing is at page number 213. That is the notification which gives us the support to say that the assessments have to happen by way of Faceless. I just read at page 213. 3. Scope of the scheme for the purpose of the scheme. Scope of the scheme. For the, I'll just read it out, my lord.
Yes.
For the purpose of the scheme, assessment, reassessment, or recomputation under 140 of the Act, issuance of notice under section 148 of the Act, both items are covered, shall be through automated allocation in accordance with risk management strategy formulated by the board as referred to in section 148 of the Act for issuance of notice, and in a faceless manner to the extent provided in section 144B of the Act with reference to making assessment or reassessment of the total income of the SC. An automated allocation word used is very, very important, my lord, because if the jurisdiction assessing officer, there is nothing question of automated allocation to him at all. He has the jurisdiction of the PAN number, he has the right to issue notice. The fact that the scheme contemplates an automated allocation in a faceless manner is clinching the issue in favor of the SC. That's how various courts have held, that it has to be done only in faceless.
So the initiation itself is faceless.
You have to initiate at faceless level. And the basis for the initiation, they have said, is in a faceless manner to the extent provided in section 144B. 144B says it has to be done in a faceless. There's no quarrel on that between both sides. Both sides are in the same plane there. Now, this was subject matter of challenge. The Delhi High Court, in the case of TKS Builders, which I placed at 379 to 440, I'm not taking it, they will take it, but it's their case. We held against the SSC. And the Bombay High Court and the Telangana High Court, in the case of Kanakala, Ravindra Reddy and Hexaware, which is the most important
in
decision.
favor of the SSC.
In favor of the SSC. Now, subsequently, my lord,
yes,
two decisions have come recently. One of the Telangana High Court and one of the Madras High Court, where they have found a solution to this problem lingering over hundreds and hundreds. The simple point is, my lord, whether the notification should be Madam, I am only making this. What this the Delhi High Court matter is pending in the Supreme Court, and the Bombay High Court is also pending in the Supreme Court.
No, Supreme Court has rejected.
Recently, I come to that, madam. That is the point, my lord.
Bombay High Court, Supreme Court, I think, has rejected.
No, Bombay High Court original Hexaware is pending, my lord, and the Delhi High Court from the Assi side is pending in the Supreme Court. Subsequently, two different combinations of division benches have dismissed the SLP, against which they have supposed to have filed a
review.
MA, review.
Reviewers,
Application
yes.
is filed basically on the ground by saying, based on the original decision, there's a batch of about 200, 300, 500 matters pending, or 900 is what they are saying. Be that may. To put the matters easier, my lord, the latest two decisions which I gave actually helps us to dispose of all these petitions pending in this court in a very easy manner.
Which
Lordship-
the Telangana High Court,
Your lordship may take the Madras High Court, my lord.
Madras High Court.
Because
yes.
Madras High Court is authored by the, my lord, who authored Exaware in Bombay, my lord.
Yes. Oh, Sriram. Justice
Shriram,
Sriram. Yes.
My lord Shriram. Dada Pharma, your lordship will see over the page how they have addressed the issue. Para 6. We follow the law laid down in Exaware Technology Supra. The said judgment was authored by one of us that it is mandatory for the FAO to issue the concerned notices, and issuance thereof by the JAO would make the notice invalid. That is the final ratio in all the decisions. Admittedly, Srinivas in fairness state that there is no stay, therefore the law laid down by Exaware applies. It is clarified, if the apex court reverses the judgment of Exaware, parties will be governed by the decision of the apex court. They have protected the revenue.
ಎಲ್ಲ dispose ಮಾಡ್ಬೋದಲ್ಲ ಇದು?
That's what, my lord. That's why I came to it. I'll complete it, my lord.
Yes,
They can
all
take
right.
one day.
All right, yes.
I'm not, because they are put to this point only today.
Yes, yes, yes.
Lordship, see, they protected the SC also at para 9. Keeping open all rights and contents of the parties, including liberty to apply to this court in case the revenue succeed before the apex court to reveal the petition. The notice issued in this petition is quashed and set aside. What they did, my lord, we argued by saying, in some other petitions, this JOFAO alone is not the question. There are some other grounds we have taken. If this is gone and that get reversed,
That, yes, that's
so
true.
we are also protected by saying that we also
So
have a right.
you have liberty to urge those grounds.
I can revive the petition back and urge those grounds. So this is one decision of the Madras High Court, my lord. Now your lordship may take to the decision of the Telangana High Court, my lord. And I just want to take your lordship before the final order. Your lordship may take to para 5, my lord.
Yes.
Para 5. 9
Yes.
high courts have given in favor of the SSC. I'll just read that one para, my lord.
Yes.
Down the line, we find the same issue has also been decided against the revenue by various high courts, by the Bombay High Court in the case of Exaware, so and so, Guwahati High Court of Ram Narayan Seth Union of India, the Punjab and Haryana High Court in the case of Jatinder Singh Bangu, the Telangana again in the respect of international taxation, Bombay High Court in case of Abhin Anil Kumar Shah, a very, very well
Yes.
articulated decision, which I kept it at page number 190 of my compilation, my lord.
Yes.
Himachal Pradesh in the case of Govind Singh, and Gujarat High Court Mansukh Bhai Daya Radia.
Yes.
In fact, Gujarat High Court once had held against SSC only in respect of central charge, but subsequently they have passed an order in our favor in this Mansukh Bhai. Similar views have also been taken with decision making of the Calcutta High Court and so and so. Now your lordship will come to the last para, para 18. We would like to make, your lordship at para 18.
Yes, yes.
We would like to make further observation that since we are inclined to dispose of the instant writ petition, conscious of the fact that the earlier order of the High Court in the case of Kanakala Ravindra Reddy is subject to challenge before the Honorable Supreme Court in SLP number so and so, preferred by the Income Tax Department, we make it clear the allowing of the instant writ petition is subject to the outcome of the aforesaid SLP preferred with revenue against the decision of this court. In the case of Kanakala Reddy, this, in other words, would mean that either of the parties, if they want, may move an appropriate petition seeking revival of this writ petition in the light of the decision of the Honorable Supreme Court pending. So this is a method by which they
Yes,
have given
Dilip, we should dispose all this.
this is all, my lord. Let them take one day or one, whatever, next week your lordship may fix a time. Two courts have held like that, so it becomes easy, my lord.
Only one submission. For us, two charges, my lord. So for us, central
No,
charges.
that is always kept open by Madras High Court and the.
No, not.
No, it's kept, my lord. My lordship may kindly go to page number 418 of the paper book, where that circular is extracted.
All right. So
So the circulars specifically say keeps
all that Supreme Court will argue madi.
Not that, my lord. There are two charges.
two charges which are out of, my lord, kept out of faceless.
That is what the apex courts, the division benches hold, that it could revive on the other grounds.
My lord, that decision does not deal about this
These
circular.
two.
These two central charges and international taxation.
Page number 418, my lord.
It was never part of Faceless, my lords. It was always by the jurisdictional assessing officers. Because assessees are challenging.
Yes, Shankar sir, it does not.
Your lordship may take to page, this issue is covered by the Bombay High Court. Decision in
Page
number
190.
190. Yes, my lord. I'll take, because the notification which they are referring to keep it out has been superseded. In fact, on the last occasion when we argued on matter, I pointed out to my friend, by showing this decision only, my lord. I will take your lordship to 1 minute, my lord. Page 200.
Yes. I am there. Thus the scheme.
1 minute, my lord. Just I'll read the two notifications for your lordship. Your lordship at page 198.
Notification is there, page 200.
No, 198, my lord. What they are referring to.
The circular.
Yes, my lord. 198.
Yes.
Your lordship,
Order.
their contention for 198 is assessment orders. Your lordship will get the order. Your lordship got it, my lord.
Yes.
Dated 6 September 21.
Yes.
Your lordship may come to para 2. Just at the end of para 2, they want to keep assessment orders in case of central charges. In the case of international charges, they are saying is to be excluded. That is this notification. So, but your lordship will notice the same thing has been considered.
Come to
Para-
page 199.
Para 10.
Thus the fact remains
Yes, my
as
lord.
to what is provided under
That's from where your lordship?
5
10.
lines from the bottom.
Para 10, my lord.
Para 10.
Thus, from the reading of the aforesaid order dated 6 September 21, it is clear that CBDT has referred to the order dated 31st March 21, issued in relation to assessment orders in case assigned to central charges and in case assigned to international charges being not required to be passed under the National Faceless Scheme. However, what has been done by such an order is to modify the order dated 31st March 21 to the extent what is set out in para 3 thereof, namely, the addition to such exception to the applicability of the faceless mechanism to the assessment orders in relation to central and international charges. An addition exception was added, namely, to the assessment orders in case where pendency could not be created on ITBA because of the technical reasons or cases not having PAN, as the case may be. Thus, the fact remained that as to what was provided with the order dated 31st March 21 in relation to non-applicability of faceless mechanism to assessment orders in cases assigned to central charges and international charges, the position under the order dated 31st March 21 remained undisturbed and continue to operate. It is thus clear what was brought within the purview of the order dated 31st March 21 and subsequent order dated 6 September 21 was the non-applicability of faceless mechanism only to assessment orders in cases assigned to central and international charges and not to applicability of any prior procedure as contemplated under 148A and 148 of the Act as held in capital GB. Thus, the scheme as framed under 151A and notified under the notification dated 29th March 22 does not include the applicability, inclusion, or even reference to the orders dated March 21 and 6 September 21. Such is the consistent view in both the decisions of Exaware and capital LG. So as to complete the sequence of event, it would be appropriate to note the notification dated 29th March 22 as issued by the central government notifying the scheme, namely E-Assessment Income Escaping Assessment Scheme 22. The said notification reads as under. Your lordship will take over the page. I already read the decision of the scope of the scheme to your lordship. So I will skip that. Now your lordship, see, my lord. Very important para 12, my lord. They completely said the old notification is gone. Having heard the learned counsel, the petitioners and Mrs. Mistry, learned amicus, it is clear to us that although the objection of Mr. Goyal at the first blush appeared to be attractive, when we first heard the matter on the earlier occasion, however, on deeper scrutiny, such objection needs to fail. Mr. Goyal's contention that the category of cases as notified in the order dated 31st March 21 and 6 September 21, that is central and international charges, my lord, issued under 119 of the Act, providing for exclusion of cases assigned to the central and international charges from the applicability of section 144B of the Act is concerned, Senate can be accepted to be the correct position of law. Such contention of Goyal needs to fail for more than one reason. Firstly, the order dated 31st March 21 issued under subsection 2 of 144B of the Act and the order dated 6 September 21 issued under 119 of the Act apply in respect of assessment orders to be passed as clearly seen from the current content of both such orders, which we have extracted here and above. It is not for notice, my lord. That those two are only for orders. Secondly, the scheme notified under section 151A, the notification dated
Both all your contentions are here.
Yeah, all my
Considered.
contentions and considered, whatever they are saying are considered.
Yes.
And ultimately they have held it Hexaware and capital A. So in fact, my lord,
What happened to this? This is before the apex court?
This my
Which this Abhin Anil Kumar Shah.
See, my lord, we have no idea how much. There are more than 200 of them. I will,
Correct.
can you check by the next occasion? I will also
Yes,
verify.
yes,
and
no
let you know.
problem. Yes.
At this point of time, I do not have that information. The point, my lord, they can take a time. It's easier to dispose of the entire batch of FAO, JAO.
Both the interest, both
Both
assessee and
interests are
revenues
protected.
interests are protected in
And-
both the decisions.
And apart from that, my lord,
In fact, the Telangana High Court holds repeated petitions are coming, you should first stop it. That's what in a particular paragraph I saw.
Southern, yes, my lord.
No, this
Southern.
Southern Power.
Southern Power
yes.
Distribution. Yes, my lord. Para 10, my lord.
Para
18.
para 6, if you see, even though the same issue has been decided by large number of high courts, we are still confronted with large filing of identical matters on daily basis.
Correct. Here also about 200 are there, my lord.
That's what. All faceless,
All faceless.
we will e-face.
Yes, my lord.
Yes.
That's all the short point. Let them take one day time, whatever.
28th.
Fourth, my lords.
ಎಲ್ಲ ಅವತ್ತಾಗದು ಅಷ್ಟೇ ಇವತ್ತಾಗದು ಅಷ್ಟೇ.
It's only because the AST has to make.
AG ಇದರಲ್ಲಿ
Isn't it?
standing covered complete. You show these judgments and still secure instructions whether ASG would appear for this.
But he's made, yes, Venkatraman wants to make some
Huh?
submission. AST Venkatraman wants to make some
No
submission.
problem. I am not coming the way at all.
Fourth, my lords.
All right, 4th, but that day we'll close it. Yes.
And your lordship will give all the decisions, my lord, all the petitions.
All the
But,
petitions.
One separate list can be made for it.
On separate list ಮಾಡ್ತೀನಿ faceless. Yes, madam, ನೋಡ್ಕೊಂಬಿಡಿ.
I just pass on the two decisions where
Got it.
Venkatraman only has appeared
My lords,
and
that's not
SLP
true, my
dispelled.
lords. That's not- They should-
There in the order, I have not to owe him. I can only produce what is there in the Supreme Court website, my lord. Maybe he has not appeared, his name has come wrongly, I am not getting into it.
My lords, that.
That's why I said secure instructions from the ASG, whether it is, whether he would appear in the light of these,
Sorry, my lord, I have sent 2 copies of that, one copy.
same order.
I placed that on morning.
Huh?
I placed the same order. Morning I've placed that.
Same order ಇವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಬೆಳಗ್ಗೆ.
ಇಲ್ಲ, ಎರಡಿದೆ, my lord.
Both he has placed.
I know, my lord. I was
Against
there.
that, we filed a MA, my lords, on the very next day, my lords, by oversight that has happened.
Oversight, what has happened?
That's this.
When the SLP was
ಅಲ್ಲ, you
heard,
forget it. ಅಲ್ಲಿ ಏನಾದ್ರು ಮಾಡ್ಕೊಳ್ಳಿ. Now we will follow the division bench of Madras High Court and Telangana High Court and close it.
ಬೇರೆ division benches, 3-4 benches ಮುಂದೆ ಬರ್ತಾ ಇತ್ತು, my lords, so we could not.
ಎಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲ. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ both are before Justice Pardiwala.
There is other batch which is coming before Justice Nagaratna. That is the confusion, my lords, which is.
anyhow, till it is recalled, it holds the fort.
Holds good. Recall agli, stay agli. These two judgments definitely will hold good.
Please, my lords, that we are.
There are 900 cases before the Supreme Court, my lord.
Supreme Court will decide, but division benches have already decided, permitting revival if Supreme Court decides against the
Actually, it is
SSC.
good for everybody for 3
Yes.
reasons, my lord. One is,
ಸುಮ್ನೆ pendency ತೋರ್ಸುತ್ತೆ.
Please.
28 ಹಾಕಿರ್ತೀನಿ, you seek instructions, will close it. Both the interests are protected by the division bench. Justice Sriram or it's clear.
I'll pass on one more decision, Supreme Court, very interesting, my lord. Though it is not dismissed, there are the prima facie view that it is only faceless and
This is against which order? Punjab and Haryana.
but the only thing is they have only issued their notice on account of the fact that other matters are issued.
Pending, yes.
But they express the prima facie view on it. My lord, my submission, my lord, is if this is disposed of, advantages to 3. The court pendency will go.
Yes, most
Both
important.
my junior bar will at least get some professional fees. And if at
No,
all,
no, definitely.
And my friends also will get it. So lastly, my lord, if suppose it has to be revived, they will all get one more piece also.
Yes.
So in fact, at least for that sake, they should agree, my lord.
You won't.
No, 28, whatever it is. See, the first thing, fees is, yes.
No,
First
I'm
thing is
joking.
pendency would get reduced.
I was just in a very
So
light
200, 300 matters pending. 28th, I'll list all the faceless. Bad, 28th there. Yes. If the learned age is appeared there, unless that is set aside, then it follows. Yes. 28th.
Obliged.
Yes. There's no fun in keeping these pending for no reason.
These
The
papers
ideal judgment is division bench of Madras High Court, which is followed by Southern.
We are concerned only so far as international tax.
That is also covered in Bombay High Court.
With regard to that, he needs to
No,
make
the Bombay High Court holds that, division bench of Bombay High Court considers that.
there are subsequent other high courts which they say, my lords, for central circle charges, it has to be kept out.
Anyway, that is before the apex court now.
Let them give, my lord. If anything, then let us on that day.
Revival, it's not that proceedings are closed completely.
grant
The
them
apex
any-
court holds against the SSC.
Any decision which is not there, I will let us start.
Yes.
I've given my full compilation.
28th, I'll get a separate list.
Yes, ma'am. We'll also
Dilip,
give-
list code.
Please, now we, from all
Sushal and
this
Dilip.
side also, we will give the list.
Give the list,
Every
all the matters.
Any decision, I will collect. Put ನಮ್ಮ ಕೊಡು.
ಇವತ್ ಅಣ್ಣಮಲೆ ಇವತ್ತೇ ಕೊಟ್ಬಿಡಿ.
ಇವತ್ತು
List
ಇವಿರೋದು
with
list
whatever
ಮಾಡಿ.
you have in your
Yes, madam.
kitty. Yes, and new list.
This decision, my lords, which where it says central charges are out of faceless, my lords, this is what, that's Gujarat High Court.
Gujarat High Court itself, afterwards, I will produce a judgment where they have not followed this. I will produce it, madam. Talati is, my friend is saying Talati, my lord.
Yes, it is
I will-
Talati.
Only
And on
that-
28th, I will give, my lord. Where they have said central charge. See, because, my lord, this Bombay High Court, they are all department on the notification dated 21. They have clearly held 21 notification doesn't talk of notice, it talk of assessment orders. So one, if it's an assessment order, the central charge and international charge, why they have given that notification for assessment orders, my lord? It requires a tremendous amount of verification of material, satisfaction and all. So they have said the notice must continue to be issued, then the assessment will come back to the, by a,
No, reading that, I was prima facie opinion that notice is issued by the jurisdiction officer. Once you file return of income against that notice, then it gets into a faceless mode. That's not what is.
that's not what it is. But that section contemplates. They don't want the officer to issue.
No,
notice,
that
my
is
lord.
how
All-
Delhi High Court, that is how Delhi High Court proceeded to.
No, that's what I thought, but
Delhi High Court is also a place, my lord. In my paper compilation,
Delhi High Court appreciated the whole scheme, not from that
but
angle.
the various other, everything is in the apex court anyway. Till the apex, you will all revive this.
Please.
As I said, 2 sets. Benefits both of you. As you said, it benefits both the sides.
yes, my lord.
In closing
Yeah,
it
we have
and
to
reviving.
prepare all the details.
More to
What I'm
them, my
telling my
lords.
colleagues, because court is not
The-
working Monday, Tuesday, so on 28th it comes, means we all have to
I know,
give the
that's
list
what,
by today
more,
itself.
today itself, if you give the list,
Today
it will all be
after
listed on 28th in a separate list,
2:30.
faceless list.
2:30.
2:30, yes, 2:30. 2:30 on Friday.
Yes.
ಇವತ್ತಿನ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದಿದೆ
I've
faceless?
given the numbers, my lords.
List ಮಾಡ್ಬೇಕು.
Thursday, sorry,
Thursday.
Thursday.
We'll give the, we'll tick it off to.
Yes, ಇದರಲ್ಲಿ ಟಿಕ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. ಆಲ್ ಇದೆಲ್ಲ ಸಪರೇಟ್ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ಬಿಡಿ. 28 separate list, all the faceless
Then so
matters.
much more are there. Sandeep, all others
Whatever
will
is
give.
there.
I'll ask
All
my-
councils, please give the numbers.
Oblige.
Yes, sir. We go to the second list.
Sorry for the intrusion, my lordship. This is for serial number 44. I just missed the call. Serial number 44, list 1. This, I am appearing for Passam Brothers, my lordship.
That's faceless?
No, my lordship.
I'm not ready. Wait, why? Yes.
It's number 2. Being spoken to seal number 1.
ಕೊಡಿ typographical error. This court,
List number 2, seal number 1. I'm appearing for the.
this court on 11th November 2024 had disposed the petition on the score that the police after investigation had filed the charge sheet. there appears to be an error in the light of the submission made by the learned additional SPP on the said date. Therefore, the order disposing the petition on the score that the score that charge sheet is filed stands recalled. The petition is restored to file. Interim order of any kind subsisting at the time when the subsisting during the subsistence of the petition also shall stand restored. List the post the matter before the bench having roster. Post the matter on list the matter on 29th. Yes.
Orders, seat number 2.
Sunil Kumar.
I am appealing for the petition.
Office objections in.
ಅದರಲ್ಲಿ ನಾನು ಅದರ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ನನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅಂತ ದೇ ಆರ್ ದಿ ಬ್ಯಾಂಕ್ ಓನ್ಲಿ
ಬ್ಯಾಂಕ್ ಪಾರ್ಟಿ ಬೇಡವಾ
ನಾಟ್ ನೆಸರಿ ಬಿಕಾಸ್ ಮೈ ಲಾರ್ಡ್ ದ ಬ್ಯಾಂಕ್ ಲೋನ್ ಹ್ಯಾಸ್ ಗ್ರಾಂಟೆಡ್ ಬೈ ದಿ ಒರಿಜಿನಲ್ ಬ್ಯಾಂಕ್ ದಟ್ ಈಸ್ ಜಯನಗರ ಬ್ರಾಂಚ್ ಅದರ್ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಆರ್ ದಿ ರೀಜನಲ್ ಆಫೀಸ್ as well as the head office.
Which are the other defendants?
My lord, the chief manager, defendant number 2 and defendant number 3.
Of City Union Bank itself?
They are the branch as well as the head office also made as a party in the original suit.
Office objections overruled. Yes, tell me now.
My lord, the respondent number 2 has purchased the property during the subsistence of the mortgage in favor of the bank. My lord, bank has initiated the proceedings under Sarfasi Act and they have affixed a notice under section Rule 8 of Sarfasi Act. And thereafter, my lord, she has filed a civil suit before City Civil Court Mayhall and sought an injunction. The City Civil Court granted an injunction and later on I filed an application for a rejection of the plaint. My application was dismissed on giving a ground that there is a fraud. My lord, the encumbrance certificate that I have not produced, my lord, I am producing now. The mortgage is, my lord, much prior to the loan, to the purchase, to the sale deed of the respondent.
Respondent Barley. The heard the learned counsel.
Now the matter is posted for a.
Heard the learned counsel appearing for the petitioner. A suit is instituted by the respondent plaintiff in OS 26501 of 2021, indirectly invoking the jurisdiction of the civil court for a proceedings under the Sarfasi Act 2002. The first respondent, the plaintiff, is a borrower from the hands of the petitioner, defaults in payment, and which results in the bank initiating proceedings under the Sarfasi Act against the borrower. So, DRT hogilva?
DRT hogilla.
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 The jurisdiction to challenge the proceedings initiated by the bank invoking the provisions of the Sarfasi Act admittedly would lie only before the debt recovery tribunal. The civil court, jurisdiction of the civil court is completely barred on whatsoever ground it may be. Therefore, the bank comes up with an application under Order 7 Rule 11 of the CPC seeking rejection of the plaint. This comes to be rejected by the concerned court on the score that what is alleged is a fraud played. The learned counsel for the petitioner submits that it is not by the bank but by the borrower. The property is mortgaged.
Mortgage, my lord, on
After the loan,
mortgage, she has purchased after a loan only.
The first respondent defendant, first respondent plaintiff purchases the property which was already mortgaged to the bank and the loan was secured against the said mortgage by the vendor of the plaintiff. Therefore, it is a purchase during the subsistence of the mortgage. All these will have to be thrashed out before the tribunal and not before the civil court, as jurisdiction is admittedly barred. In that light, there shall be an interim order of stay of all further proceedings before the concerned court till the next date of hearing. Next.
I may be permitted to serve a notice. She has filed wakalat. Others are, other
The
defendants.
petitioner shall serve the defendants by way of, respondents by way of hand summons, list the matter on,
The advocate, to the advocate on record.
counsel, sorry, may liberty to serve on the counsel who represents the respondents in the trial proceedings.
And other respondents are not contested in the matter
The
before.
memo code. Yes. If you want dispensation, give a memo.
Will give.
Yes. Next. List on 19th September.
3, number 3.
Notice taken, returned, refused. The postal shara indicates the third respondent has refused acceptance of notice. In that light, the third respondent be shown as served with the name printed on the cause list. Yes. Next. Idra continue ಮಾಡಿ.
Number 4.
Post immediately after service of notice upon respondents 1 to 4.
5.
Serial number 4. I've
Huh?
served the copy, my lord. I've served the copy to the trial court. Acknowledgement has been served in the register.
All right. Yes. There is an interim order.
Yes, my lord. Interim order may be extended.
Interim order subsisting would continue. Next. 5. Review petition. Na.
My
Your
lord,
Lordship,
sir.
this is, the matter relates to reimbursement of GST.
Ah.
I am before Lordship on only on 2 grounds, Your Lordship. Number 1, without serving notice on the respondents, the order was passed. So we didn't have an opportunity to file
Review
our.
petition ಯಾವಾಗಿಂದ?
My lord, sir. Again, the same. It's a transitional GST from VAT to GST.
So my order.
Yes, my
Yes.
lord.
When
Your
did I
Lordship had
pass?
passed an order
No, it's
on 19/2/2024. Your Lordship passed an order.
19 to 24.
Your Lordship at page number 25, Your Lordship, 25, Lordship.
18, 11, 20. Interim order.
No, final order. Final order, Lordship. At page number 25, Your Lordship. Disposed.
My lords. The coordinate bench
Ah.
has upheld the order of the single judge bench.
Oh, it's
Now, and
the
now
GM
the
roster.
notification
Ah.
has been upheld. The review petition does not hold any water, my lords.
So what's the problem? One minute, madam. Yes, yeah, what's the
Lordship,
problem with this?
I filed a review petition on 2 grounds, Your Lordship.
What ground?
First ground is that the respondents were not served the notice. So they
Refund
didn't-
of GST.
A refund of GST.
Ah, yes.
So there was an issue on the quantification of GST to be reimbursed.
Ah.
And second ground is that Your Lordship.
You are not heard?
We were not heard in the matter, Lordship. So that's the reason we are.
Why notice was not issued?
Notice was not issued, Lordship. So that's why we are before. My only prayer is, Lordship, may kindly allow the review petition and restore the writ petition.
And dismiss and allow it again.
No, because we have one quantification issue also on the GST reimbursement aspect of the matter. Because Your Lordship in operative portion.
All right, they are not heard, Andre will restore it and
As
I
to-
can't do that. The Apex court or then it will be a problem. Could.
My lords, there's no.
Notice is not issued to them even.
My lords, on the previous date, they were well informed on the fact that.
That's a different thing, madam. Notice is not issued to them. Only first respondent, that is government advocate, is heard. Should they not be heard? Yes. What is that you wanted to give?
My lords, it was the order of the coordinate bench wherein it has been held that the notification with regard
All
to.
right, let him have his say. We may pass the same order, but let him be heard.
Kindly, my lords.
The petitioner is respondent. Which respondent?
Your Lordship, I appear for respondent number 6, sir.
Yalla, everybody will start coming. I will not entertain this. I will only hear you because law is clear. All right. If law is clear, then everybody need not file petitions here. Yes. The petitioner, which respondent are you?
Respondent number 6, Your Lordship.
In Housing and Infrastructure Development Corporation. Huh?
6, Your Lordship.
The sixth respondent is before this court. Seeking. Which connected matter?
He is for.
The petitioners, review petitioners R5 and R6 in writ petition 25439 of 2023 are before this court seeking review of the order. What is this?
RP.
Adರಲ್ಲಿ ಯಾವ respondent, sir?
Adರಲ್ಲಿ respondent number 3, Your Lordship, in 28, Your Lordship.
A few of the respondents in writ petition 25439 of 2023 have have filed subject review petitions on a solitary score that though they were respondents in the petitions, no notice was issued on the ground that the issue in the list stood covered by the judgment rendered by the coordinate bench. The learned counsel for the petitioner, the review petitioner should submit that they have some submissions to make, notwithstanding the issue standing answered by the coordinate bench. This court, on the say of the parties to the list on the day when it was disposed, i.e. on 19 February 2024, had followed the orders passed by the coordinate bench and closed the proceedings, which was concerning the refund of GST. The law is declared. It is ununderstandable how it can be fragmentally differentiated now by each of the respondents. Nonetheless, to afford an opportunity to the petitioner, to the review petitioners, the order stands recalled, list the matter on 2nd September.
My
It is
lord,
made
sir.
clear no further adjournment on the said date would be granted.
My lord, sir, I appear for.
GST. ಅದಕ್ಕೂ ಹೇಳಿದೆ same order. Yes.
My lord, sir, I
The
appear
law
for.
is clear. I don't understand what is this fragmented. Huh? So what? Take this also to the writ appeal.
Contract, 18% GST is paid already. They ask for differential duty. They do not produce the contract.
Now you have to produce the contract in every case.
Commission,
That
my
is the
lords.
allegation that you have not produced any contract in any of the cases.
My
Covered
lords.
on the order ತಗೊಂಡೋಗೋದಲ್ಲ.
My lords, I want to make a kind submission, my lords. It's not like we have not produced a contract. We have done the needful, my lords. As per the order of 9721 of 2019, my lords, Chandrasekhar has order. It clearly says that we have to get
We'll
a
see.
supplementary agreement.
Now this time we will not say covered ಅಂತ quote ಮಾಡೋದಲ್ಲ. I will pass a separate order. And don't make submissions that are made before the coordinate benches all over again, just because it is before a different bench. Yes. Restrict your submission to what do you want to say. ಮತ್ತೆ rehearing ಮಾಡಿದ್ರೆ I will impose costs and dismiss it. Allow it. Yes.
They ask for differential duty.
We'll see.
My lords, may I make a submission, my lords? I appear for
Yes.
respondent number 5. I already filed a writ appeal against my lord's order. I may be also heard in this rehearing.
Why did you file review ಆಗಿಲ್ವಾ ಈಗ?
I am not on a review petition, my lords. I filed a writ appeal that is pending.
Withdraw that writ appeal. We will be heard in this.
Yes, my lords. I'll do.
You can say the
Writ appeal is posted for 2nd September. Writ appeal is posted for 2nd September.
2nd September. Yes.
I'll do that.
Produce everything. Don't come up with this
My lords, we
allegation
have
saying
produced
that.
everything. My
No, my
lords,
lords, that-
970 clearly says.
What's your name?
pre-GST My lords,
What's your name?
Monisha Sen.
So and so is directed to place on record the contracts that are necessary to be necessary to be perused at the time of disposal of these petitions. Yes.
Writ petition copies.
Correct. Notice ಕೊಟ್ಟಿಲ್ಲ.
Notice. One copy of the
No notice was issued. No petition is there. They may have filed a writ appeal. They know everything.
I
They should
filed
give a notice.
applied through a certified copy, my lords.
No.
That's how I filed the writ appeal.
Yes. The respondent shall, the writ petitioner shall serve complete set of papers upon the review counsels appearing for the review petitioners.
Okay.
As also ನೀವು ಯಾವುದು respondent?
Respondent number 5. I appear.
As also to the respondent counsel representing respondent number 5.
MESCOM.
ಆಯ್ತು ಎಲ್ಲರಿಗೂ ಕೊಡಿ. Yes.
Grateful.
Oblige.
Obliged.
ಮೂರ್. Yes, sir.
In this matter, in serial number 6, Malaz, appear for the petitioner is a defendant, Malaz, in the suit. Malaz, there was an interim order passed, Malaz, on 27th May 24. Malaz, to see that order. In fact, it was based on consent of both the parties. Now, I understand, Malaz, my hands are tied. Malaz, to see the order, I'll explain. There is a direction, Malaz, that the petitioner shall be entitled to, of course, maintain status quo.
Which order, sir?
27/5/24.
Page.
Order sheet.
ಇಲ್ಲಿ order. Yes. A collection of rents.
Correct, my lords.
Ah,
Now
yes.
the rents are not, but of course I can't seek a direction against him because he's not my lessee. So
Oh,
the
who
rents
is
are
your
not
lessee?
being paid. That's why now we filed a.
Lessee is not a party.
Correct, they're not.
Then
They're not a party. I understand. That's why I said my hands are tied. If your lordship.
lessee is not a party before the civil court also?
No.
Then,
Lessees are not a party.
then how can this direction be implemented?
I understand, my son. ಇಲ್ಲ ಅವ್ರೇನ್ ಹೇಳ್ತಾರೆ earlier amounts
Why did you take this direction? Why did you
react
take this direction?
on consent I both sides consented to it. But the only thing is now I'm told
Lessee is
that the
neither a
lessees are
party
not,
before the civil court nor here.
if it had been a different
And a
matter, if
direction
he
is
was
given to collect the rent from the lessee.
Yesterday, the submission was
Hey,
made.
27 vacation matter, vacation bench.
ಇಲ್ಲ open ಆಗಿರುತ್ತೆ ಅಷ್ಟೇ. This year it was late. Last year I think we opened
24th.
24.
In good faith, if a joint submission can be made, let the matter be remanded back to trial court and a direction may be given expeditiously, matter can be disposed of.
ಅಲ್ಲಿ impleading application ಹಾಕಿ ಏನಾದ್ರು ಮಾಡಿ.
Also in good faith, I'll make the submission. It's not that the rents I'm taking and I'm consuming myself. There is a construction that is put up. There are 3 tenants. One is a bank, one is a NBFC, one is a government hostel. The entire rent that has been coming is being paid towards the loan, servicing of the loan for which the construction is put up. And ultimately, it's a dispute between the brothers. GPA, I am claiming title, they are claiming title. Whoever ultimately succeeds will have the benefit of the
It's a fair
property.
submission. We'll go back to the.
Will get let the matter be remanded. And I'll render my accounts also before the trial court. I'll undertake to do that.
ಯಾರು ಅವ್ರು collect ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲೇ application.
This order you can't get it implemented.
Because ultimately, if it's again
Is an
implemented,
order
etc.,
against
it'll
a
get further delayed. In fact, if a period of 6 months or something is fixed, altogether matter can be disposed of. And I will render my accounts before the trial court.
Suit of the year 2022. Suit for recovery of money?
ಇಲ್ಲ
No, it's a
cancellation
declaration.
of a gift deed.
Gift deed?
Please, a power of attorney, by virtue of a power of attorney, a sale deed was got executed by them, and I am
The
challenging.
suit is for what?
Declaration.
Declaration.
Please.
The petitioner is before this court. Petitioner is the defendant. Is before this court calling in question an order of the concerned court dated 5/7/2022, rejecting an application in IA 2 of 2022 in OS 13 of 2022 for payment deposit of rents in a suit filed for declaration and injunction. Heard the learned senior counsel Sri Vikram Holigold appearing for the petitioner and Sandeep representing the respondent.
Kindly, if may I request Mr. Vivekananda from Mangalore. In fact, yesterday we had made the submission that from the lawyer from Mangalore. I'm only there instructing.
Oh, from Mangalore.
He's
Yes.
appearing on VC.
All right, Sandeep Lahiri and Vivekananda.
May I-
I'm great.
GPA
Yes.
holders, Mr. Sir.
The facts in brief. The general power of attorney is executed by the respondent plaintiff concerning a property bearing property in survey number
27.
sorry 27 measuring 4 acres
4 cents.
4 cents and survey number so and so measuring 11 cents in so and so village alide madam. It transpires a settlement deed is executed on 7/1/2020 and later the petitioner executes a gift deed on 27/1/2021. The said gift deed comes to be challenged by the respondent plaintiff in OS in the subject OS seeking relief of declaration and injunction. The parties have filed their written statement and the trial had progressed. At that point in time, the plaintiff files an application before the an application is
It's an injunction application.
the petitioner files an application in OS 13 of 2022 under Order 39 Rule 1 and 2. The said application comes to be answered in favor of
Respondent.
in favor of the plaintiff, which is called in question by the present petitioner before the appellate court in MA 19 of 2022. That is pending, is it?
No, dismiss.
Against that we are before your honor.
ಏನು ಹೇಳೇ ಇಲ್ಲ ಅಲ್ಲಿ. Your synopsis stops at dismissing, sorry. which comes to be dismissed on 22/6/2023. It is this order that is called in question by the petitioners. The coordinate bench, while issuing notice on 27/5/2024, had passed the following order. The coordinate bench had directed the petitioner to collect the rent of the suit schedule property regarding the portion which has already been leased, while the lessee was not a party to the proceedings. As a matter of fact, lessee is not even a party to the suit. In that light, the order prima facie becomes unimplementable. In the light of the said situation, the parties to the less would would submit in unison that if a direction is issued to the concerned court to dispose the suit itself within a time frame, as the issue lies in a narrow compass therein with regard to the will that is executed in favor of the present petitioner, would suffice for the present. Therefore, without interfering with the impugned orders, should I say that or not?
Only thing will and ಹೇಳಿದ್ರಿ gift deed.
Gift deed, sorry, gift. Therefore, without interfering with the impugned orders, I deem it appropriate to direct the concerned court to dispose the suit itself with an outer limit of 6 months from the date of receipt of the copy of the order. All contentions that are urged in the subject petition are permitted to be urged before the concerned court at the relevant point.
Status quo may be continued.
Relevant point in time.
As per the order says status quo.
In the light of the interim order subsisting as granted on 27/5/2024, I deem it appropriate to continue the same till the disposal of the suit. Ordered accordingly.
Grateful.
Yes.
The rents, whatever is collected, rendition of accounts.
I will render the accounts before trial.
Adon Parahack.
Please.
The learned counsel for the respondent, the plaintiff submits that the rents are no doubt being collected by him, but it is used for the construction, for the servicing of the loan that is taken for construction of the property. Therefore, he would submit that he will place all the accounts before the concerned court at the appropriate stage. This submission is placed on record.
On instructions, if it.
On instructions, correct. On instructions, the learned counsel of the petitioner on instructions would submit.
Grateful.
Counsel for the defendant, Sandeep Lahiri, would submit on instructions.
Accounts of the plaintiff and the plaintiff is there.
Illi, respondent.
Great.
Number 7.
FPF. Madam. Interim order renewal. The subject petition was listed on 28/10/2024. The coordinate bench issued emergent notice to the respondents. PF has not been paid till date. It is FPF or PF till date. Therefore, as a last chance, list this matter on 10th September. In the event the needful is not done, the petition would be dismissed for its non-prosecution. Next, memo for withdrawal.
Seal number 8, 9, logical.
8 and 9, both in terms of memo.
Seal number 10.
Serial number 8, my lord, we have filed for withdrawal memo. There is an.
Which madam?
Serial number 8, my lord.
Yes.
We had filed withdrawal memo. Of
Ordered.
Yes.
Yes.
10.
I appear for the respondent in this matter.
Question for my lord's consideration is, my lord, whether the section 47.
Yes, sir.
Question of fraud also can be gone into, my lord, with regard to the decree. I'll just give you a lord's, my lord, two judgments, my lord, for my lord's consideration. In fact, on an earlier occasion, this honorable court, my lord, remanded the matter.
1 minute, sir.
Sorry. ಅದು ತಮ್ಮ ಹೌದು ನಿನ್ನೆ
Yes,
ಹೇಳಿದ್ರಿ
ಪರವಾಗಿಲ್ಲ ಹೇಳಿ sir. Yes.
ಪೇಜ್ ಮಲಾಡ್ 236 ತಾವು ಬಂದ್ರೆ
Yes.
This honorable court, my lord, remanded the matter for consideration, my lord, the entire, please come to, my lord, page 238.
Para 6.
Yes, ma'am. This honorable court held, my lord, that they'll have to consider, take into account, my lord, the objection statement. Now, 236 is better, 239 even, order.
Yes.
Last paragraph, 3. Order is remitted back to the executing court for reconsideration fresh matter, afresh. by taking into consideration the statement of objections filed by the petitioner and hear both the parties and pass appropriate orders.
Yes.
All rival contents are kept open. Now, my lord, we had, my lord, urged that, my lord, there has been a fraud. What has happened is during, my lord, they had to, my lord, supply, my lord, material. They, my lord, did not, my lord, supply material, and yet, my lord, got, my lord, started billing. So, my lord, we said, the whole thing is, my lord, there is a fraud. Question, my lord, for my lord's considerations in the execution case, my lord, whether a fraud, my lord, can be set up under section 47. Just give your lordship, my lord, one judgment. List of dates ಕೊಟ್ಟಿದ್ದೇನೆ ಎಲ್ಲೋ ಗೊತ್ತಿಲ್ಲ ನೋಡಿ.
ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಇಲ್ಲ ಇಲ್ಲ. Yes, sir.
Lord, please come to, sorry.
Yes, sir.
List alli, my lord, I have set out, my lord, whatever I have said. There have been, my lord, if your lord
Now the only issue is whether fraud can be
Lord,
urged and considered in execution proceedings.
Correct. Can I, my lord, request your lordship look
I'll
at
get back.
page 99 alli?
You're ready, right?
Very well, my lord.
Then wait. I'll get back. Yes, sir.
Page 99. Sorry, 60 alli bani. 60.
Yes.
Paragraph 52 to 55 of this. At, my lord, running page 84 onwards.
Yes.
Fraudulent, my lord, fraud can be set up in collateral proceedings. My lord, this is a well accepted principle of law. Adu ondu. Eradnedu, please come to page 99. I'll not trouble your lordship, my lord, the other. Page 99. At, my lord, paragraph 24 at running page 105. We have made our observation in the context of section 47. Sorry.
Page number?
105, my lord.
Paragraph?
24.
24, yes.
We have made our observation in the context of section 47 of the civil CPC, which even at the stage of execution permits the party to object to the decree, both on the grounds of fraud as well as lack of subject matter of jurisdiction. It is apparent that the arbitration proceedings were a mere sham and a fraud played upon the respondent number 1 Pandey by self-appointing and nominating the arbitration who have passed ex parte invalid orders to reiterate respondent number 1 R.K. Pandey, who is not a signatory to the purport so on so on. This is all, my lord. Question is, my lord, the trial court, my lord, does not go into it. That's all that I am saying. It should have gone into it.
Now, what is the issue before the trial court? Tell me.
Please come to, my lord, the impugned order. At, my lord, running page 241.
So what was the issue taken before the
But that
civil
the billing, my
court?
lord, what had happened was he went, my lord, before the MSME.
Oh, this is that medical corporation. Yes. Medical supplies corporation.
Correct. MSME munde hodru. MSME, my lord, said, my lord, this, my lord, without going into the merits, my lord, I mean, the evidence, they said, my lord, this is liable to be paid. Against that, my lord, we said this decree, my lord, is a nullity because the evidence has not been looked into. My lord, we have placed, my lord, all those materials before the trial court executing court. That has not gone into it. This is the only question. This honorable court, while remanding, said, you must consider all that. That is not considered it, my lord, page 2.
When the matter was remitted by the coordinate bench, what was the stage?
Same.
Execution itself?
Execution.
Execution alle. I wouldn't have dared to come before your lordship.
Now, what is the impugned order?
Impugned order is page 241.
241.
At, my lord, running page 257 ಗೆ ಬರುತ್ತೆ. 257 ಅಲ್ಲಿಂದ ಶುರುವಾಗುತ್ತೆ. Non-delivery, my lord, paragraph 3 at page 259 ಬಂದ್ರೆ, what is it that, my lord, we had stated? Non-delivery of goods, defective return goods, GST amount not paid, lab testing amount, price charged higher than the accepted tender prices.
Yes.
While submitting the oral arguments, so on, my lord, we have said all that. Then, my lord, the learned judge, my lord, holds, he can't go behind the decree.
Correct.
That your lords get, my lord, at running page 262. Para 9Q, question anta baratte.
Yes.
This is all, my lord. All that I have to do, my lord, that I request your lords to see, my submission is, matter has to be remanded, let them consider it. Anything in such an argument,
that's quite,
I'll be wasting your lords.
Quite amount of consideration here.
Yes. Please,
whether that is adequate or not, we'll have to see. In terms of the order of remand by the coordinate bench, it's not that it is a perfunctory order.
Lord, can I persuade your lordship? Just look at it again.
No, but the court says it cannot go beyond the decree. All your submissions are noted.
My lord, fraud. Why? Because, my lord, it says that, my lord, the fraud, my lord, section, that's why I gave you.
So it can be urged in any proceeding, it would cut at the
In
root of the
execution,
matter.
execution itself.
That's
all, my lord. That's the only.
That's,
In there, I'll keep on arguing the same thing.
yes, yes, sir.
The relief is not anything to do with regard to the order passed by the executing court. Lords,
Now.
My lords?
Now.
Yes, my lords, in this present writ petition. My lords, the relief in this present writ petition is, my lords, to set aside the entire execution proceedings before the executing court. My lords, an arbitral award is passed. It's not challenged under 34. They participate in the arbitration proceedings. It's not challenged under 34. Award becomes final, my lords. Pursuant to the award becoming final, we file the execution proceedings. In the execution proceedings, initially they come and deposit a sum of rupees 65 lakhs. After depositing the sum of 65 lakhs, they file objections. Lords would look at their objections. Nowhere the contention of fraud was taken up there. The only thing, when they came before this honorable court and filed an identical writ petition with the same reliefs. This court, my lords, only said that since the objections were not taken into account while passing an order of attachment of movables, this court is directed to pass the attachment of movables. My lords, the contentions taken up before the court below are all saying that supplies were not affected properly, these things. My lords, this is the 2020 supplies, my lords, based on a purchase order during the COVID period of time, emergency supplies. All these supplies were affected, invoices were raised, they had not made payment. Therefore, my lords, the relief before your lordships today is nothing to do with the order passed by the executing court. Lords, question is, can they set up a proceedings under 34 by virtue of an proceedings under Article 226? Literally asking for setting aside the arbitral award, indirectly saying that set aside the execution proceedings. Now, my lords, on the simple question as to whether Section 47 can be filed, an application under Section 47 can be filed in an execution proceedings, insofar as an arbitral award, which an arbitral award is not a decree, can be gone into by the executing court. My lords, there are several judgments, my lords, which say that the
Thank you.
Yes.
Lords, I take your lordships to the judgment in
Anglo-American?
Your lordships, the judgment in Paramjit Singh Pateja, I'll take your lordships to my lords, this is judgment number 6, which is at page number
109.
Lords, page number 83, my lords.
But if it is the allegation of fraud,
yes,
it would unravel everything.
Well, the allegation of fraud in an execution proceedings, insofar as a judgment and decree is concerned, my lords, can be gone into under 47. But in an arbitration proceedings, the enforcement proceedings, the award is not construed as a decree. So therefore, Section 47 cannot be applied in those proceedings. The court holds that if Section 47 is applicable to an arbitral award, it will defeat the entire proceedings. However, my lords, there is no allegation of fraud. In the statement of objections filed by them when the matter came before this court for the first time, the statement of objections was on record. There was no allegation of fraud in that statement of objections. It's at page number 291 of the writ petition. After the matter was remanded back, the executing court considered the matter. They filed additional objections. Even in that, the question of fraud was not taken. But lords, fraud insofar as making of the arbitral award. There is no allegation with regard to fraud in making of the arbitral award. They only say that the executing court, they only say that the arbitral award, the arbitrator has not considered certain things. Well, that
can't be fraud.
Yeah, that can't be fraud, my lords. That's their only contention, that these aspects have not been gone into by the arbitrator. Therefore, my lords, there is no specific pleadings. My lords, order 6 requires a certain amount of pleadings in regard to fraud. There is no such pleading in regard to fraud. Therefore, in view of these judgments, my lords, that it's not a decree and 47 can't be applied in enforcement of an arbitral proceedings, that's the interim order.
Three arguments. One, please look at Section 36 of the Arbitration Act. It's a decree. Any award passed, my lord, is a decree. Please permit me to read it aloud, my lord. where the time for making an application such as the arbitral award in section 34 is expired, then subject to the provisions of section 2, such award shall be enforced in accordance with the provisions of civil procedure in the same manner as if it were a decree of the court. So, my lord, it can't be said that, my lord, this is not a decree. If it is not a decree, my lord, then there can't be an execution under order 21. Second, please come to, my lord, page 261. This honorable court specifically directed him to look into the objections. Please see what he says. I have not looked into the objections. Please come to paragraph 6. No doubt it is true that this court has not passed any considered order on the objections filed by the JDR before issuing the attachment warrant to movables. JDR has, my lord, given these judgments. Then, my lord, paragraph 262, page 262.
Yes.
He says, my lord, I can't go into it. Therefore, my lord, I will not even consider your objections.
My lords, one submission, my lords. If this order has not been challenged in this writ petition, this order has not been challenged. If this order were to be challenged, my lords, it will be a commercial appeal and not a writ petition. A writ petition will not lie.
Please come to page, my lord, 34 of my prayer. What I have SLD is annexure, yes.
Yes, that
Page
order that is
241.
passed will consider.
That's all, my lord.
Yes, heard
Page
reserved.
20, your lordships.
Yes.
He'll pass an order.
Appearance for the first respondent, my lordship.
I appear on behalf of the appellant.
Balakrishna Shastri.
From me?
Balakrishna Shastri.
I represent him.
Yes, sir.
ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಹೋಗಿತ್ತು
Stay ಆಗಿದೆಯಲ್ಲ?
ಫೆಬ್ರವರಿನಲ್ಲಿ
ಸ್ಟೇ ಇದೆ.
ಸ್ಟೇ ಇದೆ.
ಅನ್ಕ್ಲೈಮ್ಡ್.
ಅನ್ಕ್ಲೈಮ್ಡ್. ಅದು ಆ 2-3
R2 ನ
R2 and 3 ಅನ್ಕ್ಲೈಮ್ಡ್ ಅಂತ ಹೇಳ್ತಾರೆ. ನಾನು ಇನ್ಸಿಡೆಂಟಲಿ ಐ ರೆಪ್ರೆಸೆಂಟ್ ದೆಮ್ ಇನ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
Then you know
ಐ
that
ರೆಪ್ರೆಸೆಂಟ್ ದೆಮ್.
you will take notice.
ನನಗೆ ಅವರು ಹೇಳಿಲ್ಲ. ಈಗ ಇದು ನೋಡಿದ್ಮೇಲೆ ನನಗೆ ಗೊತ್ತಾಯ್ತು.
ಈಗ ಏನ್ ಮಾಡೋಣ ಹೇಳಿ.
ಈಗ ಇದೇನು ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
ಅದು
fresh steps should be taken for all the
unclaimed ಅಂದ್ಮೇಲೆ we will show them as served. ಅವಾಗ ನಿಮಗೆ they will come to you. Yes.
ಅಲ್ಲ ಈಗ allow me to file the wakalat.
The learned
counsel 2 and 3.
Learned counsel so and so submits that he represents the unserved respondents before the trial court.
Yes.
And therefore seeks a week's time to secure instructions on filing of wakalat to both the respondents 2 and 3. List the matter on 10th September.
ಒಬ್ಬರಿಗೆ ಒಂದು the plaintiff who is the first respondent ಅವರು ಇದನ್ನ ಡಿಲೇ ಮಾಡ್ತಿದ್ದಾರೆ. ಬಟ್
the caveat is already counsel is already there.
Appearing for the first respondent, my lordship.
He is there. Yes. List the matter on 10th September.
ಆಗ್ಬೋದು.
Yes, interim order subsisting would continue till the next date of hearing.
Yes.
Next. Affidavit.
My lords has heard this matter.
Oh,
I asked the petitioner.
Yes. Yes, sir.
What has happened, my lord, in the earlier writ petitions, my lord, the petition has given instructions to the council to withdraw the writ petition based on the endorsement issued by the BDA. But they have not done so, my lord. That's only made a mistake. Now I am granting liberty to approach the
ಚಾಲೆಂಜ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ ಅಷ್ಟೇ. ಅದು ನಾನು ಲಿಬರ್ಟಿ ಕೊಡಲ್ಲ.
No, I'm filing
Fail of
memo.
remedy.
Yes,
ಏನ್ ಮೆಮೊ?
I'm filing memo to withdraw the writ petition for challenging the writ.
For challenging, I cannot give liberty to challenge the order, sir.
And also, my lord, I am intends to file a civil suit for injunction.
Whatever you want, all remedies available in law. The learned counsel for the petitioner, after arguing the matter at length, would seek leave of this court to withdraw the petition and avail of such remedy as is available in law. Advan beda available in law. In the light of the said submission, the petition stands disposed without interfering with the impugned action. The action challenge ಮಾಡಿದ್ದಾರೆ ಏನ್ರು?
Earlier stay was granted
without granting the prayer that is sought, leaving open to the petitioner to avail of such remedy as is available in law in accordance with law. Ordered accordingly.
Possession may be protected.
No. Yes. ಯಾವ ಪ್ರೊಟೆಕ್ಷನ್ ಇಲ್ಲಿ ಬರಿಬೇಕು. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆನ್ಸರ್ ಮಾಡಿದ್ರೆ ಎಲ್ಲ ಹೋಗ್ಬಿಡುತ್ತೆ. Yes.
Good.
13.
ಈಗ ಈ ಕಡೆ. Yes.
Made an application to relax the condition while granting an interim order.
What condition is granted?
Permitted to file my objection to that. Interim order granted subject to deposit of 20 lakhs 10 lakhs which I have already deposited. My lords, for another 10 lakhs, I sought for election. The reason is this, my lords.
Your judgment letter?
No, my lords. What had happened was that the divorce petition was filed.
You are the husband?
Husband.
Yes.
My lords, can I have it? I have already complied the order. That is the reason why I have sought for relaxation. My lords.
Your husband can't be relaxed. Yes.
My lords, kindly see. 25 lakhshake, there was a consent award. Consent judgment. And pursuant to that, my lords, execution is filed for 25 lakhs. Out of which, my lords, I have already deposited 16 lakhs, my lords, which is part of record in the writ petition.
All right. An objection in the code.
My lords, 16. And another 10 lakhs rupees, my lords has granted an interim order subject to deposit of 20 lakhs.
20
for
lakhs.
which 10 lakhs I have already deposited.
All right.
Yes. My lords, the challenge is rejection of my application to recall the arrest warrant.
The total?
Total, my lords, 25 lakhs.
Where do I get that?
My lords, 25 lakhs, the decree, my lords, would get it at page number 74. Yes. Then, my lords, execution prayer sought, my lords would find it at page number 76 at last line. 25 lakhs is the execution petition filed. My lords, I have paid 16 lakhs, my lords, through the bank account of the wife. My lords would find it at page number.
Has to pay 25 lakhs to the petitioner as permanent alimony.
Correct.
Date yenidu? Order date. What is the date of the order, sir?
My lords, impugned order, rejection my application.
Impugned order alla. Idu 24th July 2023.
All
right. Adu execution hakadra?
Execution hakidru.
Right.
Bank statement produce madidane, that my lords will find it at page number 133. It comes in total amount of rupees 16 lakhs 19,000. My lords, arrest warrant was issued in execution. I made an application to recall it. That application is rejected, hence I am before this court. This court will grant an interim order, ask me to deposit 20 lakhs. That is 10 lakhs on or before May 31st.
All right, when do you deposit the remainings? Total 25 lakhs bandidya?
Iga 16 lakhs already I have.
Yes, sir.
Yes, my lord. My lords, if I may just direct your lordships, he's taking contradictory stands.
Don't worry about it. Est barbek heli.
No, my lord. 25 lakhs is completely due according to.
Completely due.
Yes, my lord. 10 lakhs ಈಗ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ ಉಳಿದ 15 lakhs due.
15 lakhs ಉಳಿದದ್ ಬರ್ಬೇಕು.
Yes, my lord. My lord.
ಮತ್ತೆ ಅದು ಯಾವುದು 16 ಲಕ್ಷ ಮಾಡಿದ್ದೇನೆ ಅಂತ ಹೇಳಿ.
What has happened? Memorandum of understanding, that is the basis on which the decree is passed. If your lordships may kindly.
Where is the MOU?
It is at annexure page number 48, my lord. Annexure B.
48.
Page number 48 of the writ petition.
Yes.
My lords, their next page 49, my lord, that is this condition 2, page number 49. If your lordship may, that the second party will pay a sum
which clause?
Second, my lord, second.
The second party will pay a sum of 25 lakhs.
To the first party in form of fixed deposits towards final settlement to the first party and children, and also monthly expenses and educational and medical expenses for next 3 years.
Yes.
My lord, this is one thing. Now, my lord, what happened when this consent decree was passed? This 25 lakhs was not recorded, because of which she filed an application for correction. My lord, in that he files an objection. That is very crucial, my lord. Now that objection, my lord, can be found at page number 65. Page number 65. Ali, next page 66, Ali, my lord. Para number 8. If I may just read it. The second respondent petitioner submits that the above application filed by the petitioner with malified intention of harassing and humiliating the respondent by suppressing true and material facts. In fact, before passing of the judgment and decree in MC number 68 of 2018, there was an oral discussion and deliberation between the petitioner and respondent with regard to payment of past, present and future maintenance to the first petitioner and her children. That the respondent has already paid maintenance amount to the petitioner and also children in cash and kind as agreed between them before passing of decree and judgment dated 29/11/2018. Whereas the respondent has been paying maintenance amount now and soon after the decree, whereas the respondent has neglected and refused to look after the maintenance of his spouse as per oral assurance. There are two things, my lord. According to him, this 25 lakhs is already paid in cash.
at the time before the consent.
Anyway, that was not accepted and the decree is modified.
What is paying later on is the maintenance amount. My lord, this fact has been already, he challenged it before this high court, my lord.
Page?
My lord, I have filed a memo for production of additional document 1. My lords, may kindly come to
Yes,
page
sir.
number 6, my
All
lord.
right.
Page number 7.
ಯಾವಾಗ ಇನ್ನ 15 ಲಕ್ಷ ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
15 ಲಕ್ಷ ಇಲ್ಲ.
ತೊಂದ್ರೆ ಇಲ್ಲ. Then order pass will pass on merits.
My
No
lords,
problem.
Kindly see, my lord.
Yes, sir.
The decree is for 25 lakhs. Kindly see. Page
Decree
number
is for
7.
25 lakhs.
Yes.
That 25 lakhs was not inserted in the
Correct.
order that is now inserted. The
So he
order,
files an execution.
the order has become final.
Final. I am admitting that.
No problem.
Now
You got
for
10
the
lakhs
20
you have deposited pursuant to the interim order.
And another 16 lakhs which is already deposited in the bank.
Where?
Yes, that is the.
By
part of-
fixed deposits.
Allah, we have already
Yeah,
paid.
why did you deposit in the bank?
Oh, the account number.
Why?
My lords, anyway, the amount is.
No, why did you deposit in the bank? And why, when did you deposit in the bank?
My lords, kindly see page number 98.
When did you deposit in the bank?
Yes, yes. My lords, page number 98, I have furnished the statement of accounts.
Simple, on the date ಕೊಡಿ ಯಾವ deposit ಮಾಡಿ.
More dates ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. Statement of
ಸುಮಾರು ಡೇಟ್ಸ್ ಅಲ್ಲ. ಎಷ್ಟು ಎಲ್ಲಿಂದ ಎಲ್ಲಿವರೆಗೆ ಹೇಳಿ?
My lords.
Between
page 99 ಇಂದ 98 ಇಂದ my lords who find it at ಇದು ಇಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೆ.
98 ಇಂದನ.
ಹೌದು. page number 98 ರಿಂದ.
That is towards expenses for the children.
Please.
Not alimony money ಅಲ್ಲ ಅದು.
But expenses towards the children is not a part of a decree.
No. Expenses towards children part of the MOU. MOU is inserted into the decree now.
ಇಲ್ಲ.
ಇಲ್ಲ ಯಾಕೆ why? What do you mean ಇಲ್ಲ? Come to page 74.
Page number 74.
Yes. The decree 29 passed by court amended to the effect of inserting the agreement between the petitioner and the respondent.
Yes, kindly see the order. Kindly see page number 74.
To pay, the petitioner has to pay 25 lakhs is permanent alimony.
ಹೌದು. ಮುಂಚೆ kindly see ಮುಂಚೆದ order.
ಮುಂಚೆದೆಲ್ಲ ಏನಿಲ್ಲ ಇಲ್ಲಿ.
Judgment and decree my lords will find it page number 57.
ಈಗ plain and simple ಯಾವಾಗ ಪೇ ಮಾಡ್ತೀರಿ 15 ಅಂತ ಅಷ್ಟೇ.
My lords, if they want to act upon the MOU, then other conditions also has to be fulfilled.
What
by
other
the wife.
condition?
Kindly see the MOU.
First you fulfill your conditions, sir.
My lords, memorandum of understanding says that he has to hand over the custody of the child to me. Page number kindly
That
see.
is on paying permanent alimony.
Page number 49 kindly be
First
seen.
pay the money, then the wife will act.
My lords, thereafter what they happened was that they are also claimed maintenance. They have filed a
That's a
petition claiming
separate
maintenance.
thing. That's a separate.
For this same cause of action, they filed a maintenance
Alimony
also.
is separate, maintenance is separate.
For children, maintenance of the children.
Correct, ಅದು ಕೊಡ್ಲೇಬೇಕಲ್ಲ.
Based on this, they filed a separate petition.
No problem.
That is also dismissed.
No problem.
My lords, execution can be only part of the decree. Decree says 25 lakhs. Execution petition also says 25 lakhs.
Correct.
I paid 16 lakhs and odd plus 10,000.
Where and how, for what purpose?
What purpose, my lords?
What purpose, on what account alimony ಕೊಟ್ರ, maintenance ಕೊಟ್ರ, ಏನಕ್ಕೆ ಕೊಟ್ರಿ?
My lords, we used to pay. That's all I can. My lords, now I am before this court is this, my lords. I'm sorry.
Arrest
I
warrant.
made an application for recalling the arrest warrant. That application is rejected. Let the executive court determine the whole thing. Let
No,
the,
I will not consider, I will not interfere with the order. ಈಗ 10 lakhs ಕೊಟ್ಟಿದ್ದೀರಾ, ಅದು ಇನ್ನ 10 lakhs 2 weeks ಅಲ್ಲಿ ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ದ?
My lords, 10 lakhs 31 May ಒಳಗಡೆ ಕೊಡ್ಬೇಕು. That I have complied it.
31 May
ಅದು
ಒಳಗೆ.
ಮಾಡಿದ್ದೀನಿ.
ಇನ್ನ ಮಿಕ್ಕಿದ್ದು 6 weeks ಎಲ್ಲಿವರೆಗೆ ಬರ್ತದೆ?
ಅದಾಗ್ಬಿಟ್ಟಿದೆ ಮೇಲೆ.
ಅದು
July
ಆಗಿದೆ
end ವರೆಗೆ
ಗೊತ್ತು.
ಬರ್ತದೆ.
31/5 ಇಂದ 6 weeks.
ಹೌದು.
ಅದು ಬಾಳ್ ಸಮಯ ಆಯ್ತು ಆಗಿ.
ಇಷ್ಟೇ ಇರುತ್ತೆ ಕೇಸ್
ಅಷ್ಟೇ.
ಇರೋದು ಎಷ್ಟು.
ಅಷ್ಟೇ.
My lords, kindly.
ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಅಂತ ವಿಲ್ ಡಿಸ್ಮಿಸ್ ಇಟ್. ಇಲ್ಲ ಇನ್ನು 15 ಲಕ್ಷ ಕೊಟ್ಬಿಡಿ, ಎಲ್ಲ ಇಲ್ಲೇ ಕ್ಲೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ.
15 ಲಕ್ಷ ರೂಪಾಯಿ ಕೇಳಬೇಕು.
ಈಗ 10 ಅಂತೂ ಕೊಡ್ಬೇಕಾ?
10 ಕೊಡ್ಲೇಬೇಕು.
ಕೊಡ್ಲೇಬೇಕಾ? ಇನ್ನ 5 ಕೊಟ್ಬಿಡಿ.
ಆಲ್ರೆಡಿ ಪೇಮೆಂಟ್ ಮಾಡಿದೆ.
ಏನ್ ಪರವಾಗಿಲ್ಲ. ಯು ಆರ್ ಪೇಯಿಂಗ್ ಇಟ್ ಟು ಯಾರ್ ಚಿಲ್ಡ್ರನ್.
ಚಿಲ್ಡ್ರನ್ ಅಲ್ಲ, ಹೆಂಡತಿ ಕೊಟ್ಟದ್ದು.
ಅದು ಕೊಡೋದಿಲ್ವಾ?
Kindly see.
Yes.
16 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾನೆ. Kindly see the statement of accounts. Wife account we have remitted the money.
ಪರವಾಗಿಲ್ಲ. Yes. Anything?
I don't have job, my lords. I am the aged about.
Your age what? 55 years.
Please, my lords.
Now don't tell me you're old. We are all of same age. Indirect ಆಗಿ ನಮಗೆ ಹೇಳ್ದಂಗ.
In fact, in his
My lords,
lighter note, my
next
lord.
date, if I don't comply, my lords may dismiss.
The learned counsel appearing for the petitioner seeks a week's time to comply with the order passed by the coordinate bench on 6/8/20, on 24/6/2025. List the matter on 3rd September as a last chance.
IA, my lord, for release of funds, 10 lakhs.
10 lakhs ತಗೊಳ್ಳಿ ಬಿಡಿ ಅವರು.
Our ಅಲ್ಲಿ collect total
The
deposit.
counsel for the petitioner, counsel for the respondent wife files an application.
Application.
Files an application seeking withdrawal of the amount of deposit, i.e. 10 lakhs in terms of the order passed by this court, a date on that. The application stands allowed. The wife is permitted to withdraw the 10 lakhs that is in deposit before the concerned court. The concerned court shall transmit the amount into the account of the respondent after due verification without broking any delay. Yes.
Great.
Interim order we extend.
Subject to the aforesaid interim order stands extended till the next date of hearing.
14.
14, my lord. See,
ಏನಿದೆ?
amendment sought in this application is, my lord, see, we are consider comply the order, in earlier order, and issued the endorsement. Now, issued the endorsement in amendment application.
Application in IA 2 of 2025 shall be considered along with the main matter. Lest the matter on 9th September, interim order subsisting would continue to the next date of hearing.
Amendment application not served to the state, my lord.
Petitioner to serve the amendment application upon the counsel for the respondent, if not already served. Next. R7 and R8.
15, my lord, see.
2 weeks to do the needful. Next.
Preliminary hearing, 16.
My lords, in number 16, I beg to appear for the petitioners in this matter.
This the matter on 28th, interim order subsisting will continue to the next date. Yes, next.
17.
My lord, in 17, my lord, I appear. I have filed an IA for stay, my lord, of auction. Despite an interim order dated 8/11/24, auction is proceeding, my lord. Some brief background. I was allotted 5 acres of land.
ASG sir. ಅದು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಬೇಕಾಗಿತ್ತು. ಅದು ಆರ್ಡರ್ ಪಾಸ್ ಕಂಪೌಂಡಿಂಗ್. Till number 16.
It was already heard.
It was already heard. I have to pass the order ಅಷ್ಟೇ. 28th ಅಲ್ಲಿ pass.
Ideally, it should have come under dictation of order.
ಅದೇ that's what preliminary hearing ಬಂದ್ಬಿಟ್ಟಿದೆ. ಅದಕ್ಕೆ on 28th. Yes.
Obliged, my lords.
Yes, 17.
I am for the petitioner, your lordship. I seek some time, your
My
lordship.
lord, Mr. Naganand is online.
Seniors held up in.
My lord, may I just make this submission? This matter had come up earlier also. What they have filed an application. He's online.
17 for the
Senior
petitioner.
counsel.
May I make my submission?
Online, my lord.
Yes.
Unless your lordships are taking at 2:30, I'll come there, my lord. Sorry.
Yes, come.
My lord, may I just make this submission? I'm there at 2:30. They have filed an application for staying the auction, my lord, which has started yesterday. We have, my lord, filed our objection, making a categoric submission. Their claim, though we dispute, their claim is with regard to 5 acres. The extent of land is 10 acres.
So remaining 5 acres.
We have set aside 5 acres. We are not touching that 5 acres. Only with regard to 1 acre. If your lordship sees our objection for a moment,
I
we have given a map also.
2:30 will pass.
Even allowing other side to open their mouth. I'm sorry to say this.
Senior not available.
Let me make my
lordship, so
submission.
taken up on another date.
Senior won't be available. He is saying he is coming at 2:30.
No, that's some other matter I think she's referring to, not mine.
Yes.
List to serial number 17.
I am there only, madam. That's with regard to that only. Yes. Pass over. You don't know which senior is engaged?
Lordship, Vivek Subbareddy sir is supposed to appear for this.
Madam, that is serial number 14.
Oh.
Where's your cause list? Where's the file? Which is the writ petition number? 1018088. That's serial number 14. I have dismissed it. Yes. Next.
18.
Petitioner, we are filing the memo to withdraw the petition.
Learned counsel of the petitioner files a memo seeking to withdraw the petition. Withdrawn in terms of a memo. Yes. ಎರಡಿದೆಯಾ? ಎರಡು both.
ಎರಡು
Yes.
ಕೊಟ್ಟಿದ್ದೀನಿ.
Right, yes, Patil.
This is plaintiff's petition.
Hmm.
Plaint schedule and defendant schedule properties are both are different. Measurement is also different.
What is under 39 1 and 2?
Yes, please. Both applications were plaintiff's application and defendant application have been rejected by the trial court in a common order.
Appeal ಹಾಕಿ.
ಅಲ್ಲ ಹಾಕಿದೀವಿ.
Appeal ಏನಾಯ್ತು?
ಎರಡು appeal ಕೂಡ ರಿಜೆಕ್ಟ್ ಆಯ್ತು.
Concurrent.
Concurrent.
ಸರಿ, again.
But ಒಂದ್ ಏನಂತಂದ್ರೆ they have filed writ petition WP number milord.
Number ಕೊಡಿ.
4943 of 25.
Tag this petition along with
This petition.
number ಕೊಡಿ. Tag this petition.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ
This petition ಗೊತ್ತಿ. Tag with ಯಾವ್ದಂದ್ರೆ this petition ಕೊಡಿ.
WP 4943 of 25.
List them both on 28th.
Very well. ಅದರಲ್ಲಿ ಸ್ಟೇಟಸ್ ಕೋ interim order is granted.
Already granted.
Granted.
In the learned counsel.
That petition.
The learned counsel submits that the subject petition is arising out of a common order that is subject matter of challenge in writ petition 4943 of 2025. The learned counsel would further submit that there is an interim order operating in the said petition. In that light, there shall be an interim order as is obtaining in the companion petition, the subject petition as well. List the matter on 17th September.
Please.
Notice ಯಾರಿಗೆ ಅದು? ಅದರಲ್ಲಿ ಯಾರು ಹೇಳಿ?
ಚಂದ್ರಕುಮಾರ್.
ಚಂದ್ರಕುಮಾರ.
ಆರ್ ಚಂದ್ರಕುಮಾರ್ ಅಂತ ಹೇಳಿ.
Sorry. Learned counsel submits the petitioner in the companion petition is R. Chandrakumar, who is the respondent here. Therefore, R. Chandrakumar is directed to accept notice. Next.
Please.
20.
Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
ಇಲ್ವಾ?
In fact, the last occasion it was listed that submission made by us. The two suits for injunction.
What is under challenge?
The concurrent orders passed by the trial court as well as the appellate court.
39 1 and 2.
Please. Lord, the appellate court has gone to the extent of making an observation that the defendants are not at all encroached the land.
We will expunge all those observations and direct these, argue everything.
My grievance is pre-trial opinion on merits is.
All right.
Please.
Those opinions of pre-trial will be expunged. Anything else?
Lord, both the matters are clubbed together and an order of status quo maintained with a time frame disposal. Lord, status quo
Suit for
injunction, both.
suit of the year
24. And ours is 25. Lord, there
Why
is
I
an
am
allegation of encroachment by the defendants. Lord, the other side has filed a suit for, say, the respondent filed suit for injunction in respect of 2 acres of land, stating that there is a podi of the land from the original survey number 61, 134/2. In the said suit, we have taken a specific defense that to an extent of 1.5 acre of land, he is trying to encroach in
ಇಲ್ಲಿ suit argue ಮಾಡಬೇಡಿ.
Please.
ಈಗ ಅವ್ರು ಏನೇನ್ whatever pre-trial opinion has emerged in the appellate proceedings, we will expunge all that. Let the court consider it. 24 suit ke time frame ಕಷ್ಟ. As expeditiously as possible ಅಷ್ಟೇ. You have suffered at both the courts.
Please. But the thing is, both the, the.
ಈಗ status quo ಇದೆಯಾ ಇಲ್ಲಿ?
ಇಲ್ಲ. But status quo. In fact, on an earlier occasion, while entertaining both the appeals, my lord, the appellate court has passed the status quo order that was challenged by the respondent in the writ petition before this honorable court.
Which is earlier writ petition.
ಹೌದು.
ಅದೇನಾಯ್ತು?
Then this honorable court has directed the appellate court to dispose within 6 weeks.
ಅದು dispose ಆಗಿರೋದು ಈ order. That is Justice
court
Kamal
has-
our order.
ಹೌದು. Then the appellate court has passed the order in this.
ಅಷ್ಟೇ.
Yes. And the property
ಅಷ್ಟೇ
is
will
required to
direct whatever is there without being influenced by the observations made in the appellate by the appellate court. The concerned court will consider the suit
The thing is,
as expeditiously as possible.
now they have taken police protection based on the earlier interim injunction obtained in their suit. Now they are, transgressing it.
Obviously, they have injunction in their suit. Injunction is affirmed in the appeal.
Please.
Police protection will ensue, follow.
The thing is, my lord, now they are, constructing a compound in our area. 4 acres belong to us, which was originally
ಆಯ್ತು
granted.
ಆಮೇಲೆ ಡೆಮಾಲಿಷ್ ಮಾಡ್ತಾರೆ. Suit, subject to suit ಎಲ್ಲ.
At least status quo may be maintained. Lord, the preservation of
Status quo cannot be granted, my lord. Why? Because the boundaries, what their very own document, please, my lord, is giving different boundaries and different times, my lord, before the court, before their own sale deeds and documents, please, my lord, is giving different.
That will be decided in the suits.
My lord, both the courts.
I'll take your lordship to.
Trial court has, come to the conclusion that the controversies has to be decided in the trial. Then, my lord, the attempt made by.
Controversies have to be decided only in a trial.
And my lord, the
Adverse has
protection
been
has
fixed,
to
my
be
lord,
accorded.
in respect of the
Interim protection ಯಾರಿಗೆ sir?
At least.
Plaintiff ಯಾರು?
My lord, what the.
Plaintiff ಯಾರು?
Both of us are plaintiffs.
Oh,
We
in
are-
separate
we are-
suits.
Yes.
In
And
fact,
the
please, my lord,
superimposition of the
immediately
area is
after
in
me obtaining an order of police protection, he files a suit. He does not challenges it. And moreover, please, my lord, Hudbust, my lord, in respect of the petty respondent's property is concerned, has been fixed twice. My lord, on all these 3 occasions also, please, my lord, the Hudbust, please, my lord,
No
there is
problem.
no encroachment.
All observations in by the appellate court will stand expunged. Suit will be decided expeditiously. ಅಷ್ಟೇ ಜಾಸ್ತಿ ಏನು ಕೊಡಕ್ಕೆ.
Status quo is to be, because both are open lands and now they are taking the.
What, you did not file an application 39-192 in your suit? ಅದೇನಾಯ್ತು?
No. In their suit, I have challenged by virtue of an appeal.
ನಿಮ್ದು obviously ಹೋಗಿ.
ಅಲ್ಲಿ ನಂತರ ನಾವು suit file ಮಾಡೋದು to protect our area 4 acres.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು?
ಅಲ್ಲಿ ನಮ್ಗೆ ಏನು in view of the earlier
Oh, ಇದು
allowing
ಹೋಯ್ತು.
of the appeal.
So concurrent all through. Okay.
So far as status quo is maintained.
All will be subject to the suit, subject to further orders in this suit.
At least here onwards, let them.
ಏನು ಕಾಂಪೌಂಡ್ ಹಂಗೆ ಇರ್ಲಿ ಅಂತ. ಏನ್ ಕಟ್ತಾ ಇದೀರಿ?
ಅಲ್ಲ ನಾನು
Stone walls
ವ್ಯವಸಾಯ
ಹಾಕ್ತಾ
ಮಾಡ್ತಾ
ಇದ್ದಾರೆ.
ಇದ್ದೀನಿ.
Stone
Stone
walls
wall, my lord,
ಹಾಕ್ತಾ
it is existing.
No.
It is existing.
Only after.
Stone pillars are
taking the
existing.
protection by the trial court in their suit. Lord, the attempt made by them
No, sir.
makes us to file the suit in so far as our land is
All
concerned.
subject to the suit. All reliefs will be there. I will not interfere on concurrent findings unless it is glaringly illegal.
It is so, my lord.
Why? Right, then we'll hear you on 3rd.
Please.
List the matter on 3rd in preliminary hearing. Yes, please. Next.
21.
Petitioner. My lord, kindly pass over the matter. The senior is engaged in another court hall.
Commercial OS.
Commercial wise.
ಏನು?
Lords, this honorable court on an earlier occasion had pleased to pass an order as such. Page number 132.
My order. ಏನಾಯ್ತು?
132, there were 2 reliefs
Oh,
claimed.
this is
With regard to valuation. Now, what the court has done, my lords,
being
this honorable
spoken to
court-
ಹಾಕಿ ಅದು ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ರ ಅದ?
House, please, my lords.
Ah,
One IA has been allowed, whether ADLR or Tahsildar, ಅದು ಈ pending ಇದೆ. ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ court, without giving any discussion, says this honorable court has directed the trial court to, at para 8 of the impugned order, my lord. All of their arguments have been Number considered 25. and then
Pass
an
over,
order has.
pass over. Pass over, come up, 2:30 I'll take, resume tax list, so come later. Yes.
22.
For petition, my lord.
We have for respondent.
Petition filed by me, my lord, under section 151 of CPC, my lord, seeking dismiss of the FDP proceedings, my lord. In view of the registered release deed executed in favor of the petitioner, my lord, annexure.
When FDP ಅಲ್ಲ?
Please, my lord.
Preliminary decree ಏನಾಯ್ತದು?
Annexure B may condition.
ಅಲ್ಲ, you did not project that point before the concerned court?
For that reason only I filed the application, my lord.
May I say, my lord? He is the executant and he is the beneficiary. In the.
The lordship may condition the application.
Anything else?
Lordship
Is
may
the
condition the
executant and he is the
application. The
beneficiary.
order passed by the trial
Already
court, my lord, on
I'll bid- you produce, ಏನು stay ಇದೆಯಾ?
Annexure B may condition,
stay
my lord.
ಏನಿಲ್ಲ.
Annexure B may condition, my lord. For
List
a
the
moment.
matter on 10th. Pendency of this petition will not come in the way of further proceedings before the concerned court.
Tomorrow
Next.
for orders, final order ಇದೆ ನಾಳೆ.
ಆಗ್ಲಿ sir.
ಅದಕ್ಕೋಸ್ಕರ ಮೆಮೊ ಹಾಕಿದ್ದೀನಿ.
No.
ಅಲ್ಲಿವರೆಗೂ till then, my lord.
Yes.
Annexure B may condition, my lord.
Yes,
My
next.
lord, sir, we have been restrained from doing business, my lord. I filed the appeal. The judge is on leave, my lord, expeditious disposal of my stay application, my lord. We have been
Stay application is not yet decided.
ಇಲ್ಲ. Restrained from doing business till the disposal of the suit, my lord.
You filed an appeal ಹಾಕಿದ್ದೀರಾ?
Appeal ಹಾಕಿದ್ದೇನೆ. Appeal ನಲ್ಲಿ stay application Consider my
ಈಗ appellate court ಗೆ stay application concern. The trial court did not grant you.
No, it has granted injunction against us, my lord, till the disposal of the.
The petitioner.
ಇನ್ನು ನಡೀತಾ ಇದೆ.
Ganesh Prasad. The petitioner is before this court seeking a direction, seeking the following prayer. The petitioner is the defendant in OS 662 of 2025. An order of injunction is granted in favor of the plaintiff respondent answering an application order 39 rule 1 and 2. The present petitioner defendant challenges the same before the appellate court in MA so and so. What has driven the petitioner to this court is the non-consideration of the application of the petitioner filed seeking stay of the order of injunction passed by the concerned court. Since the prayer that is sought is innocuous, no notice need be issued to the respondent plaintiff. I deem it appropriate to direct the concerned appellate court to decide the application filed along with the miscellaneous appeal 90 of 2025 as expeditiously as possible at any rate within 4 weeks from the date of receipt of the copy of this ordered according. Sir. 2:30 will resume the except faceless cases, my lords. Adjournments I'll call for wait. I'll take it, definitely take it.
My lords, 111, my lords.
Ade Arecanet 111. I told you make a mention at 111. 111. Arecanet matter. So 111 is.
My lords, serial number.
There are a couple of other.
Our Arecanet perishable commodity and the.
There is an order, he can pay the.
In spite,
Bank guarantee and take.
I furnished my bank guarantee, my lords.
Already furnished.
No, the honorable division bench has indicated that the bank guarantee should be to the value as assessed by me.
What has he paid then?
No,
It's on record, my lords.
Honorable single judge has directed the parties to seek clarification. So if he wants to seek clarification, he has to go before the division bench. He has not sought it.
I filed a memo, my lords, where seeking for clarification.
Where?
Before the division bench.
What happened?
They did not take it up, my lords. Already clarified and ಹೇಳಿದ್ದಾರೆ. My lords, it's very
So
clear.
you want me to clarify that clarification?
No, my lords, it's very clear.
The earlier order by the learned single judge is that the single judge cannot interpret the order of the division bench. Therefore.
And division bench has refused to clarify.
My lords, they have gone in review, my lords.
ಇಲ್ಲ ಆಗಿದೆ we will not take up ಅಂದ್ರೆ ಅಂತಲ್ಲ.
They will not take.
There is nothing to be clarified.
Nothing to be clarified. My lords, in fact, that order is very clear. Imported value of the goods.
We'll see.
I've placed it
Yes.
on record, my lords.
28 ತಗೋಣ.
My lords, 2:30. I'll play.
But if you want me to interpret the division bench order as the learned ASJ said, kashta.
No, there is already an order by Lordship Justice Suraj Govindraj on this very same issue, saying that the learned single judge cannot interpret the order of the division bench.
My lords, it's been 1 year since I filed my bill of entry, my lords.
What to do?
Yes. Furnish the bank guarantee, my lord, as per the order and take his goods.
My lords, I have furnished it.
See,
Kindly permit me 10 minutes.
1 minute. Bank guarantee in terms of what is determined if you furnish and take it, it will all remain subject to the result of the petition. In case you succeed, you will get back the bank guarantee money, whatever it is.
My lords, permit me 10 minutes at 2:30, my lords.
All right. Yeah, 10 minutes. ನೀವೇನು ಇರೋದು ಬೇಡ. We will not pass any order. 2:45 ಬೇಡ. You come at 3:30. ಆಗತ್ತಾ?
But at 4 there is a special bench.
Then 3 o'clock. You come at 3 o'clock. Please, yes.
My lords.
The moment you come, I'll take it.
My lords, serial number 35, my lords. You have to file statement of objections as served the.
Page wise, I'll call. 1 minute. I'll call page wise. Wait. Yes. List 1.
List 2, my lords.
List 1 ಕರೆದ್ಬಿಡಿ. ಕರೆದಾಯ್ತಲ್ಲ ಬೆಳಗ್ಗೆ list 1. Yes. Now list 2 ಕರೆದು.
List number 2, page wise adjournment, page 524, page 625 to 30.
My lord, number 26.
With my lord's kind permission.
26.
Appearing for the respondent number.
If you have informed the other side or get the other side, I'll grant. Yes.
Serial number 30, please, my lord. I'm for the petitioner in the matter.
KP Act. 25, tag the petition along with so and so list on 29th. Yes, next. Amal.
My lord's permission, serial number 30, may I
31
mention?
to 36.
Serial number
My lord,
32,
sir.
my lords.
Yes.
Matter is referred to mediation in the trial court. There's chance of settlement, my lords.
Learned counsel for the petitioner submits that the matter has been referred by the trial court for mediation and chance of settlement would emerge. Therefore, list the matter on 19th September.
Great.
Yes.
My lord, serial number 33.
My lord, serial number
I
35.
am on one.
List 2, my lords.
List 2, 30,
35, my lords.
I'm ready.
35.
I'll file statement of objections in the office, my lords.
Intermodal idea.
My lord,
11. Intermodal idea.
We'll
List the
file
matter on 19th September. Objections, if any, by then.
my lord, serial number 33.
Serve the copy, my lords. We'll file it in the office, my lords.
I'll code registry file ಮಾಡಿ.
Oblige, my lords.
31 ಏನು? Intermodal idea. 19th, yes.
Lord, serial number 33.
30.
33.
Yes. All right, ಆಮೇಲೆ. Objection ಇದ್ರೆ ಇಲ್ಲ. Yes.
Page 8.
May I read?
37, my lord,
Adjournment
for the
in serial number
petitioner.
30, please.
37.
For the petitioner, my lords, senior is on his legs before the civil court. Any short date that's convenient for this one.
That's not the reason.
My lord,
You should tell a better reason. Senior is held up in Supreme Court. Not civil court. Yes. When do you want?
any short.
Intermodal idea.
Interim order ಕೇಳಿಲ್ಲ, my lord.
ಕೇಳಿ.
Kindly post it after 16th of September.
List
A short date.
19th. Yes.
Page 9.
Serial number 40. My lord, serial number 41 and 42, I appear for the respondent.
Yes.
My lords, I'm led by senior counsel in this matter, my lords, I request. some time.
19th. Yes.
Much obliged.
Intermodal ಇದ್ರೆ continue ಮಾಡಿ. Yes.
My lords, no intermodal.
ಇದ್ರೆ ಮಾತು. Next.
Page 9. B group matters 44 to 50.
Serial number 48, my lords.
Hmm.
Petitioner number 2 has passed away. I'll file.
What
it.
happened to that matter, madam?
It didn't come up. Come on development.
Yes. Which is that number? Give it.
I'll write.
Yes. Hmm.
Serial number 48, petition number 2 has passed away, my lord. So I'll file the necessary application a week's time.
Rest after 2 weeks to do the needful. Next.
Page 10. 51 to 57.
51, my lords.
Ah.
I am for the petitioner. I seek for a short accommodation.
18th.
Interim
Delay
order.
alva. 16th. Yes. Intermodal continue. Next. 55. List on 16/9. Yes. Tag the petition along with so and so. List on 16/9. ಯಾರಿಗೆ ಕೊಟ್ಟಿದೆ ಅದೇ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿ. Yes, next. ಅದು 2 and 3 ನೋಟಿಸ್. Yes, next. ಅಲ್ಲಿ ಏನು ಆರ್ಡರ್ ಮಾಡಿದೆ ಅದು ಮಾಡಿ. Yes, next.
Page 11. 58 to 61.
ಮೇಡಮ್ ಇದ್ಯಾವ್ದು ಇದು ಇಂಟರ್ಲೋಕಿಟ್ರಿ ಕರೆಕ್ಷನ್. ಆಲ್ ರೈಟ್. ಎಸ್.
Page 12. 62.
ಅಷ್ಟೇ ಸಾಕು.
One submission, my lord.
ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ? Which is that court? Which court is that?
First additional senior civil. Morning 11 o'clock mention ಮಾಡಿದ ಕಾಪಿ ತಗೊಂಡು.
Yes. Okay, certificate copy ಸಿಕ್ಕಿಲ್ವಾ?
ಸರ್ಟಿಫಿಕೇಟ್ ಸಿಕ್ಕಿಲ್ಲ, ಕಂಪ್ಯೂಟರ್ ಕಾಪಿ ಸಿಕ್ಕಿದೆ, ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀವಿ.
We'll see. Yes.
Sorry.
What is the court done now?
Some lords, trial court lawyers are there, my lords, the court is telling that I have prepared the judgment, it's telling.
I have said, I have stated it, right?
Proceedings is stated.
Yes.
What comes into effect from yesterday? Court knows very well.
Let it do, we'll see. Which court is at Bharat Kodi, sir?
Sorry, my lord.
Yes, sir.
Serial number 92 was supposed to come in preliminary hearing, my lord. So first list, the lordship will take it up at 2:30, my lord. Because it's a simple matter to
No
go
problem.
back.
I'll take it.
Because it has come up in B group.
Allah, wherever
Not very sure.
notice are issued, right?
Yes, yes, notice issued, we argued also, you are wanted to remand it back.
Ozone Urbana.
Ozone.
Same orders I have passed in every case.
That is on separate, this is on income
This is separate.
tax.
No ozone left in that.
Ozone.
Ella carbon dioxide.
No, only carbon.
Yes.
Lordship
Lord,
made
serial
it
number 26 in list 2.
2:30.
Yes.
I talked with the counsel for the petitioners. They have said that they have issued NOC and no one has appeared now.
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
List 2, serial number 26.
ಫಾಲೋ ಮಾಡಿ.
Advocate
ಲತಾ
CH
ಶೆಟ್ಟಿ ಅಂತಿಲ್ವಾ?
ರೆಸ್ಪಾಂಡೆಂಟ್.
Respond number 14.
Sheshgiri Rao is not there?
They have issued NOC, sir.
You are not on record? When do you want?
First week of.
List after 2 weeks, 19th. I am hungry, sir.
Serial number 11. Serial number 24 and 25, ma'am.
ಎಸ್ ಸರ್, ಇವಾಗ ಮುಗೀತು.
ನೀವು ಬಂದಿದ್ದೇ ಗೊತ್ತಿಲ್ಲ ನನಗೆ.
Withdrawal. Yes. ಎರಡು ಮ್ಯಾಟರ. Yes. ಗೊತ್ತು. ಪಾಸ್ವರ್ಡ್ ಕಲ್ಬಿಡಿ. ಬಂತ announcement.
List number 3, pronouncement of order.
Both the petitions are allowed. Impugned notices dated 29/3/2019 passed by the first, issued by the first respondent, and all further proceedings taken thereto vide annexure B, C, and D stand obliterated. The petition would be entitled to all consequential benefits that would flow from the quashment of the aforesaid orders. Password? Password ಇದೆ. ಯಾವ ಲಿಸ್ಟ್ ಅಲ್ಲಿ password ಇದೆ? Second list.
List 1, password matter 15.
Yes, Arvind.
For consideration on that. The thing is that he has not filed the physical copy as per section 108.
No, same thing I have followed and GST ದಲ್ವಾ?
GST.
ಅದೆಲ್ಲ ಹೇಳಿದ್ರಲ್ಲ ಬೆಳಗ್ಗೆ.
But morning, Mr. Jeevan was mentioning about Yasho Industries, but that is a different issue.
That's a different issue, is it? Yes.
The payment of pre-deposit through credit ledger. But here the, it's a question of filing the hard copy. I
Hard
filed
copy
online.
Hard copy was filed in the adjudicating section. In the appellate section, they should have filed where the appeal was filed. They are not filed, only online.
Now they will file. We'll send it back to the appeals. Appeals before? The R2 or 1?
R1.
R1. Yes. RTF. Number 5.
List continued.
ಅಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಒಂದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ನಾಗಾನಂದ್ ಸರ್.
Second is password number 17.
Lord, I'll just take 2-3 minutes, that's all, my lord. Matter is not so complicated. Lord, I'll just give 2-3 dates, my lord, then I'll come straight to the point. My lord.
Yes.
This is a piece of land, my lord. This petitioner before your lordship, my lord, is a cooperative society. It was initially, my lord, a credit cooperative society. And it was making layouts and, my lord, they are all these BDCC bank employees, other persons who are members of it. In 1981, my lord, we negotiated with the landowners and entered into agreements to purchase this property, my lord. It's about 5 acres and all. I paid them advance everything. Thereafter, my lord, acquisition proceedings had been initiated. And that, my lord, has had a checkered career up to Supreme Court on more than one occasion. Meanwhile, my lord, a bulk allotment was made to this society. That bulk allotment was challenged. The matter is pending in Supreme Court, then the new rules came. So then, my lord, the government decided to bulk allot to me. And when it was allotted to me, other side challenged it. And that challenge, my lord, went again up and down the judicial ladder. Then, my lord, they decided to denotify the land. That we challenged it. So that also went up and down the ladder. Now, my lord, what happened was, because of this, in this interregnum, my lord, The land, my lord, has lost its character in the sense that there's a new road that is made, 2 acres, 40 gunta something. And there's a high tension wire. Below that, nothing can be done. So 4 acres are gone. What now remains is 5 acres and odd. Now they issued me a notice to say that you cannot own this property because you don't have an object which enables you to do this house site development. And
It's impossible to be done now.
no, not impossible. They said your objects do not enable you to do it. Therefore, you are not eligible for allotment. And they issued me an order to say we're cancelling that allotment in your favor. 16 years after the first allotment, after these 3 rounds up to Supreme Court, and I paid the money to the owners, all that is over. That, my lord, we questioned in the writ petition. And in the course of that writ petition, my lord, the court felt that they've issued you a notice, you submit a reply. Meanwhile, my lord, we amended our objects clause, and that was approved by the registrar, so my objects clause is clear now. Now, my lord, the present writ petition arises because they passed an order after the earlier round, my lord, the honorable single judge said you go and appear before them. They now passed an order cancelling my bulk allotment. It's at that juncture I am before the honorable court. My attack is against this order cancelling the bulk allotment in my favor. There was an interim order, my lord, granted by this honorable court. And that interim order, my lord, says that no action should be taken without permission of the court. Your lordships may see that interim order.
Now, what the senior counsel says is, barring the 5 acres that you are claiming, he would
I have a straightaway answer, my lord. Your lordships may see, I filed a memo, which is a document, my lord, from BDA itself. There is no other land other than that. There's a memo, my lord, on 12/8/25. I produced from the BDA records only. There's only one letter at page 5, my lord, if that memo.
Yes.
12/8/25, after the order sheets. 18/9/2007. This is the recording of the BDA writing to the government. ಸರ್ಕಾರದ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳಿಗೆ ಈ ಜಮೀನಿನಲ್ಲಿ ಪ್ರಾಧಿಕಾರವು 80 ಅಡಿ ರಸ್ತೆ ನಿರ್ಮಾಣಕ್ಕಾಗಿ 2 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನನ್ನು ಉಪಯೋಗಿಸಿಕೊಳ್ಳಲಾಗಿದೆ. ಹೈಟೆನ್ಷನ್ ಲೈನ್ ಹಾಕುವವರೆಗೂ 1 ಎಕರೆ 10 ಗುಂಟೆ ಪ್ರದೇಶವನ್ನಾಗಿರುತ್ತದೆ. ಉಳಿದ 5 ಎಕರೆ 13 ಗುಂಟೆ ಜಮೀನಿನಲ್ಲಿ ಭಾಗಶಃ ರೆವಿನ್ಯೂ ನಿವೇಶನದ ಕಟ್ಟಡಗಳನ್ನು ಕೂಡಿಕೊಂಡದಾಗಿ ಹಾಗೂ ಈ ಜಮೀನಿನ ಸುತ್ತಮುತ್ತಲಿನ ರೆವಿನ್ಯೂ ಬಡಾವಣೆ ಹಾಗೂ ಖಾಸಗಿ ಬಡಾವಣೆಗಳಿಂದ ಕೂಡಿದ್ದು ಪ್ರಾಧಿಕಾರದ ಬಡಾವಣೆ ಇರುವುದಿಲ್ಲವೆಂದು ಅಭಿಯಂತರರು ಹಾಗೂ ಭೂಮಾಪಕರು ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಈ ಜಮೀನನ್ನು ಭೂಸ್ವಾಧೀನ ಬಗ್ಗೆ ಮಾನ್ಯ ಶ್ರೇಷ್ಠ ನ್ಯಾಯಾಲಯದು SLP ನಂಬರ್ ಸೋ ದಾವೆಯನ್ನು ಬಾಕಿ ಇರುತ್ತದೆ.
That is disposed.
Yes. Now, my lord, all that I'm saying is, if they want, there is really no land to auction. They have now issued an auction notification without leave of the court. The earlier order, my lord, said that nothing should be done without leave of the court. So they've issued now an auction notification, and that auction notification, my lord, is in the memo, my lord, I filed. IA 1 of 25 is my IA for staying the auction. 26/7/25
Not to take any further steps in the matter without the permission of the court.
No, my lord, they didn't take any permission. They straight away, my lord, issued this auction notice. In fact, my lord, when the matter was heard, the honorable court was able to peruse and said, where is this land you're talking about? Neither they have developed it, nothing. So there is no land to sell, my lord. Now, all that I'm anxious to point out is that if your lordship does not interfere now, what will happen is the auction is now ongoing. No decision is yet taken. It has to go till the evening today. Suppose an auction purchaser comes. Then the question is, which is that land will arise? Already questions have been posed. Which is the land you are talking about? Where is that land? In whose position it is?
I'll make it simple for the learned senior counsel.
This was complex?
Not at all.
Yes.
Because that is the reason why I said. But now, totally about 10 acres of land, which may not 5 acres. If you lordship just see our statement of objection.
You forget the statement of objections. Come to that communication of 2007. Communication which learned senior counsel now read. ನಾಗಾನಂದ್ ಸರ್ ಓದಿದ್ರಲ್ಲ ಈಗ ಮೆಮೋ ಅಲ್ಲಿ.
That is not.
ಅದರಲ್ಲಿ ಏನ್ ಲ್ಯಾಂಡ್ ಉಳಿದಿದೆ ಹೇಳಿ ಈಗ. ಅವಾಗ್ಲೇ ಭೂಸ್ವಾಧೀನ. The whole problem is tomorrow you want to auction, one ನಿಮಿಷ, you want to auction this. BDA wants to auction and wash its hands off. ಆಮೇಲೆ no land is there and the writ petitions will be filed seeking refund. There are many pending now.
Yes. Now, what we are clear, your lordship may kindly turn to page 28 of my objection. Kindly see that.
Yes.
The sketch.
Objections.
objections are and before that sketch, my lord, objections to the IA, not the main. Paragraph 5, your lordship may kindly see, my lord, before that. And then I'll point out the
Objection cell ಇದೆ ಇಲ್ವೇ ಇಲ್ಲ?
objections to the IA.
2825.
2825.
ಎಲ್ಲ ಇವ್ರದೇ ಇದೆ. ಎಸ್ ಕಾಪಿ ಕೊಡಿ ಯಾವ್ದು?
Sorry, the last page has got detachment.
That's fine.
Your lordship may just turn to internal page 2, paragraph 5. It is submitted that keeping aside the land in dispute in the above expedition, there are areas left out which are required and not part of the dispute in the above expedition. The first respondent has taken note of the excluded area and has decided to auction a portion thereof of several small areas put together to a limited extent of measuring 3,794.8 square meters, which is less than 1 acre. Now, my lord, this is, and we have said in the next page also, internal page 3, subject matter of the dispute in the above expedition and the lands now notified for auction are produced here as an annexure R1. Since the lands now notified for auction are not part of the dispute in the above expedition, the action of the BDA notifying the same auction does not in any way violate. Now, your lordship may kindly see the sketch, annexure.
Sketch ಅಂತ ಅವ್ರು ಹೇಳ್ಬೇಕಷ್ಟೇ.
ಬೇರೆ ಏನೋ ಸ್ಕೆಚ್ ಇದೆ ಇದರಲ್ಲಿ.
This matter, I understand their apprehension about, if suppose we go ahead, if suppose they like, we are making it clear, we have stated.
Why did you not take permission of the court prior to any action?
That's what we have said, because we are not touching their 5 acres of land in dispute. Even now, I am making a statement, before your lordships, that this auction which has taken place from yesterday until today, it was listed yesterday, that's why they had moved and they only sought for time on the last occasion, which had come up 3 days back. Now, my lord, your lordship may say either result of the expedition or finalizing of the auction. And my lord, we would request your lordships, my lord, to give us a short date for the main matter itself to be heard, my lord, because as the learned senior, my lord, pointed out, my lord, it has a checkered history and the matter going up in the Supreme Court dismissed that matter. It is not as though that the Supreme Court held in their favor. It was there. That we point out. But the land which we have identified, in fact, my lord, they themselves, there is an order passed on 14/2/2017, where the order passed in their favor is status quo with regard to the petitioner's possession on the scheduled property. So, my lord, now what we are saying is their 5 acres we are not touching. Look, the sketch, if your lordship were to just for a moment see the sketch, we are showing the land of the.
No, what do you say about the
land of what we are selling? We have pointed out, and what is the land here? Your lordship may kindly see this, the grey portion.
So what is the mortal hurry now?
No, my lord, we need.
No, what is the? No, what is the mortal hurry?
We are auctioning the other.
No, what is the mortal hurry to auction?
The funds, there are 10 acres.
BD has no funds.
There are issues. What I am submitting is this one. The question is not whether there is a hurry. The question is
that only.
We are making a statement to your lordship. That your lordship may note that his 5 acres, which if he succeeds, we will give it to him. Even there,
that is your burden.
We are showing this, the sketch, which shows that we have left out the 5 acres of land. We are not even touched, but for that on merits, we'll argue that they are not entitled. That's a different matter on merits. As on today, to the limited extent for today, we are stated on affidavit that we are not touching the 5 acres. In case, it would, and if your lordship were to say that this is subject to result of the expedition or not to finalize the auction, because it's less than 1 acre, 10 acres of land, less than 1 acre of land. There is this 5 acres of land, something which is on the periphery and which is not even there, of which the land has to be given to them.
There's no land to give it to them.
There is land, my lord. We are trying to say, my lord, I am making a statement, my lord, that that 5 acres, my lord, if they succeed, we will give that 5 acres of land, or they'll be entitled for any alternate land, because they themselves say. But we are not saying anything against them or the court as of now. What is being auctioned is only a portion of the land, my lord, and that already from yesterday it has already started. So, my lord, the people have already bid, and probably by the evening, my lord, it would conclude. So, your lordship may, my lord, stay the finalization, my lord. I'll not even come in the way. Your lordship may say, subject to result of the writ petition. Lordship may put us on any other condition. My only request to your
Then
lordship is.
what you don't want this court to do then? ಎಲ್ಲ anyway ಹೇಳ್ತಾರೆ, you can do it.
ಅಲ್ಲ, ಏನು ಮಾಡೋದು ಬೇಡ, ನಮ್ಮ ಹತ್ರ ಒಂದೇ ರಿಕ್ವೆಸ್ಟ್ ಇದೆ.
ಹಾ.
ಈಗ ಆಪ್ಷನ್ ಇದು ಮಾಡ್ಬಿಟ್ಟು ಈ ಮ್ಯಾಟರ್ within 10 or 12 days, my lord, whichever is convenient for your lordship, my lord, have it at 2:30, my lord, because this, my lord, there are a lot of issues, my lord, which we want to point out. The learned senior counsel also will point out, and we will show, because this is of 81, 82, my lord, the acquisition, what has happened, why they are not entitled, what the Honorable Supreme Court has said, we'll point out. We may succeed, we may not succeed, that's a different matter. But till then, my lord, there is no issue for them. We are, my lord, making a statement before your lordship. So to that limited extent, otherwise, my lord, if the matter is to be heard, finally, after 2 days or 3 days, my lord, we are ready for it. No third party, my lord, the learned senior counsel said the third party rights, that your lordship can protect them, my lord.
Yes.
Identical attempt made earlier, this honorable court intervened and stayed it now. Exactly same thing they did. I produced that also. In my IA, my lord, IA 1 of 25.
Remove the encroachment, my lord, as and when. If your lordship sees.
Wait, what is that? Which is that?
Page 9 in my IA, my lord. 12th January 2010.
2010.
That's the order, my lord. Earlier occasion, exactly the same thing they did. Auction notification, no? And they said they'll give us land somewhere else. And it was stayed.
Here, small pieces of land.
No, that's all right. That's final hearing will do it.
Yes.
The petition is preferred by the BDCC Bank Employees Cooperative Society. It has a checkered history, the history of which need not be noted at this juncture. It would suffice for the prayer to be quoted. The prayer reads as follows. On the prayer, the coordinate bench restrained the BDA from taking any action by the following order. 8/11/2024. Is it BDA or GMCPC? By the following order. Amendment under rules, order rules 6, order 6 rule 17 ಹಾಕಿದ್ರಾ? ಇದ್ರಲ್ಲ?
ಅದರಲ್ಲಿ amendment application some correction ಅಷ್ಟೇ.
BDA na GMCPC na ಇದು?
BDA ಇದು.
ಅಲ್ಲ, IA number 3 under order 6 rule 17.
My lord, subsequent events, my lord, which happened during the pendency of the case.
617 ಯಾಕದಕ್ಕೆ?
Amendment ಗೆ. Amendment.
ಇದರಲ್ಲಿ writ petition ಅಲ್ಲಿ. Yes. Anyway, 8/11/2024, the coordinate bench passed the following order. The coordinate bench, while granting stay of the show cause notice and all further proceedings, categorically observed that the respondent authorities, i.e. the BDA, should not take any action, any further steps in the matter without the permission of the court. In the teeth of the interim order, an auction notification comes to be issued. Where is that?
On 26, part of IA number 1 of 25, my lord.
Auction notification comes to be issued by the respondent BDA on
26/7/25.
On 26/7/2025, seeking to auction several packets of land in the property which forms the subject matter of the present petition. The auction notification is issued on 28/7/2025. Correct, Adu?
26/7, my lord.
Where do I get that? ವಾಣಿಜ್ಯ ನಿವೇಶಗಳ ಈ ಸರಬರಾ ಈ ಹರಾಜು.
ಅದು in the text, my lord, your lordship will go to page
5. Page 5 of their application, document number 1.
Page 5 ಅದೇನೆ.
ಅದರಲ್ಲಿ plots mention
19/7. At the bottom of page 5, last line, ದಿನಾಂಕ 19/7/75 ಅದು
25.
ಪಬ್ಲಿಷ್ ಆಗಿದ್ದು ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಪೇಪರ್ ಪಬ್ಲಿಷ್ ವಿಜಯವಾಣಿ
On 26th July 2025. In the light of the fact that it was issued in the teeth of the subsistence of the interim order, the matter is moved again, seeking stay of the auction notification. The issue is the learned senior counsel for the respondent BDA, Shri Gurdas Kannur, would submit that the land of the petition, land that is to be given to the petitioners is not touched. The auction notification pertains to the other piece of land out of the 10 acres of the land that is the subject matter of the subject matter of the issue in the list. The 5 acres that the petitioners are entitled to would not be touched, and the remaining 5 acres would be auctioned in term. 1 acre of the remaining 5 acres would be auctioned in terms of the auction notification. The learned senior counsel, Shri S.S. Naganand, takes this court through a communication, albeit of the year 2007, concerning the same land. The communication reads as follows. Dated 18/9/2007 reads as follows. The communication is to the Secretary Urban Development from the hands of the BDA, indicating the absence of the land that could be granted to these petitioners, however, making the decision subject to the result of the special leave petition that was pending before the apex court. The BDA now, on a specious plea that they are not touching upon the land that is to be granted to the petitioner in the event of success in the petition, has sought to thwart the interim order that is granted, which had unequivocally directed that that no further steps concerning the land should be taken without the permission of the court. It is an admitted fact that no permission is sought by any mode, either by filing a memo or an application. Therefore, the BDA has taken a chance of issuance of a notification in the teeth of the interim order, which would undoubtedly fringe on the borders of contempt. The justification of the BDA is that they are not going to auction the property that is to be granted to the petitioner is too frail, frail a reed, REED, that the BDA wants to hang upon to justify its action, which on the face of it is illegal, as it is in the teeth of the interim order so granted. If the interim order were to be qualified or fragmented, inasmuch as the 10 acres divided into 5 or otherwise would have been a circumstance altogether different. The interim order is composite. It is concerning the land that is to be allotted to the petitioner. In that light, it is ununderstandable as to how the BDA could, without permission of the court, issue an auction notification which would encompass or not of the land that is to be allotted to the petitioner. That had to await a final decision. Therefore, the auction notification that is now issued would create such obfuscation by the act of the BDA. Now, if the auction purchasers would be lined up for the property, and that land will have to be allotted to the petitioners as a result of the petition, it would generate such obfuscation which would shroud with illegality. In that light, the auction proceedings that have now taken place till this hour the auction proceedings have taken place till this hour. Therefore, further proceedings pursuant to said auction shall remain stayed, and the BDA shall explain as to how they issued the auction notification in the teeth of the interim order by the next date. Yes, sir. 9th September. List the matter on 9th September. Why? Files.
The matter could itself be disposed of.
Matter will be disposed. New one, the synopsis, list of authorities or whatever dates and because this has a checkered history.
Convenient. It could be after 18th, my lord. My learned friend insists, then.
Vacation ginu time ಇದೆ.
81 issue the litigation. 81. I paid 55 lakhs in 81.
When there is an interim order, How could you do it? As simple as that, you should have filed an IA here. Then, how can you take the orders of this court?
That portion of the land untouched. That is why, my lord.
What is touched, what is untouched, sir? Nothing, yes.
We have made it clear in our, both our affidavit
This
and-
court had directed you not to touch any further proceedings. Then, other division touching, untouching,
I had said that your lordship put us on any terms or any conditions.
this is the term.
Yes, so
Yes,
I'm
Ashta-
not even opposing what your lordship is saying.
I guess you cannot and hope will not. Yes.
I'm not, but if your lordship were to say something, I can always say that please don't say this. I could have said that your lordship may not say that, but I myself said that your lordship may put us on that. So that's what I'm saying. What I say, your lordship may not agree. That's a different matter.
I have not, I have passed the order.
Yes, so I'm not saying anything about the order.
No problem. No, how can you say? You can only say it on the first floor.
No, my lord. So but all that I'm saying now is that your lordship may hear it at an early date.
ಅದೇ ಹೇಳಿದ್ನಲ್ಲ, whatever. Ninth.
My lord, I'm only saying, my lord, to the 18th, I have some difficulty. If my learned friend has very vehement opposition, my lord, I will not come in the way. Because this is a 1981 case. 81 ನಲ್ಲಿ 52 ಲಕ್ಷ ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ.
16 ತಗೋಬೋದಾ? 1981 ಅಲ್ಲಿ 52 ಲಕ್ಷ.
52 ಲಕ್ಷ. No, 81, my lord, was the
whatever will
agreements were entered into by me with landowners in 81 and I paid them the full price.
All right, we will answer all that.
After the 18th.
No, that's why at the outset I asked you, what is the mortal hurry in BDA is wanting funds?
It was all stray sites which they removed the encroach and they wanted to.
This is, no, more so the reason that you will generate hope for somebody else of getting a site in Bangalore and the land will be allotted to them later by an order, because of the order of the court. Where should that person go? Another litigation. ನಿಮ್ಗೆ ಏನಾಗ್ಬೇಕು? Stray site ಮಾರಾಯ್ತು. No. Whatever, 16th?
Any day after the 18th, I'm sorry.
ಆಯ್ತು, 19th.
Great. Now the existing interim order mechanism.
Interim order subsisting would continue till the next date of hearing.
Great.
Stay ಇದಕ್ಕೂ ಕೊಟ್ಟಿದ್ದೀನಿ. The interim order earlier granted by the coordinate bench also would continue till the next date of hearing. 2:30. Yes. 2:30. Correct. No, ಅದಕ್ಕೆ ನೀವು synopsis ಎಲ್ಲ ಹಾಕ್ಬಿಡಿ. Both sides. Yes. ನೀವು Yes, sir.
My lord,
Yeah.
first I clarify, we are not here to seek clarification, the division bench order.
ಯಾವುದರಲ್ಲಿ? Which matter?
Sir,
Oh, Arakanet.
Arakanet.
Yes, yes.
There are two sets of petitions filed. One set was three petition for the seeking the, for declaring seizure
ಸ್ವಲ್ಪ
illegal.
ಫೈಲ್ ಬರ್ಲಿ ತಾಳಿ. ಪೆರಿಷಬಲ್ ಕಮೋಡಿಟಿ ಅಂತ ನೀವು ಜಲ್ದಿ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಡಿ.
For 1 ವರ್ಷ ಆಯ್ತು.
ಇಲ್ಲ, ಅದಕ್ಕೆ ಫೈಲ್ ಆದ್ರೂ ತಗೊಂತೀನಿ. Has the coordinate bench said that it cannot clarify the division bench's order?
Yes.
ಮತ್ತೆ?
Please see the order dated 16/7. May I take just 2 minutes to give a background?
16/7.
16/7.
2025?
Yes. Before that, can I take just 2 minutes for a background?
Yes.
But in India, the prevalent rate for Arakanit is about 300-350 rupees. In other countries like Cambodia, Vietnam, Indonesia, it's available for less than 100. So to prevent people from bringing in cheap quality Arakanit so that it affects farmers in India, we have issued a notification that if you bring it below 351 rupees, it becomes dutiable. Now, the petitioner has admittedly imported Arakanit
from
from different countries,
I
maybe
see.
Cambodia, Vietnam, Indonesia.
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 Hmm.
And the petitioner is claiming that it is a roasted nut, my lord, and trying to classify it under a chapter 20, which deals with preparation of foods. Now we have a chapter 8 deals with the areca nut. Now he is classifying it there. So therefore we said this is misclassification and we initiated proceedings. He rushed to your lordship's court by challenging the initial seizure order. And in the meantime, my lord, several months passed by for passing of an order for release of the goods. Our consistent stand was, you furnish bank guarantee, we will release it. Eventually, my lord, learned single judge passed an order directing us to release on the basis of a mere bond without insisting.
That was challenged before the division
That we
bench.
challenged. The division bench said you shall furnish 25% security in terms of section 110. Now under 110, the officer has decided that the value is 80 crore. Now he has to furnish.
Value of the areca nut.
Yes, value of the seized good is 80 crore. And therefore
what if it is exorbitantly valued?
No, it can be challenged later. That can be
yes.
challenged later. But then when it came back before the learned single judge, the order dated 16/7 was passed. Now may I read? The Honorable Division Bench of this court by order dated 36/2025 has disposed of writ appeal and connected matters. While so disposing the writ appeals, the Division Bench has held that the petitioners would be entitled to release the imported consignment subject to giving security of bank guarantee or any other security which is 25% of the value of the imported consignment in terms of section 110A of the 1962 Act and as modified the earlier interim order passed by the coordination of this court dated so and so. Submission of the learned counsel for the petitioner is that petitioner is furnished a bank guarantee for the said 25% of the imported consignment value and as such respondents are required to release the goods seized. The submission of the learned ASG is that it is not just the 25% of the imported consignment value as regards with the bank guarantee is required to be given, but as per section 110A of the 1962 Act, which would be the amount assessed by the authorities. By considering the submissions, what is called upon by the counsel for this court to do is to interpret the order of the division bench, which this court cannot do. As such, both counsel are permitted to seek for such clarification as they require from the Honorable Division Bench as regards the said portion of the order, which both parties would have to comply with. Learned AG submits that the petitioner has not been participating, and thereafter a date was fixed on 5/8 appear. But not at now the petitioner claims to have filed a memo, but matter has not been listed
before the division bench.
Before the division bench. So, my lord, as on today, the division bench will have to clarify whether it is 25% of the bill value or 25% of the. So that, my lord, only the division bench can do.
We have filed 6 petitions. First for seizure of goods. Second is questioning the assessment, or not assessment, reassessment done by the respondent. There is no order on the reassessment still pending. We are here to seek relief under that petitions, not on the clarification clarification on the order passed by the division bench.
Assessment and reassessment of what? Areca nut.
Areca nut, 350.
So the foundation is 80 crore areca nut.
No, sir.
Allegedly 80 crores.
No, that is what I want to explain. My lord, they issued an order on 23/5/2025 reassessing the goods, which based on a TGFT notification, which is issued on 2nd April 2025. These goods have been imported long back, not on after that. There is Supreme Court judgment which says that the notification which is issued, which is only prospective, not retrospective. Its already issue is already settled. Moreover, the Madurai bench of Madras High Court stayed the notification issued by DGFT. And after that, many bills of entry filed in Chennai port, Tuticorin port, these goods are released under PD bond based on this thing. No duty was paid. Why in Bangalore?
Division bench.
Why only? Sir, one more thing, actually. I'll go to the basic.
Anyway, I deny all these allegations.
That's all right.
Yes. I go to the basic classification. HSN is the Bible of classification in India, everywhere, in all countries.
What is HSN?
HSN is Harmonized System of Nomenclature, which is used for classifying goods. All tariff across the world who are members of World Customs Organization follow that. I will read this one.
No. Now, what order you want now? On the you are arguing on the main matter?
no, second petition, we are questioning the legality of reassessment order issued by this thing. There is no such order issued by the division bench on the reassessment.
All right.
My lord, in the other
If
petition.
I
my lord-
now hold that reassessment is wrong, the Arecanet will have to come out.
Yes.
Correct.
Yes.
Effect is the same.
Yes, sir.
So we'll fix a date.
No, and in the other petitions, I have to complete the pleadings. I will file my statement of objections. Thereafter,
ಪೂರ್ಣಕೃಷ್ಣನ್ ಇದಾರೆ ಇದರಲ್ಲಿ?
in the.
ಬ್ಯಾಂಕ್ ಗ್ಯಾರಂಟಿ ನೀವು ಇದ್ದೀರಾ? In the other petitions? Age is appearing for everybody, every matter?
Yes.
Then
I am
no,
appearing.
yes, all right. ಯಾವತ್ ಬೇಕು?
2 weeks, my lord. 9, my lord.
Any date?
9.
We'll list it on 9th.
This September 9.
September next year ಅದು.
Any short date?
Let the pleadings get complete. If you're arguing the companion petitions where the assessment and reassessments are under challenge, we'll have to answer it on its merit. Pleading should get complete. As Leonard ASG said, I will also pass the same order now. If you have to go before the division bench.
Sir, 2:30. 2:30.
Yalla 2:30. It will be there. We'll take it. Definitely take it. Yes. Because it's Arecanet, we'll take it. ಇದು ಇಂಡೋನೇಷಿಯನ್ ಅಲ್ಲಿ ಎಷ್ಟು?
ಸರ್ ಇದು ಇವರೇ AG ಹೇಳ್ದಂಗೆ 350 ರೂಪಾಯಿ ಎಲ್ಲ ಅಡಿಕೆಗಿಲ್ಲ ಸರ್. 3 ತರ ಅಡಿಕೆ ಬರುತ್ತೆ ABC ಅಂತ. ನಿಮ್ಗೆ 80 ರೂಪಾಯಿಯಿಂದ ನಿಮ್ಗೆ 450 ರೂಪಾಯಿವರೆಗೂ ಇರುತ್ತೆ.
ಎಲ್ಲಿ ABC ಇಂಡಿಯಾದಲ್ಲ ಇಂಡೋನೇಷಿಯಾ?
ಹೇಳ್ತಿದ್ದೀನಿ ಸರ್. ಇವಾಗ ಕ್ಯಾಂಪ್ಕೋ ಅಲ್ಲಿ ಕೊಟ್ರೆ ನೀವು ಸ್ಯಾಂಪಲ್ ತಗೊಂಡೋಗಿ ಕೊಟ್ರೆ ಅವ್ರು ಹೇಳ್ತಾರೆ ಈ ರೇಟ್ ಅಲ್ಲಿ ಈ ರೇಟ್ ಇರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಎಲ್ಲ ಅದಕ್ಕೂ 351 ರೂಪಾಯಿ ಎಲ್ಲೂ ಇರೋದಿಲ್ಲ. ಇಂಡೋನೇಷಿಯಾದಿಂದ ಬರೋದು.
The government of India has to protect the farmers in
Absolutely,
India.
no
So
problem.
ಸರ್ ಇದ್ರಲ್ಲೇ ಕರ್ನಾಟಕದಲ್ಲೇ ಕಡೂರ್ ಏರಿಯಾದಲ್ಲಿ ಬೆಳೆಯುವಂತ ಅಡಿಕೆಗೆ ಜಾಸ್ತಿ ವ್ಯಾಲ್ಯೂ ಇದೆ. ನೀವು ಸ್ವಲ್ಪ ಈ ಕಡೆಗೆ ಹೋದ್ರೆ 200 ರೂಪಾಯಿ.
ಯಾವ ಕಡೆಗೆ ಬರ್ಲಿ?
ಕಡೂರ್.
Yes, we'll take it on 9th.
Very well.
Avat we'll dispose it.
Very well.
Yes. Heard the learned counsel appearing for the petitioners. The learned additional Solicitor General of India, Shri Arvind Kamath, representing the respondent, list the matter on 9th to hear further.
Correct.
Yes. After pleadings be complete by then.
I'm good. Will do.
One, B group matters 34.
This is a writ petition, my lord, challenging the reassessment proceedings for the assessment year 12-13. Initially, my lord, 148, this is a case where regular assessment under 143.3 was already done. A notice under 148 was first issued.
Assessment years?
12-13.
Notice issued?
First notice was issued on 23rd March 2018, Annexure G.
23/3/2018.
Yes.
So 149 bar.
No. This is
different, is it?
This is prior to the amendment of the provisions. This is the old provisions. The notice is issued under the old provisions in 2018. Amendment happened in 21.
No, I am talking of a pre-amendment only.
Pre-amendment.
Finance Act 2018.
Correct. 2018, it is within 6 years.
4 plus 2.
That is 4 years.
Plus 2 years.
If it is beyond
16 years beyond shores of the nation.
Beyond 4 years, they have to establish that is failure to disclose true and correct facts. That the proviso is there. But what I'm submitting is, kindly see, Annexure G was issued on 23/3/2018.
No, in the prayer you say it is barred by limitation. So I asked.
Correct. That's the contention taken. But what I'm submitting, there are two 148 notices. Without disposing of the first 148 notice, they issued a second 148 notice. That's the point I'm trying to make as the first ground, because that's the.
Yes.
So the first 148 notice was issued on 23/3/2018. Now, before the amendment, as your lordship knows, Supreme Court G.K. and Rice have said, if a notice is issued, you ask for reasons.
Yes.
And you challenge the reasons.
Yes, challenge the reasons.
Yes. So we wrote Annexure H on 10th April to provide the reasons. They don't give the reasons. Then they issue the second notice.
Page?
Which is Annexure J, page 235.
Yes.
29/3/2019 in respect of the very same assessment year, 12/13.
12/13, yes.
That's right. Even the earlier notice, if my lords kindly see annexure G, is 12/13.
That is at which page?
2230.
Ah. Yes.
So first ground is without disposing of the first notice, despite our asking for reasons, they issue a second notice. Second notice, again, we write on 29th April, annexure K, page 236, asking for the reasons.
Yes.
This time they give the reasons, which your lordships will find at page 240.
Yes.
My lords may kindly see the reasons given. May I read the reasons, my lord?
Yes.
SSE is engaged in the business of providing information technology solutions and services. The company enters into contract for software development work with customers outside India and engages services of its overseas group companies, that is associate enterprises. SE has made payments to its associated enterprises for on-site services which are in the nature of software development services and for marketing of its products and services in overseas countries. On winning a contract for a project, SSE subcontracts a certain part of the project to its AEs, and in turn the AEs are paid for the services rendered to the SC company. The AEs also render market services in overseas countries due to marketing efforts of the AEs. If a contract is won by ML, a certain percentage of contract value is paid as selling commission to the AEs for the services rendered. The details of total payments made to the AEs for AY 12/13 is as under. Software development services, your lordship kindly see, to 330 crores and marketing services is 6 crores.
Yes.
Total is 336 crores.
Yes.
Then kindly see paragraph 3 over the page. SC was required to deduct tax on payments made to the AEs, but no tax has been deducted by the SSE thereon, either at the time of crediting or subsequently. As per the Act, that liability to deduct tax on payment to the AEs rests on the SSE. Hence, non-compliance to TDS provisions results in a direct gain to the ML, as it is able to enhance its profits by not deducting tax at source. SC has thus failed to discharge its duties, which results in loss to the exchequer. It is a fact that no application under was tendered by it under section 195(2), especially in where huge remittances to non-residents were involved with massive tax effect, and also when such payments are not explicitly declared exempt by the provisions of the IT Act. Since these payments made by the SSE to the AEs are taxable under the Act and the DTA, either as FTS or royalty, and as per section 195 of the IT Act, the order under 201 and 201(1)(a) of the IT Act was passed. Kindly note this dates, was passed on 27/3/2013 by the assessing officer of the International Tax, Bangalore, holding an SSE as SC as SSE in default. Same was communicated to this office by letter dated 10/3/2016. I'll just pause here. Kindly see the assessment order in this case when it was passed.
Page.
The assessment order, my lords, will get page 195, annexure H, 21/4/2016, by which time they were aware of that order. That order was already communicated to them. In the regular assessment, this issue is not even raised. Moreover, the fact that I have made these payments to my AEs are declared in my financials. If my lords kindly see my financials, which I have produced as annexure A, kindly turn to page 53. So I have to declare all the payments that I have made to the non-residents.
Yes.
Page 53, my lords, sir.
Yes.
Kindly see middle of the page, software development charges paid to entities where control exists. Total is 330 crores. My lords, get that?
Yes, I'm there.
And then commission, last heading, commission paid to entities where control exists, 200. In fact, I have declared more than what they have picked up. They have picked up only 6 crores. I have declared 24 crores.
Yes.
These are part of my financials. So one is, I have disclosed these details. Regular assessment takes place. Their entire reassessment is on the basis that a 201 order is passed and it was communicated. That communication was before this assessment order was passed. So where is the question of initiating proceedings after 4 years? This is over and above the fact that there was a first notice issued.
First notice was naked.
Not even dropped.
Yes.
There the courts have said if you have issued a first notice without saying whether it has been dropped, without disposing it of, you can't issue a second notice. And this, as far as this issue on beyond 4 years, my lord, there are any number of judgments, one judgment.
4 years.
Straightforward, my lord, it's covered by proviso to 147. Without there being
No,
failure to dispose.
once notice is issued without passing orders on that, the second cannot be issued. Do you have anything? on
Yes.
that?
Yes. You only had it. There's one more, I'll just pass on. My lords may kindly turn to paragraph 11 at page 9.
Yes.
Though in our opinion, the petition could have been decided on only one of the several contentions raised by the petitioner in view of the possibility that the aggrieved party may carry the matter further, we would like to express our opinion on all the contentions raised before us. For consideration of such contentions, we would club all the arguments. We may recall that the department previously issued a notice dated so and so. We have reproduced the reasons recorded by the assessing officer by issuing the notice. This notice was challenged by the petitioner before this court. After discussion at the bar, counsel for the revenue under instructions stated that the notice for reopening of the assessment would be withdrawn by the assessing officer with a view to issuing a fresh notice after recording fresh reasons. Thereupon fresh notice came to be issued on so and so. We have also reproduced reasons recorded by the assessing officer for issuance of such notice. In the previous notice, the reasons recorded merely stated that the information was received by the office in response to the fictitious losses created by some broker by using so and so the client. Then these are the reasons, my lord. Then my lords may kindly come to paragraph 16. The law on subject is sufficiently clear. My lords have.
Yeah.
There can be only one process of assessment or reassessment. Pending any such assessment or reassessment, there cannot be a notice of reopening. The courts have held that there cannot be reopening of assessment which is not yet complete. Counsel for the petitioner has referred to several decisions in this regard, which we have noted. Reference to only one of them would be sufficient. This court, in the case of so-and-so, had occasion to take into consideration various judgments of High Courts and Supreme Court in background of facts which were thus. The petitioner has filed the return of income for the assessment year. Notice of reopening of the assessment issued by the assessing officer. Such notice was challenged by the petitioner before this court. High Court has admitted the petition and granted interim relief staying further proceedings pursuant to such notice. When the petition was pending, the assessing officer issued yet another notice under section 147 seeking to reopen the petitioner's assessment for the same assessment year, however, on the basis of independent reasons, possibly upon availability of fresh material. This second notice of reopening was challenged on various grounds.
Yes,
the court
sir.
held as under. So, in fact, in that case, they have challenged the first notice. Here, we don't know whether the first notice was dropped, it's been withdrawn, no this thing. Then as far as one more decision, my lord, Calcutta High Court. Page 3, middle of the fourth paragraph, the only question that arises for consideration.
Yes.
Therefore, is this writ application is whether the income tax officer could initiate fresh proceedings under 148 on so and so when pursuant to the earlier invalid notice dated so and so, the petitioner has already submitted the returns. After hearing the learned advocates for the parties and after going through I find that the question involved herein has practically
One
been
clarification.
answered. Yes, ma'am.
Pursuant to the first notice, what happened?
Pursuant to the first notice, I wrote a letter, asked him to give the reasons which he
No
never
reasons.
replied. Which he never replied.
All right, yes. Next.
In the said case, an invalid notice under section 34, which is equivalent to 148 of the present act, was served and return was submitted pursuant to such notice. The question was whether there was a valid return and whether the notice of assessment ignoring such return could be appealed. So the second notice, my lord, they said is, so on both counts that there are two notices simultaneously. And also I have already fully disclosed all the facts in my returns. My assessment was done. And in fact, this very issue of my payments to subcontractors, my AEs abroad, was taken up, scrutinized by the transfer pricing officer, incorporated in the assessment as far as various adjustments are concerned. That is already there. In such a case, can a notice under 147 after 4 years could at all have been issued? These are the 2 points.
Yes, sir.
My lord, on the first issue of, my lord, a notice having been issued at an earlier occasion, if it is on a different, my lord, information which has ultimately been dropped, but not reasons for reopening, my lord, could be different.
First is you issue a notice
I will
for the
issue a
same
notice.
assessment year,
Same assessment.
2012-13. You had some reasons to issue notice.
Please.
Those reasons are not divulged there. You stop there. They ask for reasons, you don't give reasons.
Please.
Because the law requires you to give reasons after they asking it. You have not given reasons. You stop at that. Issue another notice.
My lord, if the subsequent, the second notice issued is on a different information and on a different issue, that would survive.
Now you come back to the information. Information is
Information is
software
not-
development charges were not paid.
Please.
That is the information you had. You had that information on the first instance also because it is already made known to you. Second instance, you're divulging that information. Why you threw a second notice when already there was a first notice? Why did you not take the first notice to its
But
logical
my
conclusion?
humble-
Because you did not see anything. So issued notice.
My submission is, my lord, of course, I don't have the original records, but if the first notice has been issued for a different issue, not on
Where do you get that? If you had divulged reasons when they asked, give the reasons for issuance of notice, it would have been clear. You abandon that notice. There is no question of abandonment of a notice once you initiate proceedings. You abandon that notice. Issue another notice. So that will be a second proceeding on the same issue for the same assessing year. You may have manifold reasons. Bring about in the same notice. Why 2 proceedings?
my lord, 2 proceedings on, my lord, there could be 2 issues, my lord, issue number A and one is B.
Yes. If you have come to know,
And if we
1
had
minute.
dropped it without.
If you have come to know of the issue after the issuance of the first notice, it can form second assessment, second proceeding. Correct? No qualm about it. But this is an information that you have had even prior to the first notice.
Even if so also, my lord, my humble submission is, if the assessing authority has completed the assessment without looking into the material, still it would be open, my lord, if an assessment is completed
No,
without
sir.
making an.
Definitely you can reopen the assessment, no problem. But the question of once you have reopened with a particular notice, you take it to logical conclusion. Or how can you issue a second notice for the same assessing year without there being no further information? Yeah, between the first and the second, you have got something. Definitely you can start.
My lord, I may be given a very short time, my lord, a few days, 2-3 days.
This is only few days time. ಯಾವ್ದಕ್ಕೆ ನಿಮ್ಗ?
ಯಾಕಂದ್ರೆ just for one, just to make, my lord, the records clear, if my apprehension is, my lord, if the first notice has been issued, not for the reasons which have been issued now.
2019 mat 6 years ಆಗಿದೆ.
I'm not seeking long time, my lord, even 2-3 days also. Just to say, if we have
No, no
dropped
problem.
it and we have not intimated to the SSC.
Even if not on that point, while disposing of my objections to the reasons given in the second notice, the officer says, yes, you have disclosed these facts. If my lords kindly see the order passed.
Then
on jurisdiction.
what remains if
That's exactly what I'm saying. Kindly see annexure P.
The fact of non-disclosure has been brought out in the, my lord.
No, non-disclosure is brought out. If he says that you have already disclosed the facts, what remains?
Kindly see page 280. Page 279 is 278 is the impugned order on the reasons passed. Page 280, paragraph 1.2.
280?
That's right. It is correct that the SSE company has filed a copy of the audited financial statements, copy of accountant's report in Form 3CB along with return of income, wherein various information material have been disclosed. All that he says is,
No, however,
you have not disclosed the fact that you have not done TDS. Now, whether these amounts are TDS is done, should be done or not is an inference that the assessing officer has to draw.
My lord,
That's what
next
Calcutta
para,
discount, if my lords kindly recall the Constitution Bench judgment in Calcutta discount, my duty is to disclose the basic facts that I have made these payments to non-residents. Whether tax ought to have been deducted on these payments is an inference that the assessing officer has to draw. I cannot tell the officer what to do, what not to do. That's what the Calcutta discount in Supreme Court has said. Now, what the officer says in paragraph 1.2 is, yes, you have disclosed the details that you have made payments to the non-residents. But what you have not disclosed is the fact that you have not done TDS. My submission is I don't have to do TDS. That's why the 201 order was passed. And that 201 order, my lord, they were aware of in 2013. Assessment was done in 2016. So they cannot say that this information was not available.
my lord, that has been
This is
answered, my
apart from
lord,
the
in
fact
para
that there
1.3.
are two notices.
Para 1.3, my lord. Where is next para? It is pertinent to mention that though the SSC company has produced the books of accounts, audited financial statements, annual report, the requisite material facts as mentioned above in the preceding paragraph have been embedded in such a manner that material evidence could not be discovered by the assessing authority and could have been discovered with the due diligence accordingly attracting the provisions of explanation 1 of section 147 of the Act, which does not necessarily make the disclosure a full and true disclosure. Thus, any and every disclosure will not make it full and true, and heavy burden is cast upon the SSC to disclose fully and truly all material primary facts which are necessary or effective in completing the assessment proceedings. Perfunctory and half-baked disclosure of facts will not come to the rescue of the SSC, who has not bothered to disclose all the material facts in its entirety. It is also submitted.
No, that may be a rhetoric, but the reality is that he has disclosed.
My lord, the reality, my lord, that is discussed in the next para. What has not been disclosed?
Instant case.
Para 1, my lord.
Para 1, yes.
It is also submitted that in the instant case, the impugned issue under the consideration which necessitated the reopening of assessment have never been examined by the assessing officer during the course of regular assessment proceedings, and the same gets substantiated from a bare perusal of enclosure 11 of the tax audit report in the particular clause 27B2, which highlights the aspect of non-compliance with the provisions of chapter 17B of the Act. The tax auditor had only mentioned the default of non-compliance with regard to payments made to contractors, payment made to professional and technical services, rent on which no tax was deducted at source, making no mention of contravention of the provisions of section 195(1), in as much as no tax was deducted at source on remittances payments made to non-residents, which are in the nature of fee for technical services. Furthermore, on perusal of the order sheets, it is observed that the assessing officer had only issued a general notice under 129 dated so and so, and there is absolutely no discussion made on the invocation of section 195 with the consequent disallowance of the expenditure under 40A1. Now, my lord, if the assessing officer passes an order without making, my lord, the inquiries which ought to have been made, then there is room, my lord, for 140 for issuance of 148. If under a particular circumstances, if we
Then
had
why do you want time? So yes.
Only one additional point.
Yes.
The officer in the reason says, I have never applied for 195(2), no withholding tax. That is also incorrect factually. Kindly see page 275. I have applied under 195(2) for not to give a no deduction certificate, nil deduction certificate in 2004, and the officer has given me such certificate. My lords may kindly see this order. Please refer to your application so and so. On-site works subcontracted, you are allowed to remit the impugned amount without withholding tax.
So you need not pay taxes, what you say?
Is what he said in 2004 itself. So I have been paying these amounts without deducting tax. So where is the question of disclosing that I have not deducted taxes? In my 3CD.
It appears to be a justification for the second one. Second notice justification. Correct. Yes, heard reserved.
One small note we have prepared, my lord, because the earlier bench wanted it.
Even I wanted.
I'm sorry.
And judgments?
I just give the judgments referred to in that note also, my lord.
Raviraj, ನಿಮ್ದೇನಾದ್ರು ಇದೆಯಾ?
Please,
Judgments?
judgments, my lord, I have on 148, you know.
148 ಕೊಡಿ. Yes. Anything is,
I'll take my lordships through.
anything is learning,
Please.
give it, yes.
Please.
You need not take
My
me
lord, the
through.
first two judgments, I'll take my lordships to only the relevant paragraphs. My lord, page number,
148 proceedings mail.
oh, please, what is reason to believe or cause or just,
That
my lord,
is-
just justifiable. Page number 11.
ഇതിൽ paragraphs ಹಾಕಿದ್ದೀರಾ?
Paragraph 16,
You just give the paragraphs.
17.
You give the paragraphs,
Please,
I'll go
please.
through it. Yes. Heard reserved, yes.
Great.
There's an interim order?
Yes. That is until further orders.
Ah, then
Need to
no.
extend.
Yes.
35.
ಇಲ್ಲ ಅಂದ್ರೆ 11th ಹಾಕ್ಬಿಡಿ. This is reserved. Idir paragraphs
marking.
mark paragraphs. Yes, madam, 35.
My lord, ready, my lord, actually pleadings are completed. They want to escape, my lord. Always
They want to?
escape. Morning
Escape.
they came and informed me they want for time. Again time.
No representation on behalf of the petitioner. In the event there would be no representation, appropriate orders would be passed on the next date. As a last chance awaiting their appearance, list the matter on 11th September.
Fourth, my lord.
4th September. Yes. 2020, 5 years, I think.
36.
We close whatever is possible.
For the petitioner, my lords, 144 assessment order is passed ex parte, which is at annexure A, and thereafter, my lords, demand notice is issued.
Yes, Dharmaj sir.
This is
All I am seeking is
order.
one opportunity. my
Send
lords.
it back.
Today order has been.
Today you should not send it.
No, no,
Ah.
today order is received. This is a 2019 order. So I require to inform the department.
All right. sir. List the matter on
Thought I would have surely.
28th or 4th?
Fourth.
4th. Interim order. 35 where, sir, you are not there at all?
I'll have it next week.
I have posted it last chance on 4th. If you don't appear, I will dismiss it.
37.
36 list on 4th, madam. ಇಲ್ಲ ಅಂದ್ರೆ 11th. No representation. ಏನು ಹೇಮಕುಮಾರ್?
Next week in
Next. 11th ಕರೀತೀನಿ. Next week ತುಂಬಾ ಇದೆ. List on 11th. No representation of the petitioner. ಹಾಗಾದ್ರೆ 11th ಅದೇನ್ ಬೇಡ. List on 11th, yes.
8 dispose 39.
My lord, I am there for R1 to R5.
For R6, we need some time in filing my objections
Yeah,
because
please,
I am
ma'am.
the show issuing noting and not
All right.
issuing
My
authority.
lords, this matter
Fourth
has
ಹಾಕೊಂಡ್ರೆ
been.
ನಾನು ಹೇಳ್ಬಿಡ್ತೀನಿ.
ಏನು ಹೇಳ್ತಾರೆ? ಒಂದೇ ನಿಮಿಷ ಹೇಳಿ. ಹಾ.
I am only asking for a week's time. Perhaps if it can be taken on 4th, I'll file my objections. So because they have sent even some rejoinder, they are not given me a copy. I'll just see that and I'll file my
Lords,
objections.
I have come from Belgaum.
Belgaum?
Yes, my lords.
Oh, I heard
This is the
Belgium.
first time I'm
Yes.
submitting this. My lords, from the month of February 2025, this matter has been dragged.
Dragged?
Yes, my lords, for at least for 5-6 times on the pretext of filing objections. They took time. July last week, they filed objections. Within 3-4 days, I filed rejoinder as well. Now, on the pretext of rejoinder to rejoinder, they are seeking time. I request my lords to hear and dispose of the matter. It's a very short matter, my lords.
In such a case, my lords. in
My
such a
refund
case-
is struck since last 2 years.
Refund matter?
Yes, my
You
lords.
will get it.
It is illegally
No,
If you are entitled, you will get it. No worries.
retained.
Submission is that if such is the submission, then the writ petition is not maintainable in terms of the Supreme Court order. It can be taken up right now. It is
Let
not
us see,
maintainable.
my lords
If
can-
my lords were to hold it is maintainable. My lords, it may be taken up right away for maintainability. The judgment has
Yes, my
also been
lords.
given. Let him address on the maintainability, my lords. Then can be.
I
go into
come
the
every
merits of
time
the case.
prepared, my lords, but every time after coming here, I come to know that they need time.
It can be
So
decided.
divulge your,
Enforcement.
sir, divulge your preparation on maintainability.
There's a Supreme Court order on the maintainability of the writ petition. If they want, let them go on appeal under 107. Let them show their
Oh,
My lords, this is
107 appeal
a,
ಹೋಗಿಲ್ವಾ?
this is a,
appeal ಹೋಗಿಲ್ಲ, order
this
pass
is a
ಆಗಿದೆ.
petition against deficiency memo, my lords, not against
Whatever
the
it is,
order or
it's
decision
on
of
the
the,
merits of the case.
it is only on the deficiency memo, which is a interlocutory, memo which is issued, listing defects in the refund application.
It is not
Documentary
a simple,
defects.
simple matter of.
It is not on
refund
merits,
where
my lords.
Multiple issues has been addressed. I have filed my detailed objections.
No,
I
show
have-
cause notice issue matter ಅವರು. Let him file it.
Yes, I have already countered their objections, my lords, in my rejoinder.
Is the adjudication authority was.
I am the adjudication authority. I have filed my objections.
I kindly
They are
request
the
my lords to hear and dispose of the matter today, my lords.
Today?
Yes, my lords.
Why? Because you have come from Belgaum.
Not necessarily.
such a case,
Because it has,
maintainability may
at
be
least
taken
you
up.
can see the daily order list. At least 5-6 times it has got adjourned.
Don't
Unnecessary.
worry, the buck will stop here. Yes.
Please.
ಯಾವತ್ ಮಧು?
Fourth, my lords, I'll be reading.
Yes.
May I permit it
May be
to
posted on
appear
court.
online, my lords? with
Your
your
wish.
Permission. Your permission.
Belgaum is not far.
Yes, but every time, one matter I need to come.
You come
Welcome.
online. Yes.
Yes, my lords. Thank you.
But don't press you're coming from Belgaum.
No, not necessary.
No.
Yes.
There is a difference because Belgaum ಅಂತ post ಮಾಡಿದ್ರೆ Belgium ಗೆ ಹೋಗುತ್ತೆ.
ಅದೇ ಅದಕ್ಕೆ ನಾನು.
It's painful, my lords. Coming for one matter from all over.
You should not project as if you're coming from Boston. Belgaum. Yes.
Obliged.
41.
Fourth other.
Hearing for the petitioner, Your Lordship. Your Lordship, the petitioner has filed this.
42.
40.
40 is adjourned. Faceless.
No, Your Lordship. I'm challenging on the 148 AB.
Faceless
notice.
alva.
Faceless not, but they are relying upon other ground, 7 days.
7 days period, 148.
That we'll see. If faceless goes, everything will be revived later.
So if it is.
I've
that
adjourned it on a particular date, 28th. All faceless,
Grateful,
28th.
Your Lord.
42.
Faceless not.
Faceless,
Yes, ma'am.
yes.
42.
ಅದು ಆಡ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್ ಲಿಸ್ಟ್. ಎಸ್ ಸನ್ಮತಿ ಫೇಸ್ಲೆಸ್
Also faceless not.
40 ಆಯ್ತು 42.
42 faceless not.
ಹಾ
43 faceless.
43 ಹೇಳಿದ್ದಾರೆ.
43 is already added. Yes.
44.
That can't be faceless. Yes. Customs.
Your Lordship, I appear for the petitioner, Mr. Parson Brothers. This is a simple matter of refund case, Your Lordship. It's a
All refunds are simple. Everybody are saying this. Yes.
So the amount also is very small. It's only 7 lakhs. Yes, yeah, but it has been sort of recurring case where it has been going on for the last 5-6 years.
Yes. Tell me, sir.
So basically, so they had imported certain goods, sir, in August 2019. And so basically they had sort of first imported the goods and warehoused it on August 2018, and to August 2019 they had sort of ex-bonded the goods for further delivery. But that was sort of after sort of coming to know whether the sort of goods have been sort of transported, they came to know that they paid excess duty by 7 lakhs. Once they came to know, sir, so in September 2019 they mentioned that please cancel our bill of entry and sort of give us our refund of excess payment of duty. What the authority then mentioned, and in around January 2020, they mentioned that this particular request for cancellation or amendment of bill of entry cannot take place. Accordingly, we in August 2020, we filed an appeal. In March 2021, we received an order in our favor from the Commissioner Appeals. He mentioned categorically, if I can take you to page number 25, Your Lordship.
Yes.
In 25, you can refer to para number 2, 3, and 4, Your Lordship. It explains the entire process of how the sort of excess payment of duty has happened. Inadvertently, the amount was sort of the assessable value. It was
it was sent back for passing fresh
remand.
orders. Which is that order that is passed later?
There is no other order which has been passed later.
After this, no order is passed?
Absolutely, my Lordship. That is why I'm here with you. And even if you see on page number 21, that is the letter which the appellate order has provided an order. It said that there is no speaking order. Further, even if it is out of charge, Your Lordship, even then there are High Court rulings Even if it is out of charge, or even if it is confirmed that all the import procedure has been done, you can get it reassessed under section 17. Moreover, not only reassessed, you don't even have to file an appeal. You can get it rectified
Yes,
under.
one moment.
Plus, we have
Yes,
already-
1 minute, sir.
Sorry.
What has happened after the order at page 27?
We have gone ahead and then, asked for the signature of the statement of objections.
That's, you answer what I asked. The instant appeal is allowed by way of remand to the original respondent for fresh adjudication. What has happened after that?
We have not got any updates with regards to
Yes. Anything else?
nothing, my lords. If you can
Give
a short
refund now.
date, we will.
5 years, why are you keeping quiet after the order?
Lords, I'm so sorry, but.
I'm also
No,
sorry.
it's not like that,
Yes,
my lords.
sir.
No, if you can give us a short date, we'll file our.
No
statement of
short
objections,
dates, yes.
I would further request that there should be interest implication. It should be within a specific time period also, sir.
That's a humble request.
It's a humble request, my lordship.
Next week, if you can please take.
No, sir, yes.
My lords, we'll
Sir,
get.
time period also, sir.
That's a humble request.
It's a humble request, my lordship.
Next week, if you can please take.
No, sir, yes.
My lords, we'll
Sir,
get.
Not for an officer who has kept quiet for 5 long years after the order.
Your
What is the
lordship,
amount of refund?
7 lakhs, 7.22 lakhs. Along with interest, it will come to around 10 to 12
The
lakhs.
petitioner is before this court seeking a direction by issuance of a writ in the nature of mandamus, seeking consideration of the refund application of the petitioner and ordering such refund claim of the petitioner in terms of the representation so submitted. The petitioner, what goods?
So these are
The
wine and beverages.
petitioner, certain goods were imported in terms of bill of entry on 15th November 2018, and the petitioner had paid excess customs duty on the said date. On
Your
12th
lordship,
September 2019, the petitioner intimates to the first respondent that excess customs duty was paid and sought cancellation or reassessment of the bills of entry so made. This was the Commissioner of Appeals, in terms of his order dated 15th March 2020, accepting the
2021, my lordship.
2021, is it?
Yes, your lordship. And also,
Accepting the plea of the petitioner. Where do I get that?
order in appeal, sir, it is 16th April 2021.
Yes. The Commissioner of Appeals, in terms of his order dated 16/4/2021, allowed the claim and remitted the matter back to the hands of the which officer was that?
Assessing authority. Your lordship.
Back to the hands of the assessing authority to pass necessary orders in consonance with principle of natural justice and the statute. The matter was remitted on 16/4/2021. 4 years have passed by. Not a dot of ink is placed on the paper of reconsideration as directed by the Commissioner of Appeals by the assessing officer. In the light of no order being passed for the last 4 years, what is this order? 15/3/23?
15/3/20. This is 20, that is my mistake, your lordship. It is 15/3/2020. That is the order against which the appeal was filed.
And what is this 23 you printed here?
That is my mistake, your lordship. I humbly apologize.
So no order is passed?
No order is passed, your lordship.
Yes, Jeevan, what is this?
Power of the Commissioner of Appeals to remand the matter back is restricted in the case, my lord. Only under 3 circumstances do that.
Adaru baribekalla.
If that is fulfilled, my lord, otherwise he doesn't have a jurisdiction to remit the matter back, except under those 3 circumstances.
Now what have you done after that?
No, your lordship, I think they have categorically mentioned why there are
Read the
case
No,
laws
that
they
those
mentioned.
3 reasons are here.
No.
Yes, they
read
are
the
categorically
provision.
mentioned in the appellate order.
No,
your
no,
lordship.
that
Empowering
is,
the Commissioner of
have
Appeals to
you
remand.
seen the order?
No, I have not seen the order.
Power of the Commissioner to remand is on 3 circumstances.
Yes.
All 3 circumstances are narrated here.
If there are
Principles
present,
of
my lord,
natural
then
justice have
all
been
those
violated,
3
your lordship.
circumstances
And
are present,
one-
then it can.
And the all pervasive is principles of natural justice.
Absolutely, your lordship.
That is there.
That is all circumstance friendly.
That is all there.
Yes.
Where the order or decision has been passed without following the principles of natural
Absolutely.
justice.
Absolutely. No
That's
speaking
the-
order was passed.
That's enough.
That condition is fulfilled.
That's enough.
Remitting. Section 130.
So and so. The, yeah, any less.
128. Section 128, capital A.
Not even a dot of ink has been placed by the assessing officer pursuant to the order of remand. The learned counsel appearing for the petitioner would reiterate that for the last 4 years, his excess payment of 7 lakhs as customs duty has been lying with the respondent since 2018, and the claim for it is not, claim for refund is kept in cold storage despite the order of the Commissioner of Appeals, who had remitted the matter to consider the plea of the petitioner in accordance with law after affording such opportunity. In the light of no order being passed by the assessing officer pursuant to the order of the the Commissioner of Appeals, the petition deserves to succeed with a direction to be issued to the respondent to answer the claim for refund of the petitioner in terms of law and effect such refund within a time frame. For the aforesaid reasons, the following order. The petition is allowed the mandamus issues to the respondent to answer the claim of the petitioner and grant such refund as is available in law in accordance with law with an outer limit of 12 weeks from the date of receipt of the copy of this order.
So 12 weeks is too long, my lordship. I think it's been 4 or 5 years. The transaction wasn't. Also, interest implication, there should be certain.
Yes, along with applicable interest, yes. Now, shall I give 16 weeks?
No, your lordship. I would still recommend, suggest or plead for 1 month time, your lordship.
All right. You will get interest. From the date the payment fell due till the date the refund reaches the doors of the petitioner. Next. Fell due yavaga? What is the time outer limit to consider?
Sorry, your
So
lordship.
what about Commissioner Appeals? Did he fix a time frame?
No, your lordship. We just remanded the matter back and he mentioned ideally reasonable time during the hearing that
From the date of the, from 16/4/2021 till it reaches the doors of the petitioner. Yes.
That payment was made in 2019, your lordship.
Anyway, your claim was answered in 2021 without interest. Yes.
Obliged, my lordship.
Yes. Madam.
Yes, sir. All 7 cases are covered by a Supreme Court order with respect to limitation.
Madam.
The facts are the same in terms of the relevant dates.
Madam Authority.
May I just submit?
Yes, sir.
All 7 cases, the assessment year involved is 17/18.
All 7 cases.
All 7.
Yes.
The impugned notices were issued on 7/5/24. That, my lord, as my lord note, is 6 years after the end of the assessment year 17/18.
Notice under?
Section 148. So end of assessment year 17/18 is 31st March 2018. 6 years would lapse on 31st March 24. In this case, admittedly, notices issued on 7th of May 2024.
7th of May
2024. Similar questions came up before the Supreme Court, my lords, and last year the order passed. They've said that for the assessment years before 21-22, no notices under 148 can be issued beyond a period of 6 years from the end of the assessment year. I'll just take, my lords, the relevant.
That's 149?
149, yes, the provisor to 149, precisely. I'll just take, my lords, the relevant para, which gives the.
149, one is 4 years.
Under the erstwhile law. Then from,
that is Finance Act 2018.
Yes. Then from
notice was issued when?
This was after 2021. The Finance Act.
Under the 21 Finance Act also it is the same. It's not changed.
3 years extendable to 10 years, but the 10 years is curbed to 6 years in the light of the first proviso to 149(1), which said that because the erstwhile law gave only 6 years, they should not get the benefit of from 6 to 10 years for reassessment proceedings which have already got time lapsed.
So to restrict that, the proviso was introduced. That was interpreted by the Supreme Court to say 6 years in all cases.
So 6 years even in 2021.
Yes, yes.
Yes.
And similar matters thereafter, the Delhi High Court.
Paragraphs.
Just take one.
Yes,
My lords, may
Sanmati.
kindly turn to
It may be closed.
internal page, my lords. 63, my lords. Para 49.
Justice Pardiwala, sir.
No, Justice
Chief Justice.
Please.
Yes. Paragraph
49, my lords.
49.
My lords have that.
Yes.
May I just read this? The first proviso to section 149(1).
Yes, sir.
The first proviso to section 149(1)(b) requires the determination of whether the time limit prescribed under 149(1)(b).
Paragraph everybody, sir. Anyway, they
Paras
they accept
49
that it is covered.
Please, please. Paras 49, 53 and 60, marks.
53 and 60.
60.
Conclusions ಏನilva? Nothing in the conclusions?
Because there were various aspects dealt with in this.
In conclusions,
Those were concluded here.
sorry?
Sixty, in fact, my lord, may kindly
We'll
see.
close it.
Yes, my lord. Your lordship, other judgments are also there. My
Yes.
Subsequently, this honorable court has passed, followed that order, my lord, and.
ಅದು ಕೊಟ್ಬಿಡಿ, yes.
ಕೊಟ್ಬಿಟ್ರೆ ಸಾಕು.
That was for assessment of 15-16. For Delhi High Court has also done for 17-18 itself.
Because today I have passed an order on
Yes, my lord.
149 proviso 1 and 2, 6 years. Assessment of 2008 and 9.
Yes, my lord.
Notice issued on 2019, taking recourse to 150.
Direction or findings.
Direction of tribunal or the authority, yes. We'll follow this sort.
Please.
Yes, my lord.
The petitioners in all these cases.
Separate orders, my lord.
ಒಂದ್ರಲ್ಲಿ ಮಾಡ್ತೀನಿ ಚೇತನ್ ಅದನ್ನ will say in the light of the reasons
Yes,
rendered
ma'am.
therein separate order should be separated.
Yes, my lord.
The petitioner will start with one. The petitioner, all common petitioners
Part of the same group, no, but
anyway. The petitioner in the subject petition calls in question notices issued.
Page 115, annexure A2.
1 minute. Notices, orders are passed, is it?
Order and notice notes. 148 AD order, consequent notice under 148.
The calls in question, order passed by the second respondent under 148 AD and consequent notices so issued to the petitioner under 148. The notices read as follows. Page
115, I'm sorry, of the first petition. Annexure A2.
115. The notice reads as follows. The notice itself indicates that it is issued for the assessment year 2017-18 and is admittedly issued on 7/5/2024. The learned counsel appearing for the petitioner submits that the notice is barred by limitation, as the limitation prescribed under section 148 is for a period of 6 years from the date of end of the financial year of the assessment year. Admittedly, the financial year of the assessment year 2017-18 comes to an end on 31/3/2018, and the limitation would cap at 31/3/2024. The notice admittedly is, as observed here and above, the notice admittedly is issued on 7/5/2024, which is admittedly beyond limitation. The learned counsel would submit that the issue in the list stands covered by the three-judge bench of the Apex Court in the case of Union of India versus Rajiv Bansal, 2024-469 ITR 46, in which the Apex Court has held as follows: para 49, 53 and 60. The High Courts of Delhi and the High Court of Delhi in two of the judgments has followed the said judgment of the apex followed same thing, is it?
I think by mistake, I've given two of the same.
Followed the judgment of the apex court, which is the other one?
Sheet.
Sheetal International.
Followed the judgment of the apex court in Rajiv Bansal Supra and as held as follows. Edit page there, I don't know. Court Mavadi Purti. In the light of the issue standing answered on all its FOURS force, the petition deserves to succeed, and the orders impugned and the action impugned or the orders impugned standing obliterated. For the aforesaid reasons, the following order allowed quashed. The petition shall be entitled to all consequential benefits that would flow from the quashment of the order, all separate orders. In for the reasons indicated in the order passed in writ petition so and so, these petitions also deserve to succeed on the same reasons, and the alien prayer is and the order is quashed. Alien operative portion and we'll call incorporation. So that it becomes separate orders. All 7, yes.
Much of
40.
Worship, in this case, I have not received the writ petition copy.
You have not received what?
You have Your Worship, it has been given to Chavan sir. He is appearing for CPC. I appear for
copy
Assistant Authority.
I'll submit, Your Lordship. I have not.
What's
given-
interim order is there?
No, Your Lordship. Here it is, what has happened is assessee's individual, original return filed in that, it has been missed to mention, claim the interest on housing loan.
Huh.
So for that, demand was raised by passing the 143(1), Your Lordship. So.
Refund.
Huh?
They're asking refund.
Not refund, demand only will not be arising in that,
But this is for
to
3
that
years,
extent.
where for 1 year they had filed rectification. For another 2 years, they had to file rectification, but they have filed for reprocess option when they file it. So there is a technical error which has to be rectified by the AO. That is the reason, my lord. They have to file it in a proper
Worship,
format.
I will communicate to the AO Milad. He has to consider the rectification application and
If
pass order.
rectification is allowed, this becomes
Yes, Milad, it
infructuous.
becomes in.
Yes, Your Lordship.
We'll
I'll-
post it. Why all these
Your Worship,
technicalities?
I have not received. I had
This is 15-year-old
The
Then what?
other
intent.
so demand was raised, that has been paid by the petitioner, Your Lordship. But still the demand is showing online and the CPC portal is not.
Because
Simple case of rectification. ಅದಕ್ಕೊಂದ್ರೆ.
The proper format alla, so normally it is automated process.
There
It does not select it.
Actually,
The-
jurisdictional AO, we have appeared, Your Lordship. Those people are telling this PAN number is not belongs to me, this PAN is not belongs to me, and they are not passing only. That is the difficulty for me.
Your Worship, I will
Don't
get
pass
copy,
the buck,
Milad.
sir. By next time, I'll take it on 11th.
Please.
By then, make this infructuous. Yes.
Much.
List the matter on 11th.
47, action 48.
The petition, my lord, sir. We have complied with the court order, my lord. The 10% additional tax has been paid. I am filing a memo.
10%.
10%.
ಏನ
Wait, my lord.
ಟ್ರೈಬ್ಯುನಲ್ ಇಲ್ವಾ?
Tribunal not constituted.
Tribunal is non-constitutional.
10% pay ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದೆ.
We have
Memo
paid a
ಆಗಿದೆ.
matter and we are filing a memo.
Oh, my lord. This court on 11/8/2025 had passed the following order. The learned counsel appearing for the petitioner submits that the order is complied with by deposit of 10% and files a memo to that effect. Memo is taken on record. List the matter after 4 weeks. No date. List the matter after 4 weeks. Interim order subsisting will continue till the next date of hearing. Anyway, tribunal constitute ಆಗೋವರೆಗೂ ಇದನ್ನು dispose ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅದಕ್ಕೆ ಬರಲಿ ನಿಧಾನ. No date. Don't say list the matter after 4 weeks also. Yes.
We appear for the petitioner in this matter, my lords. We have challenged ex parte order in original at annexure L, my lords.
49.
Yes, 49.
Yes.
We have challenged ex parte order in original
Jeevan.
at page 1.
Jeevan ನೇರಳಿಗೆ. Yes, Arvind, what is this? Jeevan appears, is it? Wakalat not filed ಅಂತ ಇದೆ.
The ex parte order, my lords. All the notices and order were sent to old address of the petitioner, which was
It has
acquired
to be
by
sent back anyway.
It is para 3 is basically on the CBDT. Chinmaya Seva Trust.
Same. ಎಲ್ಲಿ ಜೀವನ್ ಕ್ಲೋಸ್ ಮಾಡೋದ ಇದು Chinmaya Seva Trust.
Please. Ex parte order.
There, Chinmaya Seva Trust. Well, where is the order? You don't know?
Remand, my lord.
ಅದೇ ಚಿನ್ಮಯ ಸೇವಾ ಟ್ರಸ್ಟ್ ಗೊತ್ತಿಲ್ವಾ?
The same remanded to reply to the show cause notice.
Stage of
The
show
show
cause.
cause notice was not supplied. We made an
Yes,
application.
sir. This, where is the show cause notice now?
I'm not enclosed.
Say
I'm
that,
not-
my lord, there was a change in the address, they closed the business.
Correct.
So they
Notice
shifted it.
ಹೋಗೇ ಇಲ್ಲ ಅಂತ.
And show cause notice serve ಆಗಿಲ್ಲ, ಆಮೇಲೆ ಇಸ್ಕೊಂಡ್ವಿ ಅಂತ ಏನೋ ಹೇಳಿದಾರೆ.
ಈಗ you have not received the show cause notice at all?
In fact, even the order, we made an application to respondent number 3, then it was given to us, my lords. Only after the bank account, my lords, was attached, we came to know our order was passed. Thereafter, we made an application before respondent number 3. Then, my lords, we have received the impugned order.
We'll close it. Chinmaya Seva Trust.
But
Same
let
order.
there be direction to issue, furnish
Fresh,
the.
communicate the notice from that stage.
That's all.
ಚಿನ್ಮಯ ಸೇವಾ ಟ್ರಸ್ಟ್ ಅಂತ ಇದೆ. ಯಾವ್ದ್ರಲ್ಲಿದೆ? ಯಾದವ್ ಸಾಹೇಬ್ ಎರಡಿದೆ, ಟೇಬಲ್ ಮೇಲೆ ಇದೆ. ಮೊನ್ನೆ ಮಾಡ್ಲಿ ನೀವು.
Order in original is, they have taken.
ಅದರಲ್ಲಿ petitions are allowed, operative portion ಈ ತರ ಮಾಡಿ. Petitions are allowed. The respondent is directed to communicate the show cause notice within an outer limit of 4 weeks.
ಅಲ್ಲ ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ಲಿ ಒಂದ್ ದಿವಸ.
ಅಲ್ಲೇ ತಗೊಳ್ಳ?
ಅಲ್ಲೇ ತಗೊಳ್ಳಿ.
ಆಯ್ತು, ಹಾಗಾದ್ರೆ ಆ ಆರ್ಡರೇ ಆಗುತ್ತೆ, ಏನು ಎಕ್ಸ್ಟ್ರಾ ಬರೆಯೋದೇ ಬೇಡ.
ಅಲ್ಲ, let them appear on one day.
The petitioner is directed to appear before the assessing officer on 1st September.
Yes.
On 1st September at 2:30 PM. The assessing officer shall communicate the show cause notice to the petitioner on the said date and permit such time to furnish his reply and regulate his procedure thereafter. ಮಿಕ್ಕಿದೆಲ್ಲ ಚಿನ್ಮಯ ಸೇವಾ ಟ್ರಸ್ಟ್ ಕೋಟ್ ಮಾಡ್ಬಿಡಿ. Judgment.
Annexure M, my lords, may be quashed because my
ಅದೆಲ್ಲ
bank.
ಕ್ವಾಶ್
Yes, please.
ಸೇಮ್ ಎರಡು ಇತ್ತಿಲ್ಲೇ ಕಾಪಿ ಎಸ್.
I pray for time because the file was received only couple of days.
ಇದೇನ ನೀವು ಹೇಳಿದ್ದು ಮಧ್ಯಾಹ್ನ?
That is 92, my lord.
92, yes. ಅದ್ರಲ್ಲಿ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
No, my lord, the issue is should have come under preliminary hearing. Because
We'll post it for preliminary on 28th.
Not
Is it or no?
Will
Reach ಆಗ್ಲಿಲ್ಲ, 4:15 ಆಗೋಯ್ತು ಅದಕ್ಕೆ.
1 minute, my lord. If the lord should take no, it will get over. The other side agreed.
No,
last
we
time.
have received the copy.
ಇದೆಲ್ಲ not this, don't
Okay,
worry.
okay,
ಅವ್ರು ಯಾವ್ದೋ
okay,
92.
Just it can be
Yes,
finished.
ತಿರುಮಲೇಶ್ ಸರ್, ಏನ್ ಬೇಕು?
We wanted to call on 18th, my lords.
18 September. Entry ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ, this is a 119.
Then yes. I'm still yet to get acquainted with the provisions.
No,
Trying to, yes.
92 serial number. It has just to go back. Ozone, carbon dioxide. That's all.
All right.
So that.
Well, I'll take it probably sometime. Yes. ಇಲ್ಲಾಂದ್ರೆ 28 ತಗೊಂತೀನಿ. Preliminary hearing ಅಲ್ಲಿ ಹಾಕ್ತೀನಿ.
Mistake it has come off in B.
No, I'll post it in preliminary hearing itself on 28th if it's not a problem. If any tearing hurry?
No, my lord.
Yes, fine.
So far they are not. 28th.
28th. That whatever it does not reach, I'll give dates. Yours 28th will post it.
Obliged.
Yes, 50 at the request of the council appearing for the respondent list on 18th September. Heard the learned senior counsel Shankar A. Shankar ಅಂತ ಮಾಡಿ ಆಮೇಲೆ. Yes.
51.
ಇಲ್ಲೂ ಇದ್ದೀರಾ? 2 weeks time. Yes, at the request of the
51, my lord.
51.
Yes, ma'am, I am appealing for petitioner.
My lord, it should be dismissed, my lord.
ಹೌದಾ?
They have to go alternative remedies there.
107
No, it
Then?
is a VAT case, my lord.
VAT case.
They filed a rectification application. Despite issuing notice, they have not appeared before the assessing officer.
Yes sir. ಯಾವತ್ತು ಅಪಿಯರ್ ಆಗ್ತೀರಾ?
Next week,
ಇಲ್ಲ,
any
5
date.
years ಆಗಿದೆ.
5 years old.
5 years ಅಲ್ಲಿ rectification ಹಾಕಿದ್ದಾರೆ. Assessment order
Madam,
mistake
next week
ಇಲ್ಲ.
any
As
date,
per section
1 week
69.
Anything else sir?
1 week, any date, next week.
ಏನು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಏನಿಲ್ಲ. We'll dismiss it. We'll take it on 4th.
ಎಲ್ಲ ಕಳಿಸಿದೀವಿ, ಚೆಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಟ್ಯಾಕ್ಸ್ ಕಟ್ತೀವಿ 1 by 1 ಅಂತ ಹೇಳಿ ಬ್ಯಾಂಕೇ ಕ್ಲೋಸ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
ಕ್ಲೋಸ್ ಆಗಿರೋ
ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್, ಮ್ಯಾಟ್ರ್ ಇದು ಗೊತ್ತಿಲ್ಲ.
ಇವ್ರು ಚೆಕ್ ಕೊಟ್ರು ಅಂತ ಬ್ಯಾಂಕ್ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ರು ಬಿಡಿ.
Lord, he is a 76-year-old. If you all should see him, very surprising.
See him.
He doesn't want to pay the tax.
ಹಂಗೆ. Yes.
Even we requested, go for ಕರಸಮಾಧಾನ, ವೇವ್ ಆಫ್ ಆಗುತ್ತೆ, ಇಂಟ್ರೆಸ್ಟ್ ಪೆನಾಲ್ಟಿ ಎಲ್ಲ ಹೋಗುತ್ತೆ.
ಅಲ್ಲಿಗೂ ಹೋಗಲ್ಲ.
No, ಹೋಗಲ್ಲ.
ಇಲ್ಲಿಗೆ ಮಾತ್ರ ಬರ್ತಾರೆ.
ಇಲ್ಲಿಗೆ ಮಾತ್ರ 100 rupees ಕೋರ್ಟ್ ಫೀ ಕಟ್ರೆ ನಮ್ಗೆ
ಅಷ್ಟೇ ಬರುತ್ತಲ್ಲ, ಬರ್ತಾರೆ. ತೊಂದ್ರೆ ಇಲ್ಲ. Yes, list on 4th, finally. It's made clear no further adjournment would be granted in the matter. Yes, next.
52.
Banta madam, 230.
It was reimbursement.
Ah.
GST reimbursement.
GST refund.
Reimbursement.
Ella one. Reimbursement. Yes.
This was
Yes, madam.
My lord,
Objections hakbaka? Consider ashtena.
my lord,
Reimbursement
other
of GST.
two,
Is it
notice
not covered by the coordinate bench?
ಇವ್ರಿಬ್ರಿಗೂ ನೋಟಿಸ್ ಆಗ್ಬೇಕು ನಾನು ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ
But will differential tax anyway, there's an added issue.
ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರು
Notice ಆಗಿಲ್ವಾ?
ಇವ್ರಿಬ್ರಿಗೂ ನೋಟಿಸ್ ಆಗ್ಬೇಕು
ಆಗಿದೆ.
ಆಗಿದೆ.
KS ಭೀಮಯ್ಯ ಅಂತ ನಾನೇ ಮಾಡಿದ್ದೀನಿ. ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ವಿ.
ಯಾರಿಗೆ?
ಚೆಕ್ ಮಾಡ್ತೀನಿ. ಕಳಿಸಿ. ಇನ್ನೊಂದು 3 ಟ್ಯಾಗ್ ಆಗ್ಬೇಕಿತ್ತು ನಾನು.
ಓ ಇಲ್ಲ, ಲಿಸ್ಟ್ ಆಗಿದೆ. 3 ಟ್ಯಾಗ್ ಆಗ್ಬೇಕಾ? ಕೊಡಿ ನಂಬರ್ಸ್ ಕೊಡಿ.
ಇದು ಮೋಸ್ಟ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ. Similar matter.
Numbers kotra? Tag this petitions along with so and so list on 11th.
Okay.
The petition.
My name may be deleted and Sanmati's name is shown.
Idralla 53. Registry to delete the name of M. Tirumalesh appearing for the respondent and print the name of EI Sanmati. 148A. List the matter on 11th. 11th or 18th. List the matter on 18th. Interim order subsisting will continue till the next date of hearing.
Grateful. 54.
For the appellant in this case, my lord. Appearing for the petitioner in this case, my lord, this is the dispute.
Where is the file?
Here it is.
Why? What's the matter?
This is a dispute under the CGST Act, my lord, for the assessment year 2017, 18, 18, 19 and 19, 20, my lords. In this case, the assessment order has been passed against the petitioner without issuing a cause notice to us. And
No show cause notice issued?
no show cause notice.
Show cause notice is issued, my lord. Order in original is passed ex parte. Though for hearing notices, it can be remanded.
Has to go back.
Has to go back.
You have to go back ಜಾಸ್ತಿ ಆಗಿದೆ. We'll take it on 28.
Please.
My lord,
Yes.
the small submission.
Why?
The, GST registration has been cancelled.
No problem, madam. Next week we will allow it.
That can be restored at least for.
We will, other subsequent, we'll send it back. All further action will be dependent there. On 28th, ಇವತ್ತು ತುಂಬಾ ಆಗಿದೆ. List on 28th.
Obliged, madam.
My pleasure. Lordship, this writ petition is against an assessment order as well as the order passed under rectification, your lordship.
Well, what had happened in this case was the second round. Well, the assessment order was passed on 18 December 2019. Against the assessment order, Malaj, he had filed a rectification application and simultaneously challenged the assessment order before Commissioner Appeals. Malaj, the rectification application was pending, Malaj. The Commissioner disposed of the appeal, Malaj, by the order dated 13th September 2024. Malaj, in the first round of litigation, Malaj, he challenged the Commissioner's order, assessment order, as well as the rectification application pending before the AO. Malaj, this honorable court, Malaj, at page number annexure L is the order, Malaj. Page 94, Malaj. Malaj, the only direction given, Malaj, in the first round, Malaj, to consider the rectification application filed by them. Malaj, we've considered the rectification application and we passed the order. We've given relief to the petitioner. Malaj, against that, they've challenged that is an appealable order even if.
What has happened, your lordship? After the direction by the High Court, your lordship, we have produced this copy of the order before the assessing officer, your lordship, as per the direction of this honorable court on 17th January 2025, your lordship. During that period, your lordship, there was some issue between the assessing officer and the petitioner, your lordship. So he has not produced any document before that, and he has given a request to the principal commissioner for change of the assessing officer, Your Lordship. And apart from that, Your Lordship, he has also initiated a contempt proceedings against the assessing officer, in which, Your Lordship, this honorable court has already issued a
So what should be done
notice.
with, what should be done with this
I mean,
now?
I'm only seeking for a remand of this matter.
No
Now that
rectification
assessing-
ಮಾಡಿದಾರಲ್ಲ ಮತ್ತೆ ಯಾಕೆ remand ಬೇಕು?
No, Your Lordship, I have not produced the documents. Only partially they have allowed it on their own.
Even without.
Your Lordship, initially they have not allowed my claim.
All
At
right.
least subsequently they have partially allowed without even producing the documents. That means they themselves are accepting that they are at
They
fault.
are accepting there is a mistake, they have rectified
Yes,
it.
Your Lordship. In fact, Your Lordship, the remaining portion also has to be allowed. I will produce
As
the
in the
documents before the
I
assessing
will
officer.
hear it.
Please.
ಬಂತ madam?
It's on Thursday, my lords. next
I'm only
uh,
Thursday.
seeking
It's a
for
small
remand,
matter.
nothing.
It is an
28.
appealable order.
Please. Please.
Yes. Less on 28.
Please.
ಮೇಡಮ್ ಅದು 4 o'clock 2:30 ಒಂದಿರಲಿ 4 o'clock ಒಂದಿತ್ತಲ್ಲ ಇದು ದಟ್ ಅಂಗದ್ ಜಗದೀಶ್ ಇಸ್ ಹಿಯರ್ ಆನ್ಲೈನ್ ಕರೆಕ್ಟ್ ಜಗದೀಶ್ ಎಸ್ ಸಂಗತ್
Learned amicus is appearing online, he instructed.
state nobody represents. Yes, Jagdish sir.
Yes, my lord.
What
Yeah,
is
my
happening?
colleague is going to hand over the documents, my lord, with respect to some of
No,
the-
no, with regard to the cyber cell being established, what is happening?
The notification, some of the notification my colleague is going to hand over, my lord. Your
No,
lordship,
next time,
may I-
could you give it? You have the copy?
Yes, he's already served me on.
What notification is this?
This, my lord,
Yes,
the
from
notification.
Special Empowered Committee.
Yes, sir.
Committee or cyber cell, what was directed? Where is my file code, madam?
It's a cyber command, my lord. This is what's
That's what. Paragraph 13 of the order was clear.
Yes, my lord. Get the printer.
State shall endeavor to give life to the cyber command centers or constitute a separate wing to tackle cybercrime like the
One
CCB.
moment. This court, while disposing the petition, while passing an order on 25/4/2025, had observed the need for creation of a cyber command center in the following paragraph, paragraph 13 extract mode. In furtherance of the said direction, the state appears to have created a special empowered committee to monitor cyber crimes. This was not what was directed to be done by the state. It was to be a cyber command center with appropriate staff like the other specialized investigating agencies due to the proliferation of the cyber crimes.
I'm sorry, but that notification has come prior to your lordship's order.
Prior, is it? Yes.
Prior to your lordship.
Also, yes, 26/8/24. The learned amicus places on record a government order dated 26/8/2024, which had created the Special Empowered Committee to monitor cyber crimes. While the order, as quoted supra, was to create a cyber command center to, in the wake of the increasing cases of cyber crime, which was the new age crime, and to tackle the new age crime, a new kind of investigating agency was directed to be constituted, a specialized investigating agency. There is ಆಮೇಲೆ ಏನು ಮಾಡಿದ್ದಾರೆ ಜಗದೀಶ್ ಸರ್?
No, may make one request, my lord. Your lordship
Yes.
may see that 9th April 2025, cyber command unit has been constituted.
Cyber 9th April 2025.
Yes, my lord. Cyber command unit.
Cyber
has been-
command unit.
Yes, my lord.
That has not been
May
activated.
request your lordship to have it on Saturday.
The
my lord.
learned amicus submits that on 9/4/2025, a cyber command unit has been established. This was observed, in fact, while passing the order And the further observation was that it was only on paper and was not activated. In the light of those observations, the state has to now steer clear as to whether the Cyber Command Center is given such teeth to act on cyber crimes as it was lying only on paper on the said date, or come up with a Cyber Command Center as was directed by the court in the aforequoted paragraph as a specialized cyber crime tackling agency. The state shall place before this court on the next date as to what has come about of the paragraph 13 of the judgment quoted supra. List the matter on 12th
Saturday,
September.
Lordship, may I have it on
30th
Saturday?
Thakla? 30th.
This Saturday, my lord.
This side, all right. List the matter on 23rd.
Yes,
Information be placed before the court on the said date.
Yes, sir. The grateful, my lord.
Yes.
230
More bad. ಅದೇನು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಏನು ಕೇಳಿದ್ ಮೇಡಮ್? 4 weeks. The petition comes to be disposed by an order dated 22/7/2025.
Page 17, my lord, there is no time limit given. Because
2025. Action shall be taken by the petitioners.
Action
Come to page 17.
Directing consideration the case of the petitioners.
I deem it appropriate to dispose the directing consider case of petition in accordance with law bearing on observation in the course of the order. As also the implementing action shall be communicated to the time limit was
Time
not.
limit.
The petition is moved. This petition was disposed by an order dated 22nd July 2025. The matter is moved for being spoken to on this court. The no time limit was fixed for consideration of the case of the petitioners. In that light, I deem it appropriate to add that the direction be complied with within 6 weeks. 4 weeks from today, because agla idu ಒಂದು ತಿಂಗಳಾಗಿದೆ. 4 weeks from today, if not earlier, the subject order shall be treated as a part and parcel of the main order. Yes, next.
Order still number 2, Shri Rajesh.
In terms of
Number 3, Shankarta.
ಇದ್ಯಾವುದು 2004 ಸೂಟ್ ಬಂದಿದೆ, ಇದಕ್ಕೆ ಬಂತು? ಇದು list this matter on Monday ಅಂತ ಹಾಕಿ. 3 Monday.
Number 4, KV Satish Chandra.
Maintainability. Maintainability ಏನು?
ಅಲ್ಲ, there are 3 IAS jointly filed.
ನನ್ನ ತಕ್ಷಣ ಹೋಯ್ತು, ಪವರ್ ಹೋಯ್ತು.
Yesterday that Salma Court is directed to clubbed IAS start.
Clubbed?
3 IAS is the same, Your Honor. Recall, reopen and call for the witnesses. Witness summons. But in this case, Your Honor, I produced the BDA plan, Your Honor. But respondent was disputed. Then I filed an application to Commissioner to produce all the original documents and other relevant documents.
Next date in?
Today is there, Your Honor. Today is there for the argument. Otherwise, it is posted for the judgment.
What suit of 2013?
2013, he filed earlier is in a bare injunction.
That's all right. You are a defendant.
Yes, Your Honor.
When was the prior permitted to be amended to that of declaration?
Yes, Your Honor.
When?
It is also subsequent.
Subsequent andre
amended petition is filed, Your Honor.
When?
Is on 2000. Amended petition is on. What is there?
When?
It is on 2016, Your Honor.
Yes. Now, if, when the matter is posted for judgment, almost judgment,
Almost judgment.
almost over,
No,
no ground.
Allah, because on submission, Your Honor, notice is to be this. Only, it is not, still it is in a posted for the argument, Your Honor. It is not argument is not concluded, then it is posted for the judgment.
Conclude your argument.
No, conclude.
Conclude,
Today,
I am saying.
Today is not, it is posted for the argument.
You conclude your argument.
No.
Not here, there.
Because there is without there is substantial question of law is there,
no,
Your Honor. Substantial question of law is
not
there.
at the fag end, nothing.
Because, no, Your Honor. First he filed in a bare injunction, subsequently possession, subsequently declaration. I am also filed in a bare injunction, Your Honor. I mean possession.
Let the suit be decided. Leave it. Yes.
In the date may be given.
List the matter on
Monday, Your Honor.
List the matter on 1st September.
In the meanwhile,
Monday, 1st September.
On notices.
No.
Otherwise, they are trial court is to be going for the orders, Your Honor.
No problem. Yes. Next. List on 1st September. Next.
5. Right from here.
ಸ್ವಾಮಿ ಲೋನ್ ಶಾಂಕ್ಷನ್ ಆಗಿದ್ದು 12/6/2020 ಲೋನ್ ಶಾಂಕ್ಷನ್.
ಈಗ ನೀವು ಯಾಕೆ ಬಂದಿರೋದು ಕೋರ್ಟ್ಗೆ?
ಸ್ವಾಮಿ ಅಷ್ಟೇ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಯಾಕೆ?
ಇವಾಗ ನಮ್ದು ಮನೆ ಇರೋದನ್ನ ಸೀಸ್ ಮಾಡಿ
ಮನೆ ಸೀಜಾ?
ಹೌದು ಸ್ವಾಮಿ. ಇದು
ಯಾಕೆ?
ಇಮ್ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟೀಸ್
ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಗಿದೆ.
ಹೌದು ಸ್ವಾಮಿ.
ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಯಾಕೆ ಆಗಿದೆ?
ಇದರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಎಲ್ಲ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಸೂಟ್ ಯಾವಾಗಿಂದ?
ಸೂಟ್ ಬಂದು
ಆರ್ಬಿಟ್ರೇಷನ್. ಸರಿ.
ಎಕ್ಸ್ಪರ್ಟ್ ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಆರ್ಬಿಟ್ರೇಷನ್
ಹೋಗ್ಲೇ ಇಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ
ಸ್ವಾಮಿ? ಅದನ್ನ ನಾವು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ಅದನ್ನು FR ಅಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ. ಅದನ್ನ
ಯಾಕೆ ಕಂಪ್ಲೈ ಮಾಡ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನ ಎಲ್ಲ ಹಾಕಿದ್ವಿ.
ಅಯ್ಯೋ, ನೀವೇ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ವಾ?
ನಾವು ಕಂಪ್ಲೈ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. ನಾವು FR ಅಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ. ನಾವು ಹೋಗಿ ಇದು ಮಾಡ್ತಾ ಇದ್ರು ಆನರಬಲ್ ಕೋರ್ಟ್ ಸೇಮ್ ಕೋರ್ಟ್ ಅಲ್ಲೇ ಇದೆ ಸ್ವಾಮಿ. ಅದು ಇನ್ನು ಅದನ್ನ ತಗೊಳ್ತಾನೆ.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಸ್ಟೇ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ.
ಆಗಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇವಾಗ ಮನೆ ಇರೋದು ಒಂದೇ ಮನೆ ಸ್ವಾಮಿ.
ಇರೋದು ಒಂದೇ ಮನೆ.
ಹ್ಞೂ ಸ್ವಾಮಿ, ಆ ಮನೆಯನ್ನ ಇದು ಮಾಡ್ತಾ ಇದೆ ಸ್ವಾಮಿ. ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಆಫ್ ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ. ಆರ್ಡರ್ ಡೇಟೆಡ್.
ವಾಟ್ ಇಸ್ ದಿ ಆರ್ಬಿಟ್ರಲ್ ಅವಾರ್ಡ್?
ಅವಾರ್ಡ್ ಆಗಿರೋದು 4 lakh.
4 lakh.
$4,41,480 ಸ್ವಾಮಿ.
ಕೊಟ್ಬಿಡಿ. ಅದಕ್ಕೆ ಯಾಕೆ ಎಕ್ಸಿಕ್ಯೂಷನ್?
ನಾವು ಆಲ್ರೆಡಿ ಇದಕ್ಕೆ ಹೋಗ್ತಾ ಇದ್ದೀವಿ ಸ್ವಾಮಿ.
ಇಲ್ಲೇ ಕೊಡ್ತೀರಾ?
ಸ್ವಲ್ಪ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿಬಿಟ್ಟು ನಾವು ಇದು ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ.
ಒಂದ್ ಸ್ವಲ್ಪ ಕೊಡ್ತೀರಾ?
ಅಲ್ಲ, ಸ್ವಲ್ಪ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು. ಅವ್ರು ಒಂದೇ ಸರಿ ಕೊಡಿ ನಮ್ಗೆ ಅಂತ ಇದು ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಓ, ಆತರ
ಸ್ವಾಮಿ.
ಈಗ ಸದ್ಯಕ್ಕೆ ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
10%.
10 ತುಂಬಾ ಕಮ್ಮಿ.
ನೋಡಿ ಸ್ವಾಮಿ.
I'll state subject to condition of 30%.
30% ಬೇಡ ಸ್ವಾಮಿ, 20% ಆದ್ರೆ.
ಏನ್ ಬಾರ್ಗೇನ್?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಕಟ್ಟಕ್ ಆಗಲ್ಲ ಸ್ವಾಮಿ. 20% ಥ್ಯಾಂಕ್ ಯು.
ನಮಗೂ ಬೇಡ, ನಿಮ್ಗೂ 25%. Yes. The petitioner is before this court calling in question an order dated 10/7/2020.
10/7/20.
Yes. 10/7/2025 by which the property of the petitioner is put to auction. The learned counsel for the petitioner submits that the execution is instituted pursuant to an arbitral award for an amount of rupees 4,71,000. The learned counsel ಎಷ್ಟು? 4,41,000.
480.
So 480. So yes. The learned counsel submits that if a reasonable time is granted, the award would be fulfilled. But the only house of the petitioner, residential house, is now put to auction. In that light, I deem it appropriate to stay the proceedings before the executing court and the impugned order, subject to the condition that the petitioner would deposit 25% of the amount 25% of the aforesaid amount within 1 week.
1 week.
2 weeks.
4 weeks.
No, 2
4
weeks.
weeks. 4 weeks.
Within 3 weeks from the date of receipt of the copy of the order. Yes.
Number 6, Shastri.
suit for specific performance. Defendants are the petitioners here in my lords. Suit was decreed. We went on a regular appeal, my lords. The first appellate court, my lords, held that on the first date of hearing, stay was not granted of the trial court judgment. 3 months ali sale deed execute ಮಾಡ್ಬೇಕಂತ ಇತ್ತು trial court order. I will hear it finally in the final arguments anta it was adjourned by the first appellate court. Later, my lords, once again on 19/2/2025.
I will direct the court to consider the IA.
My lords, in the meanwhile, let there be a stay of trial court order, my lord. That is the only. Otherwise, they will take up possession. Sale deed has already been executed.
You serve on the respondent.
Please, my lord.
Petitioner to serve on the counsel representing the plaintiff before the concerned court. List the matter on 10th September.
In the meanwhile, my lords,
order of the trial court dated 18/9 injunction ಅದು ಇಲ್ಲ ಡಿಕ್ರಿನೇ ಆಗಿದೆಯಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡಿಕ್ರಿ ಆಗಿದೆ.
ಮತ್ತೆ ಡಿಕ್ರಿ ಹೆಂಗ್ ಸ್ಟೇ ಮಾಡೋದಲ್ಲಿ?
My lords, let there be a status quo regarding
that will see, yes.
My lords, because possession
list the matter on 10th status quo where the property be maintained till the next date of hearing.
Great. See.
ಏನೋ ಹೇಳ್ತೀರಾ? Next.
7.
ಬಸವರಾಜ್ ಮೆಮೊ ಕೊಡಿ, ಅದೇ ಹಿಂಗೆ ಹೇಳ್ಬಿಟ್ರೆ ಆಗಲ್ಲ. ಎಸ್
Basavaraj Bappa Sappanava.
I filed an application for amendment that has been rejected. Suit for ejectment and damages, my lord.
Suit of the year.
Suit for ejectment and.
Suit of the year.
2017. 2017. I have already vacated, my lord.
Already vacated.
I have vacated in the year 2021.
Again, money recovery.
Money recovery. His case is that I have inducted respondent number 3 as my tenant in the second floor. So he is claiming damage against me. And his case is based upon the rent agreement dated 16/3/2005 that has been forged, my lord. The signature of my father has been forged. I have lost the complaint. FIR is
signature of your father is forged.
The signature of my father has been forged.
ಅದನ್ನೇ ನಾನು ಕೇಳಿದ್ದು. Yes.
So my lord,
your father is there?
He is dead. Charging, he is dead.
ಆಮೇಲೆ ಬರೋದಿದೆಲ್ಲ forgery. Father did not question it.
My lord, FSL has given a report that
it is forged.
Has been forged and charge sheet has been filed. So no matter is posted for judgment, my lord. And these are all the subsequent events which I could not take in my written statement. Now I have filed an application for amendment incorporating these facts in my written to be incorporated in my written statement. That has been rejected.
Then produce those documents and make arguments. I will permit you. ಎಲ್ಲ ಮಾಡಿ court will consider. ನಿಮ್ಗೇನ್ charge sheet ಆಗಿರೋದು ಹಾಕ್ಬೇಕಷ್ಟೇ.
My lord, as your lordship knows, even if I adduce any length of evidence in the absence of pleading, that doesn't carry any evidential value.
We will permit you to do that. ಈಗ amendment ಆಗಿ ಅದಕ್ಕೊಂದು objection ಆಗಿ.
Your lordship may permit.
You are the tenant.
I was tenant in first floor.
ಈಗ ಬಿಟ್ಟಾಗಿದೆಯಾ?
ಅಲ್ಲ ಬಿಟ್ಟಿದ್ದೇನೆ. Our second floor, his case is that I have inducted the respondent 3 as my subtenant in the.
Yes, sir.
My lord, when the matter was already posted for judgment, this application came to be filed.
Judgment
when the matter was
ಅಲ್ಲ ನಂದು ಏನಂದ್ರೆ ಈ ಕಂಟೆನ್ಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ
ಏನಂದ್ರೆ ಏನಾಗಲ್ಲ.
This amendment will take back the case to 2017. I will have to file again.
Time limit may be fixed. Only my contention, my lord, whatever I lead evidence in the absence of.
Will not permit you to make out a new case now.
Yeah, it is not new case, my lord. I have already contended into my written statement that.
Very good, no problem. Anything else?
But regarding filing of the charge sheet, I have not contended, my lord.
You can submit judgment. ಯಾವತ್ತು judgment ಹಾಕಿದಾರಾ?
ಇಲ್ಲ ಇದು order 2nd of September judgment ಇದೆ.
My lord, my request is that if the judgment is passed, definitely the trial court is going to pass a decree against me in respect of the rent payable by respondent.
You are aware of the order, is it?
Respondent number 3, my lord.
ಅದಕ್ಕೆ ಮತ್ತೆ amendment.
I have already taken. It is not new condition, my lord. I have already taken my. Your lordship may kindly have a look on my written statement. I have taken, but specific contingencies were not taken because I was not appearing there. I came later.
Oh, now you are taking.
I already have taken, my lord. Otherwise, ನನಗೆ ಲಕ್ಷಗಟ್ಟಲೆ ಬರ್ಡನ್ ಬಂದ್ಬಿಡ್ತದೆ. ನಾನು ಎಲ್ಲ ಪೇಮೆಂಟ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದೀನಿ. ನಾನು ಐ ಹ್ಯಾವ್ ಪೇಡ್ ಆನ್ 24/8/2021.
ಎಲ್ಲ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ.
ಅಲ್ಲ ಈಗ ಪೇಮೆಂಟ್ ನನಗೆ ಡಿಗ್ರಿ ಆತಂದ್ರೆ if I have to prefer RFA, I have to deposit 50%. That's all the problems.
That's ತೊಂದರೆ ಮಾಡಿ.
ಅಲ್ಲ ನನ್ನ ಟೆನೆಂಟ್ ಅಲ್ಲವ. He is not my, he has also vacated. He has also vacated. He's not my tenant. And his case is
ಎಲ್ಲ
that-
ಹೇಳಿದ್ರಲ್ಲ, why are you thinking? Think positive.
ಅಲ್ಲ, at
The
least-
order will be in your favor.
And my lord, I am sure, my lord.
You are sure it is going to go against
My lord,
you?
in the sense, I have not incorporated these facts, my kindly.
No, sir.
In the interest of justice, my lord.
No, ಯಾವ ಇಂಟ್ರೆಸ್ಟ್ ಇಲ್ಲ ಇದರಲ್ಲಿ.
ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ಈಗ if I, in these contentions are not incorporated, definitely I will lose my case.
No, sir. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಆಗಿದ್ದು ಯಾವಾಗ?
ಅಲ್ಲ, ಅದು criminal case charge sheet is filed. Charge sheet is filed.
2021.
2021 I have vacated and I have lost the complaint in
ಆಯ್ತು,
2017.
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದು ಯಾವಾಗ ಅವರು?
Charge sheet ಹಾಕಿದ್ದು ಇಲ್ಲಿದೆ, my lord. Charge sheet date,
Your lordship has said it.
just I will submit.
482 ಅಲ್ಲ?
ನೀವೇ
ಅಲ್ಲ, charge sheet date is
Court order number
19/6/2021.
24
19/6/2021. Charge sheet date.
When I was sitting in court hall 24, I have stayed it. So this is 14. Amendment 24 ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
ಅದನ್ನ ಹಾಕೋದು ನಾನು ಇರ್ಲಿಲ್ಲ ರೆಕಾರ್ಡ್.
ನೀವು ಇರ್ಲಿಲ್ಲ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ. ಇದ್ದಿದ್ರೆ ಆಗ್ತದೆ.
ಇದು 19/6/2021 charge sheet.
19/6/2021.
19/6/2021 charge sheet is filed. These contentions were left out to be taken in the written statement. I lose my case, man. At least your lordship may fix the date, my lord. The judgment may be stayed.
Date is already fixed by the court, 2nd September.
Your lordship may post it on 4th itself.
I will post it on 4th, no problem.
After staying.
No.
Otherwise, my petition will go, man. The purpose will not. Again,
No,
I will
no,
come,
sir,
I will have
nothing.
to come. Till then.
Proviso to rule 17 is hit by proviso to rules.
Because
change of counsel amendment ಬಿಡ್ತಾ ಹೋದ್ರೆ ಅಷ್ಟೇ. Parties will indulge in engaging counsel weekly.
I fairly agree with your lordship.
No.
The thing is that, my lord, what is the respond number 2, what the respond number 3 is supposed to pay the rent, that I am not going to pay the rent.
No, sir. Anything else, sir? Withdraw ಮಾಡ್ತೀರಾ?
Because it will not serve. If the stay is not granted, petition will not serve.
Correct. Stay will not be granted. Learned counsel appearing to the petitioner after arguing the matter at length would seek leave of this court to withdraw the petition and urge all the contentions before the concerned court at the appropriate time. Appropriate time ಆಗೋಗಿದೆ. Yes. Appropriate time. Yes. Reserving such liberty, petition stands disposed.
If these conditions are considered, definitely I will succeed, my lord.
No problem. Yes.
Bill number 8, Ashwini O.
Number? Yes.
Mobicom Technologies.
My lords, this is a constitutional challenge.
Yes, sir.
Section 56(2)(7)(b, popularly known as the angel tax.
Lordship, this is a pending matter. Just now.
ಅದು ಗೊತ್ತಾಯ್ತು, ಅವ್ರು ನೆದರ್ಲ್ಯಾಂಡ್ಸ್ ಇಂದ ಬಂದಿದ್ದಾರೆ ಅಂತ. ಲಿಸ್ಟ್ ಆಗ್ಬೇಕಾಗಿತ್ತು, ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ.
Your Lordship, income tax appeal they have filed. There is appeal is submitted.
My lords, the fact that an appeal has been filed and it's admitted does not take away our recourse under writ jurisdiction to challenge the constitutionality of a provision either. And in fact, this matter has been, the preliminary arguments have been made.
When did you come from Netherlands?
I arrived in Bangalore only yesterday.
Yesterday?
That's right, last night. And I'm going to miss my flight because I'm
now.
Now, that's right.
You're going back?
Yes, that's correct.
What time is your flight?
7:30. But we have time. Otherwise,
don't think you have time.
That's all right. I'll take.
You may even now miss the flight because it's 4:45.
That's all right. We'll miss the flight. There's always more flights.
No, you can reach Netherlands by air, not airport by road. Yes.
Yes, one has experienced that.
Yes.
I'm obliged. Your Honor, if one looks at, well, my lord, beg your pardon for calling.
It's all right. Tell me.
On the 3rd of December 2024, this writ petition was admitted, and if one reads the order of this honorable court, Srimati Swati L. Kamath, learned counsel, accepts notice on behalf of respondent number 1. Shri E.I. Sanamati, learned counsel, is directed to accept the notice on behalf of respondent number 2. List after winter vacation 2024, objections if any by then. Nothing has been
Shall
filed.
we maintain that order now? List after winter vacation.
No, that was winter vacation 2024, of course.
Also.
Now, my lords, the issue over here is very simple.
All right.
In this, not the constitutional issue. I mean, that of course cannot be simple, as my lords pointed out the last time around as well.
Yeah.
The issue is that the company needed working capital of about ₹1 crore. This working capital was infused by the main shareholder of the company. It's a startup.
Yes.
Now the government comes and says, oh, you know what, we think the valuation was was lower than the valuation at which you've invested the money, even though we followed the discounted cash flow method, which is the prescribed method. The reason for them saying this is not at face value is they said the discounted cash flow method only looks at future projections, does not look at the reality of your future transactions, and therefore we discard it. The government has prescribed this particular method. Now, in this particular case, what is happening is they've said the entire share premium we're going to treat as your income, and we're going to tax it as income. What is essentially happening is they're taxing the capital receipts received by this company. We're saying there is no legitimate reason for taxing capital receipts in this particular case. It is not income at all. It cannot be income insofar as it is arbitrary and it is discriminatory, because it's only done for the purposes of a company, not for the purposes of an LLP or a partnership, for example. At the same point of time, the import of this provision is that if I, as an entrepreneur, have incorporated my business, I'm getting a certain valuation for it. They say, no, you must value your shares downwards and sell off more of your company if you want not to be taxed. So in reality, it is also breaching the shareholders' right of on 19(1)(g) to carry on trade and business freely. So these are the broad contours of the arguments that we're facing. They've had this petition now for nearly 9 months. In this situation, it cannot wait for longer, because as long as we keep on waiting for the fundamental right to be protected, my lords, then that fundamental right continues to be breached. So in this particular case, my lords, I am aware that we're not going to decide this case in the spur of the moment today.
Exactly.
But it must be time bound, my lord.
It will be.
And yes, it cannot be time bound till winter vacation 2025.
No, 24 order is 24 order.
But
yes.
But they're saying we didn't know. We only got to know
All
now.
right.
That is false.
Where in Netherlands you are? Amsterdam, Rotterdam?
I'm in Leiden.
Huh?
I live in Leiden, but I
Leiden.
also practice in Bombay, and I come to India almost every month.
Oh.
So I'm happy to fly down whenever your lord, my lord, asks me to. But
After
this
4
has to-
weeks, anytime you.
Why 4 weeks?
Your Lordship, statement of objections has to be filed.
File.
And Your Lordship,
It's 1 year old.
Your Lordship, since constitution validity is saying,
Ah,
I
ಅದಕ್ಕೆ
have to
we should
engage ASG only
So?
I have to give the matter. I
So?
have to take steps to engage ASG, my lord. It will
ಅದಕ್ಕೆ
take
ಸ್ಟೆಪ್ಸ್ ಏನ್ ತಗೋಬೇಕು?
process ಮಾಡಬೇಕು. Because I have to.
This process isn't going on for 9 months, my lord.
See.
They can't sit on it for forever and they say, oh, we still haven't even started the process. That is bad faith.
4 weeks, my lord.
No, I'll take this matter on the 18th September. By
My
then,
lords, on the 18th September, there's a constitutional challenge on.
you are always appearing in constitutional challenges.
Well, it seems like that's the
Oh,
case
yes,
before the Bombay High Court right now.
Okay,
We've
fine.
challenged 56-10 over there for discrimination against.
A lighter
sex.
way, don't.
Yeah, appreciate
It's only to break the
it.
monotony.
But no, but certainly we can keep it the week thereafter.
We'll keep it on 23rd.
Oblige, my lord.
23rd.
But on-
ಕರೆಕ್ಟ್ ಆಗಿ ಒಂದು ತಿಂಗಳಾಗುತ್ತೆ. ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿ ಏನಾದ್ರೂ ಮಾಡಿ. Take out
Getting
all
4
steps.
weeks.
Huh?
He's getting 4 weeks eventually.
Yes.
In the process, but my
They-
lord, if it can
What's
be,
your name?
Dr. Dhruv Janssen Sangvi.
Dr. Dhruv?
Sangvi. Yeah.
Ah, all right.
Sangvi.
Anyway, we just make a note of
I'll
it.
make a note, my lord.
Yes. They heard the learned counsel appearing for the petitioners. So learned counsel AI Sanmati seeks time to engage, seeks time on the submission that the constitutional validity is challenged in the case at hand of a particular provision. 52, what is challenged?
56 to 7B.
56 to
7B.
7B.
Roman 7B in that's a clause.
7 prayer lide nodi. So and so. In that light, the services of the Additional Solicitor General of India must be engaged, has to be engaged, and objections have to be placed on record. In that light, I deem it appropriate to grant 4 weeks time to the respondent revenue to do the needful, making it clear no further adjournment would be granted on the next date on the score that the ASG is not available, ASG has not been briefed, or objections have not been filed. All the pleadings be complete and instructions be done by then. Yes. List the matter on 23rd.
Obliged, my
Yes.
lord.
Hmm. Other big group matters, dates,
89 is covered by the judgment, my lord.
which they have,
89,
if both of you say it is covered,
Yes, my lord, it is covered.
yeah, 89.
89.
Liberty may be granted to the respondent to pass a fresh.
ತಗೊಳ್ಳಿ ಮೇಡಮ್ 89 ಆರ್ಡರ್ ಇಸ್ಕೊಳ್ಳಿ, ಫೈಲ್ ಬೇಡ ಅದು ಇಸ್ಕೊಳ್ಳಿ.
K9 judgment, my lord.
K9 judgment.
K9.
Your lordship aware that 2-3 matters passed.
ಇದು
Liberty to pass.
ಸೇಮ್ ಇಲ್ಲೇನಿದೆ, ಇಲ್ಲೂ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ
Yes, yes,
ಸೇಮ್.
61 is fully covered.
ಒಂದ್ ನಿಮಿಷ ಇದು ಸೆಲ್ ನಂಬರ್ 89. Yes.
Serial number 69, my lords. 69. It's covered, my lords. Page number 90.
Both of you saying it's
Jyoti
covered,
madam.
I'll take it. Jyoti madam,
Fully covered.
Jyoti,
ಇಬ್ರು ಹೇಳ್ಬೇಕು. ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ಇನ್ನೊಂದಿನ. ಯಾವ್ದು 60?
61.
Covered by what?
Covered by this.
ಅಲ್ಲ ಯಾವ್ದು ಜಡ್ಮೆಂಟ್ ಕೊಡಿ, ಈಗ ಇಲ್ದಾರೆ I have to write, no time to write. ಇಲ್ಲಾಂದ್ರೆ I'll take it on 28th. ಶಿವಾಗ ಸಮಯ 28 ತಗೊಂತೀನಿ.
It is a 7-day notice ಕೊಟ್ಟಿಲ್ಲ.
ಗೊತ್ತು, 28th I'll dispose it.
Can it be taken in orders?
It will be taken in preliminary hearing only, or orders rather.
Orders.
Yes.
Much
The
obliged.
the learned counsel, serial number?
Serial number 78, your lordship, 101 and 104.
61.
Oh, sorry.
ಎಲ್ಲ covered.
ಎಲ್ಲ
ಅಲ್ಲ ಇವ್ರೇನೋ ಹೇಳಿದ್ರು. Oh, you said
For me.
something?
Let it be on.
Oh, you adjournment,
Saturday, your
wait,
lordship.
wait, yes.
No, his submission is different. Your lordship.
Russia. 61 is faceless.
No. It is a 7-day, minimum 7-day notice, ಕೊಟ್ಟಿಲ್ಲ ಅದು.
28th ಹಾಕಿ.
28 in orders, my lord.
my lord,
All other matters
my lord,
on.
69 can
My
be
lord,
taken on 28th. It can be disposed of.
My lord, serial numbers,
It's a covered decision.
1 minute. 4th, 11th or 18th.
my
Only
lord,
3
serial
days.
number 75, 4th, 11th or 18th is okay, my lord. Matter was initially listed before an in-charge court where serial number 75, list 1, tax matter. It's a GST matter, my lord. It was listed before an in-charge court under income tax classification. So then we had made a submission to reclassify it. At that point in time, notice was ordered, my lord. Matter has not been heard and it's getting listed in a B group. My only
Preliminary.
request is preliminary
Preliminary.
hearing.
All right.
Any, my lord.
On 4th preliminary hearing.
Much
My lord,
obliged.
serial
Serial number
108.
64, my lord.
108.
ಇಲ್ಲ what page
My lord,
wise ಕರೆದ್ಬಿಡಿ.
My lord, serial number 108.
I'll
Cut
call
copy
page
paste
wise,
order.
otherwise there'll be chaos. Yes.
Yes, ma'am.
Page 11, 67 to 70.
66.
Yeah. Fourth ಅಲ್ಲ 11th. Yes.
My lord, 69, my lords. It can be, it's covered. I served a copy.
69?
69. 28th, it can be taken up.
Covered, ah?
Covered, my lords. Jyoti
Respondent
madam.
ಯಾರು? Jyoti
Jyoti
madam.
madam.
69 covered.
No, my lord,
It has
4
to be-
September. ಅಲ್ಲ, remand back ಮಾಡ್ಬೇಕು ಅಂತ ಅವರು.
Remand
Want
us.
to go at this stage of show cause notice. Maybe remanded, but.
ಆಯ್ತು. ಈಗಲ್ಲ.
ಇವತ್ತಲ್ಲ,
4 September, my lord.
28th.
4th. Okay. Yes, 4th in orders. Yes.
Serial number 70, your lordship. It's covered by.
Covered, ah?
Yes, your lordship. Serial number
Why
70.
faceless? Same ಇವ್ರದ್ದು. 62 and 6. ಅದು ಬಂದು 28 ಹಾಕಿದೆ ಆಲ್ರೆಡಿ. ಬೇಸ್ಲೆಸ್ ಕ್ಯಾಟಗರಿಲಿ ಹೋಗಿದೆ ಅದು. That is baseless. We'll see. Yes. We'll dispose it anyway on 28. Don't worry.
Serial number 70, your lordship.
17.
It's also covered, your lordship. 70.
Covered. Respondent ಯಾರು?
Arvind Chow.
Covered. ಯಾವುದು? ಕಾಮನ್ ಶೋಕಾಸ್. ಅದು ಇನ್ನೂ ಯಾವುದು ತೀರ್ಮಾನ ಮಾಡಿಲ್ವಲ್ಲ ನಾವು. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಇದೆ ಅಲ್ಲಿ. Wait. Yes.
There is no interim order in this.
That will be on.
After 40, it is.
That will be on 11th. Yes.
In preliminary hearing.
Yes, preliminary.
71 to 77.
71 to 77, wait, yes.
77, 18 September.
All right, we'll distribute it, don't worry.
23, the interim order to be granted.
Interim orders will extend in all the cases wherever it is, please don't worry about it, yes.
78 to 85.
Lordship 78, your lordship, it is only for remand, your lordship, 119 2B, your lordship.
Fourth. 1 minute. 80? 81 name. Huh? Early, 11th, yes.
Page 14, 86 to 91. 86.
86 yen.
Fourth, the second time is not.
Not reach. Interim order idea?
No, that's fine.
Fourth.
Lordship 89, my lord, seriously.
Avattu ಏನು ಗೊತ್ತಿಲ್ಲ, 150 matters, we'll see.
Lordship 89.
80?
89, my lord, there is no interim order.
89 is disposed. Allowed. Yes.
ಇದು heavy industries,
ಯಾವುದು ಚಿದಾನಂದ್? ಹಾ.
Crypto 84.
11th in preliminary hearing. If you move it, if they come, I will take it at 2:30 on any day.
Page 50.
Lordship 84, my lords, 84.
ಮತ್ತೆ ಯಾವುದು ಅಂತ ಗೊತ್ತಿರ್ಬೇಕು first. It will come on 11th, yes.
Preliminary hearing.
Yes, sir. Preliminary.
And 90, my lord, serial number 90, it is covered by Supreme Court's order.
Covered by Supreme Court, everything, sir. Wait.
Written is whether, my lord's provisional attachment order.
We will see, we'll see. 11th again. ಯಾರು ಹೇಮ್ ಕುಮಾರ್ಗ ಯಾವ್ದ್ರಲ್ಲಿ? Don't precipitate. Now this oral direction is recorded, you need not worry. Yes. Yes.
Page 15, 94 to 98.
No interim stay.
No interim stay?
Please, my lord.
No interim stay.
My
11th.
Yes. Next week, my lord, 28th.
28th.
Preliminary, my lords. It's coming week.
28th only preliminary hearing.
Please, please.
Yes. But it's a pending matter, sir. Avat bari fresh matters ಆಗ್ತೀನಿ ಅಷ್ಟೇ.
My lord. I
We'll
will
take
try-
it on 4th.
Please, my lord.
Yes.
94.
For remand, your demand is for remand on 4th. Yes.
94 also. 94.
ಅದೆಲ್ಲ 4th, 11th. ಕಾಮನ್ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಅಷ್ಟೇ.
Page 16.
ಅವತ್ತು ಕೊಡುವ. 89.
ಗೊತ್ತಿಲ್ಲ ಸರ್, ನಂಬರ್ ವೈಸ್.
28th. We'll dispose it if it's for amendment. Sushal. Tell Sushal. Yes.
Lordship 94 and 98, my lords. There is no interim order in 94 and 98.
4th or 11th. Yes.
Preliminary hearing, my lords.
Yes, sir. ಯಾವ್ದು refund?
Even 101 also, your lordship, they have collected the whole amount, your lordship, there's a refund, your lordship.
I will see.
101.
11th all. Interlocutory.
Even
Final hearing.
104, your lordship, there is a bank attachment.
All on 11th. Interlocutory all on 11th.
106, my lord, in that. There is no
Lordship.
interim 107
11th,
appeal
11th.
dismissed for non-prosecution, my lord.
ಯಾವ್ದು dismiss for non-prosecution?
106, my lord. 101
One not?
That 107 appeal before
Ah.
GST authority dismissed for non-prosecution, I am seeking order for remand of the matter.
107 listed on,
Hearing.
listed on 28th in preliminary hearing.
Lordship,
That's serial number
104, can it be
106
on
ಅವ್ರದ್ದು.
28th, your lordship?
108.
ಇದು dismiss ಆಗಿದೆಯಾ non-prosecution?
No, my lords, 108 correction of judgment, copy paste ಆಗಿತ್ತು. 108 ಮೊನ್ನೆ ಬಂದಿತ್ತು.
Oh, yes, yes, 108
Can we
list
take-
on 28th for preliminary hearing.
Lordship, even 104,
Will dispose
your
it.
lordship, there's a bank attachment, can it be on 28th?
ಬೆಳಿಗ್ಗೆ ಇಲ್ಲ ರೀಕಾಲ್ ಮಾಡಿದ್ನಲ್ಲ ಬೆಳಿಗ್ಗೆ ಅಲ್ಲ ಇರ್ಲಿ ಬರ್ಲಿ ಆನ್ ಎಸ್
Lordship, 104, your lordship, there's a bank attachment, your lordship, no stay also has been given, your lordship, can it be on
ಬ್ಯಾಂಕ್ is attached
28th?
in 2024.
28, your lordship, please.
28.
This Saturday, please.
No, Saturday, no. Saturday there is a Supreme Court ordered matter. I can't take anything else.
My lord, serial number
Then
105, interim orders may be.
Interim orders will be extended in every case, don't mind. If there is an interim order, it will get extended. There is no interim order, that also will get extended. Yes. ಆಯ್ತು 11th. 4th ತುಂಬಾ ಇದೆ. Then again, same scene on 4th if it's too much.
This number 2.
List number 2, serial number 21 was passed over.
Pass over, I think. Passed over to next week, yes.
28th commercial court today, ma'am.
ಯಾವ್ದಕ್ಕಿದು?
It is regarding appointment of commissioner for valuation of property. Already end finding ಕೊಡ್ತಾರೆ. This court says in
Oh,
appointment.
correct, that matter is it. 28th will take. List on 28th.
Serial number 57 in second list.
50?
Serial number 57. I filed vacating application, my lord. Yesterday it was posted to today, my lord.
57.
There is an interim order, my lord, so application for temporary injection is not been considered.
Yes, Sushal.
But this will take hearing, Lord. I have not alienated any property in this matter, my lord.
You're not alienating any
Some of the respondents are doing it. I am not doing it. I have not done anything, my lords. Lord, this application, my lords, for their modification was rejected long time back. I have only come on an amendment application.
29th.
Serial number 60, my lord.
My lord,
Serial number 60, my lord. Parole extension, my lord.
GM police.
Parole extension, my lord.
ಯಾವತ್ತು ಎಂಡ್ ಆಗ್ತಾ ಇರೋದು?
Already end ಆಗಿದೆ ಸ್ವಾಮಿ, ಸರೆಂಡರ್ ಆಗಿದೆ.
ಮತ್ತೆ ಫ್ರೆಶ್ ಪೆಟಿಷನ್ ಹಾಕ್ಬೇಕು ಎಂಡ್ ಆಗಿದೆ.
ಮುಂಚೆನೆ ಪೆರೋಲ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಹಾಕೊಂಡಿದ್ವಿ ಅವ್ರು ಆಚೆ ಕಡೆ ಇರ್ಬೇಕಾದ್ರೆ.
ಅಲ್ಲ ಒಳಗಡೆ ಇರ್ಬೇಕು, ಆಚೆ ಕಡೆ ಇರ್ಬೇಕು ಹಾಕಿದ್ರಾ? ಏನು ಅಫೆನ್ಸ್ ಏನು?
ಅಫೆನ್ಸ್ 302, my lord.
302. ಒಂದ್ ನಿಮಿಷ ಸರ್, 302 ಇದ್ದಾರೆ, ಒಂದ್ ನಿಮಿಷ ತಾಳಿ.
302, my lord.
ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ?
4 years ಆಗಿದೆ.
4 years ಸಾಕು, ಸ್ವಲ್ಪ ಇರಿ ಒಳಗೆ.
Kindly have 10 days, my lord.
List the matter on 26 September.
Lord, serial
Last day ನೋಡೋಣ.
64, 59. A further hearing matter, my lord, the complaint filed against one advocate. 64, my lord.
ಯಾರು ಇದು? petitioner ಗಾ?
Petitioner.
Yes, 64. We'll take this on 29th at 2:30 PM.
My lordship.
64, interim order will continue.
59, my lordship. 59, cause list 2, my lordship.
In serial number 65, my lord.
Abdul Majid. Where is your band? Where is your band? I saw you walking without a band. I will vacate the interim order now. ಎಲ್ಲ ದಿನ ಪ್ಲೀಸ್ ಆಗಲ್ಲ. ಕೊಂಡ್ಕೊಂಡಿಲ್ಲ, ನೋಡ್ಕೊಂಡಿಲ್ಲ. Now I can't tell where somebody's band and come. ಮರ್ತೋಗ್ಬಿಟ್ಟಿದ್ದೀರಾ? ಆಯ್ತು, ಯಾವತ್ ನಾಳೆಗೆ ಹಾಕ್ತೀನಿ.
It is the eject.
That's all right. Don't bring overtones here. Yes.
From yesterday it was posted for today.
Tomorrow. From today, tomorrow. No, tomorrow. ನಾಳೆ ಯಾವ ಡೇ ಮೇಡಮ್? ಫ್ರೈಡೆ ಅಲ್ಲ? ನಾಳೆ ಬೆಳಗ್ಗೆ post it in orders.
My
I will take it at
59,
11 o'clock.
my lordship.
Tomorrow 11 o'clock, sir. No, I will vacate the interim order right away. Yes. List tomorrow.
My lordship, 59, my lordship.
Yes, 59.
Actually, kindly may I have it on my hearing on main matter, my lordship.
ಯಾವ್ದು
Actually,
sir?
the II ಮೇಲೆ the vacating stay there, we are not pressing, my lordship. I am for the respondent.
You are not pressing the vacating stay application.
The main matter can be disposed of immediately, my lord. It's a small matter regarding orders 18. They filed an application on order 18 rule 1, my lord. It can be disposed of
My lordship.
Sorry, 1st September.
Much.
My lord. ಅರೆ ಯಾಕೆ? Why? ಇರೋದು 4 ಮ್ಯಾಟ್ ಇದೆ. I am hearing 40 voices. Why? That will be extended. Yes. ಯಾವ್ದು 36 ಮೇಡಮ್? $36. ಯಾವ್ದು ಮೇಡಮ್? ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. Why further hearing?
Last time also it came for admission, my lord.
So it's an admission. Let it be an admission. Yes.
Serial number 56, my lord.
Serial
Only
number
correction
30.
of
Yes,
statement.
79.
Serial number 30.
Yes, you made a mention. What is that?
The rampant construction is being carried out on the property despite your lordship's order granting status quo.
40?
43. List 2, serial number 40.
We'll take it. ನಾಳೆ ಆಗುತ್ತಾ ಮೇಡಮ್? We'll take it tomorrow.
Serial number 56, my lord.
Serial number 30.
Serial number 50, my lord.
Cause list 2, serial number 30, my lordship.
Thank you. If you're all like this, I'm walking. ಒಬ್ಬೊಬ್ಬರಾಗಿ ಹೇಳಿ. Yes, ಏನ್ ಹೇಳಿ? ಆಗೋಗಿರೋದು ಹೇಳ್ಬೇಡಿ. What is remaining, you tell me. I've already ordered in first list, no first list going back.
Serial number 56, my lord.
First list?
Second list,
Second list, my lordship.
56, my lord.
ಏನು?
Correction of survey number in the judgment.
Cause list 2.
56 ಯಾಕೆ? ಕರೆಕ್ಷನ್ ಯಾಕೆ?
ಅದು ಸರ್ವೆ ನಂಬರ್ ತಪ್ಪಾಗ್ಬಿಟ್ಟಿದೆ. In the
ಅದು
judgment.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಇದ್ದಾಗ ಹೇಳಿ.
I am the respondent, my lord.
You are the respondent. Petitioner ಇದ್ದಾಗ ಹೇಳಿ.
My lordship.
Yes.
Serial number 30.
A date may be fixed, my lord.
Cause list
Next
2.
week, yes.
Cause list 2, serial number 30.
First list? ಏನು? ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ರಿಲೀಸ್ ಮಾಡ್ಲಾ?
My lords, 50, my lords, my lord.
ಫಸ್ಟ್ ಲಿಸ್ಟ್?
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಹಾ.
ಅದರಲ್ಲಿ ಅಮೌಂಟ್ ಡೆಪಾಸಿಟ್ ಆಗಿತ್ತು, ವಿಡ್ರಾ ಮಾಡಬೇಕು ಅಂತ ಹಾಕಿದ್ವಿ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಂತ ಇದೆ, they had to file on affidavit, ಒಂದು ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರು.
ಎಲ್ಲ ಥರ್ಡ್.
First or third? My lords, 57, my lords. My lords,
First or third?
my lords.
Serial number 63, my lord.
Serial number 30. Madam, cause list 2, serial number 30.
ಇರಿ ಸರ್, ಕೊಡ್ತಾರೆ.